I'm calling to order this hearing. This is a public hearing, oversight hearing, being conducted by the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chairman of the Council and Chair of the Committee of the Whole. Today is Thursday, February 24th, 2022. The time is 9:24 in the morning. This hearing is being conducted virtually. It is being broadcast live via the Chairman's website, which is www.chairmanmendelson.com/live. It's also being recorded and will be available on the Council's website, www.dccouncil.us. The subject of this hearing is agency performance for the Office of Zoning, the Office of Planning, and the Department of Consumer and Regulatory Affairs. In that order. This is the second of 6 oversight hearings that the Committee of the Whole is having over the course of this week and next, which this committee, similar to all the other committees of the Council, is doing prior to our getting the budget for fiscal year 23 from the mayor on March 16th. The next oversight hearing that the Committee of the Whole will have is tomorrow with the DC Auditor, the Retirement Board, the Statehood Commission, and a couple other agencies. Next Wednesday and Thursday, the 2nd and 3rd of March, the Committee of the Whole will have 2 days of hearings concerning the education agencies. That's DC Public Schools, Office of the State Superintendent, the Public Charter School Board, the Deputy Mayor for Education, the State Board of Education. That's next Wednesday and Thursday. And then on Friday, the 4th, we will have our final oversight hearing, agency performance oversight hearing for fiscal year 21 and 22 to date. And the agencies will be the University of the District of Columbia and the Commission on Arts and Humanities. Mayor will be submitting her budget on March 16th, and beginning March 22nd, the Committee of the Whole will have hearings regarding the mayor's proposed budget for different agencies. Our hearing schedule, and I believe the hearing schedule for all the committees regarding the budget, should be available on the Council's website, again, www.dccouncil.us. As I indicated, we will be hearing testimony regarding the Office of Zoning, followed by the Office of Planning, and then the Department of Consumer and Regulatory Affairs. So I'm going to call witnesses who've registered for the Office of Zoning. There were 3, and then I'll hear from the agency director. The first is Alex Baca, but I believe she'll be testifying regarding the Office of Planning. So that'll be coming up in a minute, meaning like a half an hour. Khalid Halizi and William Jordan. And William Jordan is registered as representing or testifying on behalf of Park Morton Equity Team. These folks can be let in. So we'll hear from them. Then we'll hear from Sarah Barden, who's the director of the Office of Zoning. Then we'll hear from witnesses regarding the Office of Planning. And I believe we have 10 or 9. I see William Jordan. Why don't you proceed? If you could turn on your camera, that would be great. You're looking very serious this morning. Is that the first witness in your?
I'm going to testify, and I'm pissed. And my testimony is aimed both at the Office of Zoning, the Zoning Commission, and OP, because at Park Morton, you see all of it come together. And so I'll get started.
Please.
But I just want you to know I'm angry. Okay? My testimony today focuses on the Office of Zoning, the Zoning Board, and the Office of Planning, particularly on what I perceive as the agency's 1950s, 60s Virginia-style massive resistance toward the implementation of a racial equity lens and accompanying racial equity tool as required by law in the comp plan. There's probably no better example of OZ and OP's role in massive resistance towards racial equity than the Park Morton NCI cases 1611 and 1612. In fact, OZ and OP and the zoning process have been used to systematically deny Park Morton resident council the council's development, housing, and voting rights based on our city's bias against low and moderate income Black women and their families. By slow walking in a racial equity lens view and tool, the zoning process is being used as part of a cover-up. And unfortunately, the council is complicit. This fall, the remand zoning case 1611, Bruce Monroe, was reheard by the Zoning Commission in context of the new comp plan. The new comp plan requires the Zoning Commission to evaluate cases using a racial equity lens, and effectuate it using a racial equity tool to evaluate upon consistency with the comp plan. Chair Hood asserted that conducting a racial equity analysis, which includes a centering on the residents of Park Morton, would be reverse discrimination. So the Zoning Commission could not do a legitimate racial equity analysis. OP Steingresser under Cross basically said OP did not need a racial equity tool. They could just make it up, their racial equity analysis. The applicant attorney, in response to a racial equity analysis, argued that the applicant is not responsible for racial equity requirements of the comp plan. The city of the District of Columbia is responsible. The applicant, however, in cases 16, 11, and 12, is the city. And the attorney represents the development team in the city, and the development team is an agent for the city. Not only does OP, OZ, and the city's attorney argue this forked-tongue speak on racial equity, the council itself is complicit by looking the other way in a hear no, see no, speak no evil, as the council allowed Councilmember Nadeau to use emergency legislative process to skirt budget and racial equity at Park Morton. By approving project legislation for Park Morton NCI, including dispositions, knowing that the project had an approximately $90 million plus budget gap and was not legitimate. Although only 16 of the 133 Park Morton families remain at Park Morton, yet the council approves Bill First narrative and provides no checks and balances based on a false sense of deference to the Ward 1 council member. I urge this committee to hold a racial equity special hearings around Park Morton NCI, consider major actions at OP and OZ for their massive resistance to racial equity, and then have a special legislative session to take action. I also recommend that OZ, OP, and the council read 2 books, How to Be an Anti-Racist by Ibram X. Kendi, and Nice Racism, How Progressive White People Perpetuate Racial Harm by Robin DiAngelo. Thank you for your time.
Thank you, Mr. George. Since you're the only witness, before we get to the argument, I'll spend a few minutes following up with you. First, I don't think that we have a copy of your statement. And I know you asked about writing, so.
Yeah, I'll send what I just gave immediately. I couldn't write because I just got so angry to constantly repeating the same thing for the last 4 or 5 years. It's just difficulty to keep presenting fact after fact after fact to this council, and the process continues while the residents of Park Morton suffer and have their rights denied. It's just very difficult. I mean, I don't even know if it's even worth participating in this process anymore, because it's ridiculous, some of the things that people are saying in writing and expecting us to accept it, like we can't think.
So the zoning decision from that case in 2016 went to the Court of Appeals, was remanded to the zoning commission for further,
Yes, it was.
I'm going to say for further processing. And that hearing was held last fall.
It was held in October.
And the commission explicitly said they did not have to apply a racial equity lens.
They said that, well, it's a little bit more parsed than that, but the commission basically said that they didn't require a racial equity tool in order to do a racial equity lens, is what they said. So they said that we can make it up. We can just say, it's got some affordable housing in it, it's a great plan, and therefore it meets the conditions of racial equity. They don't have to do an analysis, they can just make it up. But the comp plan, and anybody in the business knows that you have to do analysis. I mean, the council's core is a perfect example of how you do these kind of things. And they just ignored it. And so, yes, so Chairman Hood basically said, and I tried to get the video, but it's down, basically said it would be reverse discrimination to do a racial equity analysis that's centered on the residents of Park Morton and evaluating the PUD. They haven't written their order, so I would tear apart their order, but they haven't written their order. I can only go by what they said verbally.
Sure. I don't think I have any questions for you. I'll look for your testimony. That'll be helpful to me. Let me see if my colleague, Councilmember Lewis George, has any questions.
Hey, good morning, William. Good to see you.
How you doing?
I'm well. Question, when you say zoning, when you say a racial equity tool, is there a specific tool you would like to see them use? Is there something, I know the council, we have do the RIAs,
Yeah.
What are you envisioning there for a tool that you would like them to use?
It should be similar to what we see with the RIAs.
Okay.
And what CORE is doing. And of course, again, it's required by the comp plan that there be a tool. So it's not just what I would like to see.
Mm-hmm.
The commission is supposed to have developed the tool and put it in action before making all of these decisions.
Right. Okay. And do you have any sort of other suggested sort of reforms for the commission?
I guess I guess what I would say is the relationship between the commission,
Mm-hmm.
the council, and the executive agencies. Okay, because what happens is, because the zoning process is a legal process, that means groups such as the resident council at Park Morton are at a disadvantage, right? Particularly when those other forces align to push through something, right? So in this case, the mythology that we all know is that if you build larger buildings, you'll get more affordable housing. But we know from all experience and analysis, it's just not true. In this case, proves it, right? Because bigger projects take longer to develop, which leads to more displacement. So I think that there is the council needs to exercise its checks and balances. And the zoning commission needs to act independently. And I guess the best way to do that is for the council at these kind of oversight hearings to really drill down and make sure that they're acting independently and not just, so I guess
When you
my
say
recommendation
independent,
is everybody needs to do their job.
right, so when you say independent, you mean independent of the executive, independent of the council, or independent of like developers? Where are you seeking, where are you saying independence needs to happen?
All of the above. I mean, it's an interrelationship, but they're supposed to look at the facts in the cases and make an analysis,
Mhm.
right? And so that's what they need to do.
Okay.
So particularly in these cases where the applicant is the city. So the challenge is not so much when the applicant is an independent developer.
Okay.
And when you have, like in Park Morton in this case, all of the financing for this project is coming through the city. The developer is not doing anything. He's just the agent for the city. So when the developer speaks, he's really speaking for the city, right? If the city is aligned with the developer, how do you hold the developer accountable for the conditions if the city is not accountable? So the only way for the city to be accountable is if its entities have a check and balance, right? So I guess that's how I would answer that. It's kind of convoluted, but that's the point. You know, that it's scary because what happens is deference, right? Everybody defers. So that ends up being one person making decisions.
Okay. Okay, thank you. I appreciate that feedback. Thank you, Chairman.
Thank you, Councilmember. Thank you, Mr. Jordan.
All right.
You are excused, but please get us a copy of your statement. I'm now going to call Sarah Barden, who's the Executive Director, or the Director rather, of the Office of Zoning. And I believe she's accompanied by the Chairman of the Zoning Commission and the Chair of the Board of Zoning Adjustment, Fred Hill and Anthony Hood. So maybe what I will do is recognize, I'll let Mr. Hill and Mr. Hood tell me who I recognize first.
Morning, Mr. Chairman. You can recognize Ms. Barton. I guess she can go first, and I think Mr. Hill, Chairman Hill, and I are here for support, and I'm Anthony Hood.
Oh, I was told that you were introducing her, but okay, so she.
Oh, I can do that. I can do that, Mr. Chairman and Council and residents. Without further ado, I will introduce the Director of the Office of Zoning, who does a stellar job, excellent job, Ms. Sarah Barton.
Thank you. Good morning. Good morning, Chairman Mendelson and members of the City Council. My name is Sarah Barton, and I am the Director of the Office of Zoning. With me here today is Chairman Hood and Chairman Hill. I am very glad to be here with you today to testify about the accomplishments of the Office of Zoning over the last fiscal year. As usual, I would like to start my testimony by taking a moment to thank OZ staff for their hard work and dedication to public service. Our office grew by 33% this year with the addition of the Office of Zoning Legal Division. The division is comprised of 7 very talented attorneys who in the past few months have made a big impact on our operations. I will expound on that further on in my testimony, but I felt it was important to point out their hard work early on in my testimony. We've all worked together as a strong and cohesive team day in and day out as we provide service to the public, the Board of Zoning Adjustment, and the Zoning Commission. As you know, OZ is an independent agency that provides professional, technical, and administrative assistance to ZC and BZA. We support them in their oversight and adjudication of zoning matters in the District of Columbia. In administering the zoning application process, we review and accept applications, schedule public hearings and meetings, and draft and issue legal orders that document the decisions of both the Zoning Commission and the BZA. In addition to OZ's primary mission to support the Commission and Board, we have 4 ongoing strategic activities in keeping with that mission. First, we are applying computer technologies to enhance the effectiveness of our zoning processes, which provides for greater transparency, Second, we are concentrating on outreach activities to educate the public on the zoning regulations and procedures which empower city residents to more effectively participate. Third, we are assisting the public in navigating through the zoning process. And fourth, OZ has made it a priority this year to work to advance racial equity initiatives. We have provided a letter containing the answers to the questions included in the City Council's letter of February 8th. Since the beginning of FY22 through today, we continue to make significant gains in a number of important areas. I'd like to highlight a few of these areas and also a few performance measures. In FY 2020, OZ was provided with funding and FTEs to hire 3 attorneys that it detailed to the Office of the Attorney General. In FY 22, the City Council and Mayor founded 3 additional FTEs so that the legal division could be housed at OZ. The transfer of responsibility was presumably to make OZ accountable for the time it takes orders to be issued, and we take that very seriously, especially since we began to receive calls and emails about affordable housing projects that were being held up because of the delays in issuing full orders. We assembled a team that to a person has made it their goal not only to serve the ZC and BZA to the best of their ability, but to clean up the 70+ BZA and ZC order backlog that we inherited. Even though there was a learning curve, they all hit the ground running and have been providing excellent service to the Zoning Commission and BZA and have been producing orders. In FY 2019, 50 BZA full orders were issued, but it has been since declining to the point where there were only 21 BZA full orders issued in FY 21. Thus far in FY 22, we've issued 9 BZA full orders and 11 ZC orders. The BZA and ZC orders that were issued were on average 1 year old, with the oldest BZA order being 1.5 years old and the oldest Zoning Commission order 2.5 years old. We foresee that we will clear the ZC backlog by the end of the fiscal year, and we will begin ensuring that ZC orders are issued within 90 days of decision. On the BZA side, we are anticipating 30+ orders issued this fiscal year, and we will be working on issuing BZA orders within 120 days of decision. Another initiative I would like to briefly mention is our online regulations application. It's designed to give users 24/7 access to organized, easy to navigate regulations that allow them to also access a complete archive of text amendments enacted since 2016. It also has a built-in e-reader that it makes it easier to peruse content and related information. Next, I would like to address OZ's FY21 performance measures. In FY21, OZ continued to feel the effects of the pandemic and thus failed to meet its goal of hearing cases within 3 months of filing. Last fiscal year, on average, it took 4 to 6 months to have cases heard. The barriers impacting progress were threefold. A, trying to catch up on the backlog created by the absence of hearings for 3 months in FY 2020. B, the ANC notice period being extended from 30 to 51 days. And C, the reduction of the amount of cases being heard in a day at the request of previous legal staff. In FY 21 into 22, OZ set out to catch up by going back to having more cases per hearing day. This could be achieved by drafting legal reports that were more succinct and that allowed for efficiencies within the hearing process. Currently, OZ is now back to scheduling new cases to be heard approximately 3 months from filing. Lastly, I would like to mention a few fast facts. Overall, caseloads continue to rise. Based on the first quarter numbers, we project the BZA and ZC caseloads to match pre-COVID numbers. At the same time, Court of Appeals cases are dropping. This year, we will continue to have outreach meetings with the ANCs and the public. Meetings with the ANC and the public in general about our processes and procedures, as we have been for the last 20+ years. In conclusion, we are extremely proud of our accomplishments and are optimistic that we will continue to advance to new heights in the remainder of FY22 and beyond. I would like to express my sincere thanks to you, Chairman Mendelson, and the City Council, and Mayor Bowser for your ongoing support. This little office could not function as it does without the unfaltering support it receives from all of you. I would also like to express my sincere gratitude to Chairman Hood and Chairman Hill for their steadfast support of our office over the years, which has allowed us to accomplish so much and lay the groundwork to better serve the citizens of the district. This concludes my testimony, and I look forward to your questions.
Thank you, Ms. Barton. And I may have questions, I'm not sure, for Mr. Hood or Mr. Hill, but my understanding is they don't have statements.
Mr. Chairman, I did have a brief statement, very brief.
Then go for it, please.
Okay. Let me first of all say good morning, Chairman Mendelson, and also Councilmember Lewis George, and other council members and staff. I too want to thank you, Chairman Mendelson, and the council and your staff for all the hard work and the support that you all show us. I want to thank Mayor Bowser. I also want to thank all the residents of the District of Columbia who help us in our decision-making and engagement. I also want to thank all the government agencies, and particularly the Office of Zoning, for the excellent and stellar support given to the Zoning Commission under Ms. Sarah Barton's leadership. I am here for questions or any responses. And also during the virtual, and I said this before, we really patterned a lot of what we did virtually after the city council. I thank you all for being the stalwarts to kind of show us how it's done. I want to especially thank Ms. Sharon Shellen, Mr. Paul Young, and Mr. Ron Barron. But Mr. Chairman, I am here to answer any questions, especially on the racial equity tool and how it's done. The good part about this society now is all I say is go back and look at the hearing. The hearing speaks for itself. I implore everyone, maybe your staff or somebody, go back and look at that hearing and see how the equity tool was handled. And I'll leave it at that. I don't think I can talk so much on it, but I will answer the best I can because I think the order has not been put out yet. But let me end it at that. Thank you, Mr. Chairman and Councilmember Lewis George. Thank you.
Thank you, Mr. Hood. And I will probably have a question or two on that. Ms. Barton, can you say more about the backlog? You spoke to that in your statement. How much of a backlog does the BZA have?
Currently, it's in the 40s, about 40, 42, I would think.
And do you know how old the oldest case is?
The oldest case would be an appeal, and I believe it's in the range of maybe 5 years old.
And you say it's an appeal.
Mm-hmm. It was an appeal that was denied.
And with the zoning commission, how many cases?
They're lower because they've cleared 44% of them so far this fiscal year. So it's probably 14, maybe.
And you testified that they will be, I don't know what verb to use. They'll be cleared by the end of the fiscal year.
That is our goal.
And that thereafter they'll be issued within 90 days.
That is also our goal, yes.
Now, why are you going to be able to do what the Office of the Attorney General wasn't able to do for a decade?
I don't know how they were organized or structured, but when given the task, what I did was I separated the Board of Zoning Adjustment and the Zoning Commission. I made them each have their own lead with their line attorneys, and then they both report to the General Counsel. And it seems to be working.
I think you said something about working at the orders being more succinct. Did I hear you correctly?
No, the legal reports that are given to the board and commission for their decision-making process.
That's what would be more succinct.
Right. We kind of restructured how it is so that the information, the pertinent information is upfront.
Okay. You do know it's my view that the orders would benefit from being more succinct.
Yes.
I mean, I kind of remember some controversial case from a few years ago. I won't mention a name, where the solution to a court court challenge was to make the order longer, not necessarily clearer, but longer. And longer isn't necessarily the solution to to simply laying out the facts and the legal conclusions of law. You indicated in your statement that cases are increasing.
Yes.
Are they increasing above pre-pandemic levels, or is this we're getting back to normal?
It's basically about the same as prior to the pandemic. For instance, I think we had 302 BZA cases in the fiscal year prior to the pandemic, and we are on track to hit that again this year.
And you're optimistic, though, that the zoning commission will still be able to get its orders out in 90 days with the cases growing.
Certainly, that's what our goal is. We may not meet it, but we are going to try.
I neglected to ask with regard to the BZA backlog. So you didn't say that you hope to have that resolved by the end of the fiscal year. So when will that be resolved?
It's hard to tell because of course, as we're clearing up the backlog, there are more orders being issued, there are more decisions being made, So I think possibly maybe by the end of next fiscal year, if not halfway through the fiscal year after that.
By the end of next fiscal year, which means September 30th, 23.
23, possibly.
Or June of 24.
Correct.
Actually, halfway would be March 31st of 24.
Correct.
That seems awfully far.
It does, but at the same time, again, we're also trying to ensure that the decisions that are also being made right now are not being added to that backlog, that we're getting those issued in a timely manner as well. It could happen faster, it could, be slower, but certainly our goal is to get rid of that backlog as soon as possible.
And what's the goal in terms of how long before orders are issued on current cases? So it's 90 days for zoning commission. What is it for BZA?
I have 120 days right now, and we'll see whether at some point in the future we can lower that as well to 90 days. But I'm trying to be realistic, and so for right now at least, by the end of this fiscal year, our goal will be to hit that 120 days.
Yeah. That 120 days is what, 4 months, basically 4 months.
Right.
So I'm a little homeowner and I want to put a deck on the back of my house. Let's say it's controversial, so it's going to be a full hearing and everything. How long before I figure out the zoning administrator tells me I have to go to the BZA, I file the application, how long before the hearing roughly?
Now it's 3 months.
And then another 4 months after that. So I want to build my deck and I'm going to have to wait roughly 7 months.
Right. And to put it this way, right now, some people have been waiting 1.5 years just for the order part. And so we're trying to find a way to bring those numbers down significantly.
In your statement, you said, I should know this stuff and I don't. That's not what you said. That's what I'm saying. I should know this stuff and I don't. But in your statement, the PNC notice period was extended from 30 to 51 days. I remember we did that in conjunction with the pandemic. Is that still the case?
I believe it still is the case, but we've been able to catch up. It kind of pushed us back for a while, but it's now working out because we're noticing well in advance of a hearing anyway. So it's not really affecting us anymore.
Okay. You also indicated that the number of appeals, that is appeals taken to the Court of Appeals, have been dropping. Excuse me, can you say more about that?
The only thing I can say is, I believe it was 3 fiscal years ago, we had 16 appeals, and then we had 6, 7, and so far this fiscal year, we've had 0. That's pretty much all I can say about that.
Well, have you issued any orders this year?
Yes, yes, we have. Let me just see if I want to ask anything else about that. Are you seeing a drop? I don't think I want to ask it that way. Are the number of PUD cases being filed, are they going back up? What I'm getting at is this. 2 years ago when there were 16 appeals, that's roughly the time that there was a lot of upset over the PUD process. That in addition to filing and waiting and then going through a long case, and I don't mean any criticism there, but a complicated, controversial case is going to take some time before the zoning commission, and then waiting for the decision, and then going up to the Court of Appeals because there were so many cases going there. That was a deterrent. Developers were saying that was a deterrent to their trying to do discretionary development, and that they would just do matter of right. That's not necessarily a good thing. But what it meant was that there would be fewer PUD cases filed. So the number of appeals has dropped. That sounds good. But the other side of the coin is, are the number of cases are there very few of them? Do you get what I'm getting at? Yes, over the last few years, we have had a few PUDs, and yes, I believe this year that there is an increase in the amount. It's not a significant increase, but there is an increase in the amount of PUDs that have been filed.
Let me just put Mr. Hood on the spot. Can you comment on what I'm asking about?
Mr. Chairman, if you could just repeat the question. I think you were asking, has there been a drop in PUDs now since the cases that have been going to court? I believe that's the question. I want to make sure I get right on your question.
My question is really getting at what dynamic is at work here. So about 3 years ago, the dynamic was that the development community was saying, this is too difficult to do a PUD. So we're not going to file the cases because all the cases end up getting appealed. And that there's too much delay and too much uncertainty. Plus cases were getting remanded by the Court of Appeals. So Ms. Barden testified that the number of appeals this year is 0, and the last couple of years was half what it had been 3 years ago. But that could be because there are fewer cases being filed. So my question is really getting at the dynamic. Is the development community still walking away from the PUD process, or are they coming back? And we're seeing the cases are successful.
Mr. Chairman, I think they're coming back. I think they're engaging the community better. I think that the dynamics have changed because PUDs what started in the 70s. I think there are a lot of things that have changed that have made things better. It's not necessarily favoring one against the other. I think what's happening is we have learned to make the adjustment, and the residents who are dealing with the PUD sequence are now understanding and working better with developers. And some developers, I believe, have said that I know one stopped me in the street and said, I'm going to Boston. It's easy for me to do it in Boston. I can develop in Boston. So those are some of the dynamics, but I think people want to develop here. I think people want to do things here, but they also want to do it in tandem and consistency in working with the residents of those of us who want to have to endure whatever is developed. If I know that's a long-winded question, but that's the way I see all the different nuances and faculties of how that all is working.
So the trend is positive.
I believe the trend is positive on all levels, on development, on residents. Yeah, we have residents, because at the end of the day, I'm not a zoner, I'm a resident first. But we have residents who like what's going on. We have some that don't. But you're going to hear from the ones that don't. But there are a whole lot that love it. Just like I won't name the case because I don't want to go in the wrong lines. I think the order's written. But there were a lot of residents who are looking forward to a particular development, which is high controversy here in the city. A lot of them want it. But do they come to the council hearings? No. Do they see us, Councilmember Lewis George and Chairman Mendelson in the street and mention it to us? Yes, that's just the way it happens.
Okay, let me move on. Ms. Barden, your FTEs have increased, I think you said 33% with the attorneys. What is the effect on your space? What are you doing about your office space?
So currently we are still looking for space for the attorneys, but we are working with DGS and have a potential solution to perhaps house the attorneys within our suite and build out some space there. But we're still working on that. We've got 2 attorneys who do come into the office, but the other 5 work from home, telework.
Well, if you build out your existing space, does that mean you're going to squeeze more people in, or are you going to expand a little bit?
Squeeze more people in.
When will this be resolved, or do I get to ask about it next year?
I think we'll have a better idea in the next month or 2.
The Zoning Commission and BZA have spent the last 2 years conducting your meetings online. What are the plans going forward with regard to online versus in-person?
Okay, so I'll let Chairman Hood expound on this after I say this, but every time that we were considering going back in that studying, doing the hybrid, because I think there are many people out there who would prefer to continue to be able to Zoom in or WebEx into the hearings, but we're going to have to figure out a way to make that happen with in-person and the Zooming in. But we would just, a new variant would come out. So we are now again beginning to start to look at how we can do it, and should have a plan in the near future, but it'll all boil down to when the commission and board are ready.
When should boil down to what?
When the commission and board are ready to come back.
Okay. Mr. Hood, you want to elaborate?
Yeah. Thank you, Mr. Chairman. Can I just add to that? I think that what we have found and what we've heard from residents is a lot of them appreciate being able to be at home, comment, and have input instead of coming to 441. So we're looking at doing a hybrid. I think we wrote it into our regulations already that we can continue to do virtual, and that the residents and the applicant can opt out if they choose to go in person. So we're still working out the intricacies of that, but we want to make sure that we keep the virtual environment in place. We've learned something new. This is a new thing, and it's working well. Our participation is definitely where we might have in person 9. I watched one time where we might have wasn't a major issue. We might have 4 or 5 people. We had 25 and we have 30. Our numbers are up. People are more engaged. People tune in from their own homes while they're cooking dinner, taking care of their kids, and come and do that. So I think it's a win-win for everyone, Mr. Chairman.
Mr. Hill.
Hi, Chairman Mendelson. Could I thank a couple people also real quick?
Yes, but then get to the question.
Oh, okay, sure. All right. Well, I would like to thank also yourself and the council for their support. Ms. Barden and her staff, Cliff Boy and his staff, Jim Moeller, Mary Nagelhout, and the attorneys, also Joe Lawson in the Office of Planning. The zoning commission that comes in, rotates in with us. And then I really wanted to thank my fellow board members on the record, Kershaw Smith, Carl Blake, and I couldn't do it without Lorna John, who's the vice chair currently. And I really appreciate all the work that she's done in helping me. And then also finally thank Mayor Bowser for her continued support of my working with the BZA. And then lastly, I'm going to follow Chairman Hood saying that, the people that come in here to testify, it's really great to hear from people because we have an opportunity to hear from people that are in the neighborhood, that are doing what they're, that these projects are in their neighborhood. And also I'm a citizen just like Chairman Hood. And then again, finally, I do really want to thank you and the council that it's a privilege to be able to do this. I've been doing it now for 6 years and really have learned a lot and have had an opportunity to serve the city in this way. So I really thank you for that. For your support. In terms of the virtual meetings, I think that the virtual, again, if it got to a hybrid, that would be great if there was some way to do that so that people could, again, come in and do testify. I think that there is something to be said, and I think even, I'm sure the council themselves are trying to figure this out. There is something to be said about in person and getting to see people and getting to talk with them and then interact. Even the people that are interacting when there's a hearing before us, the different attorneys, the different people that are there to testify, it's easier for them to interact when they're next to each other as opposed to over Zoom. But we're going to follow whatever the lead is that is put down before us. I'm looking forward to in-person hearings again at some point in time, but also then a hybrid would be, I think, a great thing to be able to do. And I'm sure that all the different boards and councils across the country are trying to figure it out. So, but I hope that answers your question.
Yeah, I think it does. So what I'm hearing is that everybody wants to see if a hybrid is possible in the future. I have a couple more questions. Ms. Barden, describe what additional work was completed on the OZ website and the, I don't know how to pronounce it, ISIS
Right, ISIS. Yes.
Information system.
This year, so I think I mentioned it in my testimony. We have new online regulations that is so much easier to use than anything we've ever had before. Searchable, just all the information at your fingertips. As far as ISIS goes, we have added new modules. Party status comes to mind. Modules that get rid of paper forms that we still have on some levels. It's also about going back and using new code because a lot of the system is older now, so upgrading the whole system in general. And I can get you a whole list of everything we've been doing with that over the last year.
This is a continuing capital project?
It is. It is.
So we'll see this in the, or should see it in the budget next.
Yes, absolutely.
And is there anything we should be on the lookout for with regard to the ANC redistricting and how that will affect you in terms of your notice requirements?
No, but we have been looking with our GIS map and such. We have been looking at that some. I don't think you're going to see anything from us though about that.
Okay, they're going to be about 300. I think there may be something like 340 or 350 single member districts.
Yes.
I have one last question, and I'll turn to Councilmember Lewis George. So what is the Zoning Commission and the BZA doing with regard to developing a racial equity lens? And are they doing it, or is it really your office, Ms. Barden, that's doing it for them?
Okay, so we have a multi-pronged approach. First, last fiscal year, the Zoning Commission asked the Office of Planning to apply the racial equity lens in its reports to the Zoning Commission so that they can use that to consider in their decision-making process. Secondly, we've been working with the Office of Racial Equity to provide our staff and the Commission and Board with training. The first board and commission training was in January, and we're now working with them on a follow-up training that will come in the next few months. Third, we're building a GIS tool for the mapping and analysis of racial data in an effort to better support an understanding of the racial equity issues in our communities. And then lastly, we're proposing a text amendment that would also require the applicants to submit an analysis of the application through a racial equity lens.
When you said you've asked the Office on Racial Equity for training, that's the Executive's Office on Racial Equity?
Yes.
Okay, because there is a Council's Office on Racial Equity.
Mr. Chairman, can I also add to that?
Yes.
I also, well, first of all, when Councilman Guthrie and others first introduced this, I actually helped with some of that, instituting racial equity. So racial equity is very dear to me. I implemented, I speak about it consistently at every hearing. I've even taken some personal interest. I've been going to the Rappaport Center. I've been trying to learn it. I've even went to the point where I'm trying to start push my own racial equity tool. Well, I will tell you, I've asked applicants for a starter to offer some units for free, and let's go to 0 to 30% of the MFI. So I'm also pushing as well as with Dr. Hewitt and also the Office of Counsel, the Council's Racial Equity. I've asked how they're working together. I think this was an excellent idea from the council and from the mayor, and I think now it's about us just getting it right. From our piece of zoning, I think it's just about getting this right. I think it's very important. We have been, people have been adversely affected for years, and we need to get it right. And I think it's very important, Mr. Chairman. So Councilmember Lewis George, that's why I pushed, if you watch the hearings, I push racial equity consistently. Do we have it 100%? No. But are we asking for a lot of input? Yes. I just wanted to opine on that. Thank you, Mr. Chairman.
So if I were to ask, I'm guessing that if I were to follow up Mr. Jordan's testimony regarding Park Morton, that case, the order hasn't come out, and it's a contested case, so it's not smart for me to ask.
It's not smart to ask, but if I had to recuse myself, because I think it's very important, that case was held open for the racial equity tool from Mr. Jordan. I was actually admonished by a resident in that case. I gave Mr. Jordan the credit for the racial equity tool, and the young lady chimed in and said it was her racial equity tool. So we held the record open. I think I probably said enough, but we held the record open to receive that racial equity tool. And I think he said reverse discrimination. I'm going to go back and look at the hearing. That's the good part about this, because I can tell you that's not really even in my vocabulary. Reverse discrimination. It's the first, I don't, and I'll stand to be corrected, but I doubt very seriously if I use it. But I understand Mr. Jordan's perceptions are his realities. I have no problems with Mr. Jordan, been knowing him a while, but some of what I said, I just say for the residents who are listening, go back and watch the hearing. It's on tape.
Just to follow up, Ms. Barton, you mentioned 4 items. The third was?
A GIS mapping tool.
Can you explain that a little bit more?
I'm reluctant to do that because we're still working through it, but the idea is to bring in data into a mapping tool that will give some kind of idea of racial equity issues or analysis in areas of the city. But again, we have just begun work on that, and I'd hate to say something that we're not able to achieve.
Okay. Councilmember Lewis George, did you have any questions?
Yes, I do. I'm gonna come back to racial equity, but I want to start with affordable housing and steps that are being taken here. The district is in the midst of a well-documented crisis, especially affordable housing, and we need all hands on deck to solve this problem. Yet it seems that Office of Planning has at times been hesitant to engage when presented with proposals from other agencies and district residents. What steps is the Office of Planning taking to ensure transparency and effective participation in the rulemaking process? And I mean, the Office of Zoning, sorry, has, the rulemaking process, and what are you all doing to address the affordable housing crisis that we're dealing with as a city?
Thank you, Councilmember Lewis George, for the question. I will tell you that one of the things that we have been doing is we have pushed, even though I will tell you, and I think you asked me this a year ago at the oversight, I'm always trying to get lower. If you watch the hearings, and I know there are other unintended consequences, that, a lot of applicants will say, well, we can't get lower than a certain percentage because it doesn't work, the numbers don't work, or this doesn't work. There are other tools. Zoning is only a small piece in this whole crisis. It's a small piece, but it's a piece that we push to the limit. Again, as I stated, I'm always asking for units or a couple of units from 0 to 30%. I'm always told that it can't be done unless there are other tips maybe given by the council or other incentives. So, I continue to try to keep pushing that. That's the best we can do, but we have to be real. I know there are a lot of other unintended consequences. And there are a lot of other nuances that work to where we won't get there. Because I think what I believe developers would just walk away if we start saying you have to do 0 to 30%. But I always have the ask. I'm always for the push. As late as week before last, I'm always pushing to try to get to the lower numbers. The reason why I push for those numbers, because a lot of times when we talk about 60% of the MFI, we're not really getting to the residents that really need it. We need to be looking at lower numbers. I believe that. I push that. Does it happen? Gradually, I think gradual steps are to get there, but whatever we can do to speed that up, and I think all hands on deck, as you stated, I think will help us get there.
Has the Office of Zoning considered how other agencies, resources such as the Housing Production Trust Fund or tax exemptions could be coupled with inclusionary zoning to subsidize deeply affordable units? And I guess, I'll let you answer that first.
Yeah, I think Councilmember Bonds has been working. I've been watching her, and I'm trying to institute some of what we do to work along with some of the creativity ways that she has been trying to. I think she has some excellent ideas. I think some of them are still on the table, but then we want to see how we can push into that to add to lowering those numbers. I think it's an all hands on deck. I don't know if that answered your question, but I know there are a lot of things that are out there that needs to be, I agree, coupled to help us get there.
Okay. I know OAG proposed amendments to expand the IZ program, and I guess there have been delays in scheduling public hearings on it. What's the holdup in adopting this amendment to expand the IZ program and the scheduling that's been happening here?
I would tell you, Councilmember, I'm very Office of Attorney General, and I'm not going to point fingers because at the end of the day, it's about getting the job done. The Office of Attorney General has represented us and given me advice for years. And I follow that advice. I depend on that advice. I need that advice because they're the experts. During that, I think they just branched off from us in October. So during that period of time, when and I will call his name Max Tundra, and I have worked very closely together in trying to get places. Some of the things that they're instituting, or some of the things that they've now presented as a rulemaking, are things that we discussed for years. But during that time of advising us is unintended consequences. You might not be able to go that far. So my question becomes, as a resident too, why all of a sudden after 4 months that you are not responsible for the legal advice, we can just go there? So those are some of the things that we have to look at. The unintended, what has changed in 4 months that hadn't changed in 2 or 3 years? That's the question. And I don't want to get into a back and forth. The bottom, at the end of the day, it's about getting it done, making it work. And I know that, we need an analysis. The same analysis that I needed when you told me we need to gradually do this is the same one that I need for the 4 months that you have not been our attorneys. Help me get there. It's not about us versus them. It's
Right.
us. It's us.
Yeah, I mean, I agree with you here, and I'm not want to get into sort of you all's, dynamics here. I'm just trying to understand sort of what the holdup is in having a hearing on the amendments to expand the IZ program. Is the holdup, because I'm hearing you're saying like unexpected consequences, et cetera, which is fine, but I don't think it's giving me the answer as to why those amendments haven't been considered as of yet.
Because first of all, Councilman, we have not had, they are being considered. I think we have something on the table tonight, actually. I'm not sure. I think it's on the table tonight, even next week, but they are going to be considered. I think a lot of their ideas and a lot of their text amendments actually, Councilman Lewis George, came from us. They were our lawyers. They heard us saying these things the way we're trying to get to. So I think it's about getting it done. And also, as they said, nothing has changed. It's about doing an analysis. I want to get there too. I've been wanting to get there. One of the things I will say is we talk about gentrification. I've been trying to talk about gentrification for years, but I've always been told it's not in my jurisdiction. But the courts now have told me it's in my jurisdiction. So if you watch the hearings, not you, Councilman, but anyone, I talk about jurisdiction then, and I'm talking about it now. And that's been a long-standing problem that we're trying to work with. So to answer your question, long-winded, Councilman Lewis George, the answer to your question is, when we come for a hearing, we have to have all of our stuff in place, and we have to also go by what we were advised by the Office of Attorney General when they were our lawyers, is that we have to do an analysis and look at unintended consequences. That was the advice we got then, and I don't see how it changes in 4 months.
Can I just add that I believe this was considered back in January, and one of the things that was requested was an analysis from the Office of the Attorney General, which we have not received yet. So I believe that once that analysis is in and the OP report is in, then it will proceed.
Okay. I want to ask about the downtown zones. The downtown zones have been exempted from the inclusionary zoning requirements since the inception of the I program in 2006, despite these areas being a hotbed of development. With each passing day, affordable housing opportunities in these zones dwindle, ensuring the transformation of these areas to be exclusively wealthy enclaves and encouraging further displacement. Why is the commission requiring an economic analysis before it will hold a public hearing? Has the Office of Planning conducted an economic analysis of the exemption? And don't you feel this is an issue more appropriately addressed at the public hearing, especially given the speed with which these areas are being developed?
Typically, Councilmember, by law, we have to go through and that's in the regulations of the process. So before we do anything, it has to go to the Office of Planning for an analysis. That's by law. We want to do that, and that even is not necessarily the Office of Attorney General or anybody else. The commission has been talking about that as well. When we first did the downtown housing back in the mid 2000s, we wasn't expecting that, but things have changed. And what you said, Councilman, you're exactly right. That's why the commission, especially the vice chair, has really been pushing this. And I agree with them. We need to revisit that. Actually, we want to revisit that sooner than later. And you're exactly correct.
Yeah, I think I agree. We agree. I think it needs to be revisited, and it's a missed opportunity. And it really is, each passing day, we really are missing out on housing opportunities in these zones. I want to do some questions on. Actually, let me get a Ward 4 question really quickly. I heard that you asked for my input on a Helios dance law in a prior hearing, and I did not hear it. I just heard that from a commissioner. PUD like dance law on 14th Street that include great density on a transit corridor and a significant number of affordable housing units, but are still getting some pushback from neighbors concerned about the project's impact on their homes.
I'm sorry, Councilman, at least on my end, you were breaking up a little bit. Were you speaking to me? Did I ask for your input? Oh, I couldn't hear.
Okay, can you hear me? Is it working now?
Yeah, I can hear you now.
Okay, I was asking a specific Ward 4 question. I recently, I think was told, somebody said, well, Director Hood asked specifically on sort of input regarding the Helios dance law in a prior hearing. I wasn't there to witness it, but I wanted to actually ask you about it. Are you approaching PUDs like dance law on 14th Street that include greater density on a transit corridor and a significant number of affordable units, but are still getting some pushback from neighbors concerned about the project's impact on their homes?
I don't recall. I probably did. I do that also, not just you, but other council members when I haven't seen them weigh in, because the council members have their pulse on the community. And I think you represent the whole Ward 4. And to me, that carries a lot of influence with us, with me. And because I know you have your boots to the ground. So that's probably why I asked that. I don't exactly remember that, but I probably asked it. I'm not even sure. Have we written the order? Is that finished? Or?
Not sure.
No, not yet. No.
Oh, well, I better not say too much. Then I had to recuse myself. I've been down that road too. I will get back to you. I will get back to you, Councilmember, on that.
Okay.
Ms. Barden, if you and Michelle can make sure that I respond back to the Councilmember on that.
Awesome. And then just want to round this out. Did the commission require the Office of Planning to provide racial equity analysis of the recommendations to waive additional IZ requirements for the new Ward 8 changes?
I kind of pieced some of that together, Councilman. You kind of went out in and out. Maybe it's my machine. I'm not sure. Could you restate that, please?
Yeah, did the commission require the Office of Planning to provide a racial equity analysis of the recommendation to waive the additional IZ requirement for the new Ward 8 changes?
I would have to ask Ms. Shellen. I'm not sure what we've done on that. Unfortunately, there's a lot of stuff going on, and I don't always keep having it on the top of my head. But is that an answer I can get back to you? Would you like me to get the answer now? I can get it quickly.
I'll be asking some more racial questions. I said I'm going to be rounding out on the racial equity questions. So maybe by the time we finish, we can possibly have an answer there. So what I was hearing you say from your answers to Chairman Mendelson regarding the racial equity piece, right? So the Office of Zoning nor the Office of Planning have developed tools for this analysis as of yet.
The direction has come from the council. The way I see it, Councilman Lewis, so the way I feel it, the direction has come from the council and from the mayor. And what we're doing is Office of Planning was development specifically to zoning, because zoning is a tool. The instructions came from the council and the mayor. So once we got the instructions, we're developing it to the business model of zoning here in the city. On the side note of that, we're still trying to push. Some of us are doing our own individual, working with Prince George's County and then having conversations with Virginia, as well as Rappaport, and having conversations with others of how they also instituted, and also listening to other residents of how they think we should develop a racial equity tool. It's still fluid. But I can just assure you, council member, that it's on the fast track as far as I'm concerned.
Okay. Are there specific, I guess, are there specific directions and deadlines to the Office of Planning to formulate the analysis? Do we have like a set deadline, dates at this point?
I think we did. We usually give them a month or two, depending upon the analysis they have to do. But we always give the Office of Planning, when we set things down, we don't just leave it open-ended. And then we also do recurring checks at every meeting doing our status report to find out where we are. And we also get a status update of everything that we have in the pipeline, the things that we need to work on or need to correct or straighten out or revisit.
Okay. I guess the greater thing I'm trying to understand is sort of why the commission sort of permitted permitted the Office of Planning to submit reports without this critical analysis when it is requiring, I think, when it's requiring in-depth analysis on other issues from other applicants and petitioners.
Are you speaking in terms of racial equity?
Correct.
That's a requirement. That's a requirement. Once it came down, that's a requirement. That's a strict requirement. Matter of fact, I look at that first. Me personally, okay. I look at that first.
Okay. Okay.
Councilmember, did you have any more?
Yes. If they have the answer to the racial equity analysis on the IZ requirements with board 8 changes, I think I can round it out there. I had so that I can hop on to Department of Human Services.
We are still checking when I'm being notified. Councilmember Lewis George, if I don't have it, we will get it to you, and then we will come back during the budget hearing and ask it publicly. I mean, we will answer it publicly because since you're asking publicly, we will answer it publicly.
Okay, thank you. I appreciate it.
And thank you for your question.
Thank you so much. And as quickly as we can include inclusionary zoning in the downtown, downtown zones. That goes to supporting, the quicker we can sort of work on these proposed amendments to expand the IZ program, and the quicker we can get this tool for equity analysis, I think better off DC residents will be, and the better we will be in addressing the affordable housing crisis. So thank you for your time. Thank you for your office's work.
Thank you.
Thank you, Councilmember. I had one more question, and that is, the Attorney General filed, I believe, several cases regarding housing, affordable housing, earlier this year. What is the status of those cases?
So the case, they're going through the process right now. So I think we mentioned that we're waiting for an analysis on one, but they, at least I think 2 or 3 of them were addressed at a meeting back in January. But I can give you detailed information on that.
So you'll follow up, give me more
Yep.
detail? Okay.
Mr. Chairman, we are not dragging our feet on what the same analysis and stuff that we're asking for from them now. They no longer represent us. It's the same analysis they told us we needed when they were represented. So we're trying to do our due diligence.
Okay. But in any event, Ms. Barden will give me more information. I think that's going to conclude the questions for you all. We will see you. We will see you on your budget, I believe, on March 24th. You don't want to comment on it now. Well, actually, you don't know your budget yet. Never mind.
Right.
Thank you all very much.
All right. Thank you.
We will turn now to the Office of Planning. I'm going to invite all of the non-government witnesses in. Bob Ward, Alex Baca, who is representing the Greater Washington, is representing Greater Washington. She's the DC Policy Director. Meg McGuire, who is Chair of Northwest Opportunity Partners, CDC. Sabrina Rhodes, who's with Empower DC. Cheryl Court, who's with the Coalition for Smarter Growth. David Castile. Chris Otten, who's with DC for Reasonable Development. Scott Roberts. Rebecca Miller, who's with the DC Preservation League. Parisa Naruzzi, who's with Empower DC. And those are the folks. Give a moment for everybody to be let in. Why don't we start with Mr. Ward? We have a few more witnesses here, so I'm going to be paying attention to the clock. Clock is in the top right corner of your screen. If you are in gallery view, please pay attention. Mr. Ward? You're up. Good morning.
Good morning. Thank you, Chairman Mendelson, members of the committee. My name is Bob Ward. I'm a resident of Cleveland Park in Ward 3. My comments today are directed at the Historic Preservation Office within the Office of Planning. So recent research that I've conducted found that more than 1 in 5 DC residents, 22%, live in an historic district. That's a shockingly high number, I think, and suggests that the bar to designation is quite low. But more disturbing was the racial profile of historic districts. Just 15% of the population in historic districts are Black, while elsewhere in the city it's 49%. So the question is DC measuring the outcomes of its historic preservation decisions? I don't think it is, and I think it should. As Georgetown professor Brian McCabe has noted, to the degree that neighborhoods become less affordable or more exclusive following the designation of a historic district, they contribute to patterns of segregation and marginalization. Are historic districts catalysts for displacement? How would we know? These findings and the questions they raise point to a glaring omission in the measurement within the Office of Planning and Historic Preservation specifically. Measuring the outcomes of public policy is critical to evaluating their success or failure. Preservation yields obvious benefits to society. It's a link to our past, the fabric of our neighborhoods, stories, but it's not free. It comes at a cost, both to individuals and to society. The district cannot examine the balance between the benefits and costs because they're not measuring it. Preservation societal costs may include perpetuating segregation and inhibiting the development of needed housing and other uses, especially in high opportunity areas. The Historic Preservation Office has not published any demographic information on the makeup of historic districts and how they compare to areas outside of them. What are the racial profiles, income, home values and rent, levels of education, health outcomes, and employment? Are historic districts providing equitable places to live, or are they protected enclaves of white privilege? And do historic districts become more white and affluent over time, accelerating displacement? Also missing is an analysis of land utilization within historic districts. The Office of Planning has no data to measure what impact historic districts are having when it comes to the preventing of construction of new homes and businesses. Nor do we have an HPRB reviewed, have data, excuse me, have data on HPRB reviewed projects on housing that was not built as a result of HPRB decisions. If we are to ensure the cost of if we are to endure the cost of historic preservation as we enjoy its benefits, we should be measuring what they are so we as a society can assess the price and if it's worth paying. The committee should ask the Historic Preservation Office to acknowledge the need for critical self-assessment of its outcomes, the lack of data in doing so, and offer steps that can be taken to address these shortcomings. There should also be a fast track for larger multifamily projects within historic districts that begin the balancing tests of special merit upfront and proactively. I would say let's remove preservation from its silo and balance it along with other key priorities that we have. And I think that process starts with measurement. So thank you for hearing my views.
Thank you, Mr. Ward. Ms. Baca.
Hi, good morning, and thank you for skipping me for OZ. I needed the time. My name is Alex Baca, and I am testifying on behalf of Greater Washington, where I serve as DC Policy Director. We're pleased with Office of Planning's current trajectory and fully support Anita Kozart's leadership. We do hope to see her made permanent director. I'm going to speak to just a few topics that I've been keeping an eye on. Rewriting the comp plan. The comp plan needs to be fully rewritten. While I am shocked and pleased that we all survived that brutal amendment cycle, the plan itself needs to be radically different. An April 2021 staff report from OP suggests that a full rewrite should be underway by 2025. GG Wash is going to keep pushing for this. Comp plan implementation. That said, there's plenty to do now that the 2006 plan has been amended. Many thanks to the council for adopting it. The two prongs of implementation, as I see it, are neighborhood planning and building a lot in high opportunity areas. I will address the latter momentarily. With regard to neighborhood planning, I look forward to OP's work in determining frameworks for racial equity impacts of not just new development, but of maintaining our built environment status quo. This will need to happen at a project level and at a district-wide scale, and it won't be consistent or uniform across the board. I think it is also essential for OP to lead on what is legally possible with regard to racial equity in zoning. It's a really tricky topic to address without accidentally giving white people more power than they already have. One that I'm not sure that armchair planners, and I, for what it's worth, count myself as an armchair planner because I do not have a planning degree or a law degree, and I don't think that we should be steering this. So I look forward to OP taking the lead on that strongly. PUDs, it's my understanding that PUDs are kind of sort of happening again. That's good. I asked to be removed from the witness list for OZ, but I will submit more detailed written testimony for the record, especially with regard to what OAG is trying to sort of make PUDs do. I have a lot of thoughts on that, and I think that's a really complicated thing, and it sort of seems like OAG and OP are not talking, which is a problem. But for what it's worth, I myself am actually not huge on PUDs because I kind of think everything should be high density and by right with prioritization per planning area of certain features that need to be added to balance out the distribution of those features district-wide. That's a personal view. If we have PUDs, it's great that they're actually happening. I would hope that we could add some guidance and some clarity for especially ANC commissioners. It's really hard to negotiate a PUD, Chairman, I think you know this yourself. And sometimes I think it's really unfair to expect individual actors, even if they're unified as an ANC, to take on that negotiation in service of the public interest. Building more and meeting our housing targets. Juju Wash fully supports the mayor's housing targets. We wish it were even more ambitious than 36,000 new units and 12,000 affordable units. So we do hope someday that that goal is renewed into something even larger. As it is, the breakdown of affordable housing targets by planning area has been crucial to our work, which is steeped in the fair housing concept that every neighborhood should share the benefits and the burden of new development. That does mean doing things that we aren't currently doing or considering, such as building more higher density housing back into residential blocks, not solely on corridors, allowing projects with a certain level of affordability to be approved by right, and ground leasing public lands so as to have greater control over the cost of housing on it in the future. Right now, the flashpoint for a lot of this is the Wardman campus. I am fully supportive of Cleveland Park Smart Growth's efforts to push the developer toward a better project, but that shouldn't be the sole feature of our new developments and meeting our targets. So I look forward to expanding beyond just major developments and looking at this district-wide. Thank you.
Thank you, Ms. Baca. And I think you said you'll be submitting your testimony.
I did. I submitted it at the very last minute. So you all do have it, but I will send in some additional comments on OZ. And my apologies for that.
Yes, and I just was handed your testimony. Thank you.
Thank you. Thank you to your staff.
Thank you, staff. Meg McGuire. You're muted. Ms. McGuire, you're muted.
Oh, sorry. I'm Meg McGuire, Chair of the newly formed Northwest Opportunity Partners Community Development Corporation. Our mission is to reverse the historic racial inequities of removal and exclusion of Black residents in Ward 3 by expanding affordable housing and economic opportunities. During the next 3 to 5 years, Ward 3 will experience massive new developments. 3 questions must be at the heart of the Office of Planning's upcoming process in Ward 3. First, how will current development incentives and rules be reshaped to achieve the mayor's goal of 1,990 new units of affordable housing by 2025 in Rock Creek West? Number 2, at the end of the day, will the people who work here and their families be able to live here? And 3, what does it mean to achieve racial equity in Ward 3, and what policies and actions are needed to achieve equity? Based on residential development at 3 unusually large parcels, the outlook is not promising. City Ridge will produce only 56 units of affordable housing. Mazza Gallery, between 28 and 35 affordable units. The Wardman Hotel site, 72 units. Total yield from these three large-scale projects, a paltry 163 units of affordable housing. Related to Carmel's matter of right plans for the 9.5 acre redevelopment of the Wardman, we respectfully disagree with OP's position that the development is under the 3 acre threshold that qualifies for large tract review. While the footprint of the new towers may be only 2.8 acres, the entire site will be rebuilt, including 2 acres of new park space that will be designed, engineered, terraced, sculpted, and yes, built. Underground space will also be redesigned and rebuilt. This large tract is exactly what large tract review is designed to study. Related to the planning, OP will soon launch in Cleveland Park, Woodley Park, and Friendship Heights. It is important to set goals for affordable housing throughout our ward and recommend ways to hold developers in the city accountable for achieving them. It is also essential that OP use only the best 21st century technology planning tools to ensure that neighbors, advocates, developers, and planners all share a common factual and visual understanding of the current land use and together examine future options. Cities around the world are increasing citizen participation and creativity in planning transformative change through these 21st century tools. We request, indeed insist, that the city use ArcGIS Urban and City Engine in all upcoming Ward 3 planning. Outdated massing studies or standalone models presented apart from a realistic context are a thing of the past. For example, most residents have no idea what the visual difference is between medium and moderate density. Planning, as usual, will only keep people in the dark when the goal should be developing a common visual understanding and reaching consensus. It is a great privilege to do business in this beloved city. Our leaders must send a clear message to developers. Housing is a right, not just a commodity. Through their skill and proven accomplishments, developers have a vital role in meeting our shared social obligation to create the diverse and equitable city we must become. Thank you.
Thank you, Ms. McGuire. Sabrina Rhodes.
Hey, good morning. Good morning,
Morning.
Chairman, Committee, and witnesses. I'm Sabrina Rhodes, organizer with Empower DC and ANC Commissioner for Ivy City 5D01. First, I want to start off by thanking the Office of Planning with the help of Council Member McDuffie's office for organizing a meeting with the residents of Ivy City on a small area plan. We appreciate the community engagement and looking to us for advice and suggestions. This is very important, and we do want this work along with collaborating with the district agencies. We will set standards for future planning because Ivy City's small area plan will be the first using a racial equity lens. The Office of Planning has been in the past, been a definite go-to for developers to slide in and slide out with plans in hand to displace and gentrify. This has harmed many families, then it's done good, who have made the district their home, but cannot afford to live here. Moving forward, our hope is to have the agency work with the community as we have begun to do, ANCs, grassroots organizations who work closely as advocates in these communities, small businesses and others that want what's best for the neighborhood and not take control or take advantage. What has been taken for granted is the wealth of knowledge, the wisdom, commitment, and diversity we bring to the table, which has been often overlooked far too long and has become apparent with the presence of environmental justice here in Ward 5, specifically Ivy City and the Brentwood communities. A lack of deeply affordable housing, overburdened industrial land uses, lack of resources, lack of communication amongst agencies and with the public, no trust, and elected officials who are totally disconnected from their constituents they're supposed to serve. To make necessary changes, we need to have honest conversations, and to recognize it starts at the top. Hands-on, meaningful communication, not drive-by new definitions with new language, cut and paste, or for example, OP proposing to make WMATA facilities matter of right that eliminates public input and all other matters that will affect our health and the environment. We don't want developer-led gentrified communities with amenities such as green space and dog parks on the rooftop with private shuttles. We demand community-led equitable development, clean air, clean lead-free water, housing that's affordable to all and free of toxins, green space, access to healthcare and clean food, employment opportunities for our youth, proper curriculum with educated teachers that want to teach, safe school environments inside and out, and community safety with efforts to overcome inequity and inequality. Thank you for allowing me to testify.
Thank you, Commissioner. You're testifying as an individual, but you're ANC, did you say 5D01?
Yes, I'm testifying on behalf of Empower DC.
Yeah.
But I am a ANC 5D01, yes.
Thank you.
Mhm.
Cheryl Court.
Thank you, Chairman. My name is Cheryl Court. I'm with the Coalition for Smarter Growth. We are the leading nonprofit in the DC region advocating for walkable, bikeable, inclusive, transit-oriented communities and as the most sustainable and equitable way for the DC region to grow and provide opportunities for all. First, we want to thank the Council for the adoption of the Comp Plan Amendment in May of 2020. Since then, we have been engaged in implementation and appreciate that Office of Planning is moving forward with important action items from the Comp Plan. Recently, we have been working on the Chevy Chase Small Area Plan with Chevy Chase and Ward 3 neighbors and are eager to start planning effort for Friendship Heights and other Ward 3 communities. These Ward 3 efforts can play an important role in opening up long exclusive neighborhoods to new affordable housing opportunities and access to Ward 3 amenities. Adding more housing in Ward 3 helps alleviate some demand pressure in other neighborhoods and offers steps towards racial equity. We ask that the Council support Office of Planning in being bold in seeking to diversify housing opportunities in Ward 3 neighborhoods to fulfill our commitment to looking at all planning and zoning through a racial equity lens. We want to see Office of Planning follow through on rezonings of key designated areas designated for more housing from the future land use map and include IZ Plus as a part of those rezonings. We're interested to see OP beginning this process with the Benning Road rezonings. Regarding PUDs, we do see that there is a return to doing plan unit developments. There are concerns that remain, however. We see less ambitious housing matter of right plans are going forward, especially we've noticed in Ward 3, without the public process and benefits of a plan unit development and or rezoning due to the risk of being delayed for years on appeal that may have little merit. On the other hand, we are also seeing affordable housing proposals using the plan unit development process facing costly, perhaps crippling delays as one or two unhappy homeowners can veto or stall new affordable homes through an appeal. This is despite broad community support and comp plan guidance prioritizing that affordable housing. We ask the DC Council to continue to work with Office of Planning and Zoning Commission to address these challenges. Last, we wanted to express our support for the appointment of Anita Cozart as the interim director. We're grateful to have Ms. Cozart in this role, and we're eager to see her be appointed to permanent director. She comes to the job with a breadth of experience inside and outside of Office of Planning. Her experience with PolicyLink, a national research and action institute advancing racial and economic equity, positions her to ably lead Office of Planning in how to implement a racial equity lens in all of our land use decisions. We look forward to continuing to work with her in her new role. Thank you for the opportunity to testify.
Thank you, Ms. Court. David Christille.
Thank you, and good morning, Chairman Mendelson and committee members. My name is David Christille, and I live in Ward 3 on Connecticut Avenue. I'm the chair of Ward 3 Vision Steering Committee. Ward 3 Vision is a group of residents advocating for smart, more sustainable growth, including planning and development that makes Ward 3 more walkable, environmentally sustainable, inclusive, and vibrant. Planning is the foundation to achieving a better Ward 3, and we urge the council to continue to support the work of the Office of Planning. Ward 3 Vision submitted many proposals to Office of Planning on the comprehensive plan update, and we appreciate how the Office of Planning processed the thousands of proposals it received and then reported out how they handled them. We supported OP's approach to the update, prioritizing smart growth objectives and equity. The update was a monumental and often controversial effort, but we appreciate OP's work and that of the council to bring it to a successful conclusion. Ward 3 Vision has engaged with the Office of Planning on 3 Ward 3 planning efforts. We urge the Office of Planning to move forward with the Chevy Chase Small Area Plan with a focus on recommendations for more housing, including a substantial portion of those homes to be affordable. We ask that OP continue to engage the community in fine-tuning the design details and implementation strategies for this important gateway to the district. The Cleveland Park Woodley Park District design guidelines will begin next month. We hope these guidelines will encourage mixed uses, including more housing and affordable housing. The Tenleytown Friendship Heights Small Area Plan process will begin also. Friendship Heights urgently needs attention as the retail market is shifting and large sites are vacant and in need of redevelopment. We encourage the council to help OP quickly complete these planning efforts that will better guide future development. We too are concerned that projects proposed in Ward 3 are moving forward in advance of these planning processes identified by the comp plan update. We're seeing matter of right proposals that are underutilizing the capacity contemplated by the future land use map. This deprives us of additional housing and affordable housing that are desperately needed in Ward 3. The Wardman redevelopment as proposed by Carmel Partners is perhaps the most glaring example of this lost opportunity. As is mentioned by others previously, we need the Office of Planning and other DC agencies like the Housing Department and the Finance Agency to increase the amount of affordable housing beyond inclusionary zoning that will be needed to achieve the 1,990 affordable homes called for in both the Housing Equity Report in 2019 and the Rock Creek West Roadmap. We're also seeing lost opportunities for proposals of matter of right development on Upper Wisconsin Avenue and in the Friendship Heights, the Mazza Gallery and 5151 Wisconsin Avenue. We believe these projects undermine the great work that OP and the council did on the comp plan update, and Ward 3 Vision will work with the Office of Planning to find ways to encourage more sustainable and equitable development in the area. We believe planning is important to create the great and equitable district of the future, and we ask the council to recognize this by supporting the Office of Planning going forward. Thank you for the opportunity to testify this morning.
Thank you, Mr. Castillo. Sutton.
Hi, can you hear me?
Yes.
Very good. Good morning, Councilmember Mendelson. My name is Chris Otten. I'm with DC for Reasonable Development, a citywide unincorporated nonprofit association consisting of citizens from around the city who are deeply, deeply concerned about displacement that has come with all of this explosion of growth that has been unplanned. And we see that unplanning continue to happen. The comp plan was passed as legislation in May of 2021 and signed by the mayor in August of last year. And the comp plan maps were just made official by the council back in November. Applications for PUDs, map amendments, and other zoning changes started to be filed in anticipation of the plan adoption starting in the spring of 2021. And now the application spigot is wide open. In the spring of 2021, you, Councilmember Phil Mendelson, touted that the plan is now less racist because of the touted racist equity lens policies put in the plan at the last minute. The Council Office on Racial Equity recently put out a report showing that the racial equity lens implementation as real rules that the zoning commission and public can rely on when considering PUDs and map amendments and zoning changes don't exist yet. So since May of 2021, when these policies were put into place, more than a year, almost a year later, there are no racial equity lens regulations in place. There are no racial equity lens regulations discussions citywide by the Office of Planning beyond notice questions about notice. There's been no real jurisdictional analysis of racial equity rules and regulations by the Office of Planning to support conversations about implementing racial equity in DC's planning processes. That is, how are other cities dealing with racial equity in a real way based on a planning concept that is now nearly 2 decades old? This is a big reason why almost 20 DC residents from around the city are prosecuting a successful lawsuit about the lack of planning and equity in bringing about the comp plan changes, especially those of the plan maps of upzoning, the tower, that we keep hearing the smart growth conversation about how great the upzoning is. People will be directly affected by this, and so will their communities permanently. And the 60,000 Black people that have been made gone from DC will only be exacerbated. That's over 20 years, genocidal numbers over 20 years. So in this vacuum of the lack of conversation about racial equity, the developer's favorite law firm, Holland and Knight, has filled that vacuum and is rewriting the concept of racial equity developed by the directly affected people over the last so many decades. This concept is being flipped on its head. I don't know, Mr. Mendelson, if you're reading these documents from the Office of Planning and Holland and Knight in these various applications before the Zoning Commission, but they're startling in how perverse and absurd they are flipping this concept on its head. We are asking you to act, whether legislatively or otherwise, to ensure no PUDs, map amendments, or zoning changes are processed any further until true, real racial equity lens regulations are actually in place, as you touted they would be, certainly by now. We want that done, and we're asking the Office of Planning to step up. People are ready to have this conversation and implement these regs. Let's do it. Anything otherwise is criminal.
Thank you, Mr. Otten. And if we could have a copy of your statement, I'd appreciate that.
I'll send it over right now.
Thank you. Scott Roberts. Is Mr. Roberts here? Mr. Roberts, you're on.
Good morning.
Morning.
Good morning, Chair Mendelson and other attendees. My name is Scott Roberts, and I live in the Bloomingdale Historic District. I help coordinate the DC Historic Districts Coalition, which is an informal alliance of individuals and organizations supporting DC neighborhood historic districts, including potential future historic districts. But I am here today to speak on behalf of myself as a longtime homeowner and historic district champion in Bloomingdale. Over the past 15 years or so, I've closely followed historic preservation planning here in the district. Since Bloomingdale's historic district designation in 2018, I have monitored local projects undergoing design review. As a member of the Bloomingdale Civic Association, I share updates related to these projects as well as relevant resources with my neighbors, as well as with the wider DC historic preservation community, primarily through the Historic Washington List. During this time, I've made some observations about the city's historic preservation process and where I perceive a need for some adjustments to the DC Office of Planning's Historic Preservation Office. First of all, let me add that I am thankful for the set of dedicated HPO staff reviewers assigned to the 42 residential historic districts. I realize that this design review involves hundreds, if not thousands, of properties every year, many of which are quite complex. Nonetheless, I wish to testify for increased enforcement in the city's historic districts. As of right now, enforcement is far too reliant upon residents reporting changes in their neighborhoods that do not conform to historic district design guidelines. Let me briefly quote Loretta Newman, who just received the 2021 Lifetime Achievement in Historic Preservation Award at the 2021 District of Columbia Awards for Excellence in Historic Preservation event held at the DAR Constitution Hall. Loretta Newman: better enforcement is needed for more physical inspections of illegal construction and compliance with HPR stipulations via design guidelines. Also, regarding newer DC historic districts, such as Bloomingdale, residents are responsible for maintaining an inventory of before photographs of properties. These photographs allow for before and after comparison if non-conforming exterior work is being performed on a building, whether that work is permitted or not. This is an unreasonable burden on historic district residents. Therefore, there is a need for better enforcement by the city, as well as additional funding for more staff at the HPO. Additionally, more financing should be made available to the popular and successful HPO Historic Homeowner Grant Program, currently administered by Brendan Meyer. This program is key to making our historic districts successful and affordable. Moreover, I suggest expanding the program so that it covers every residential historic district in the city rather than just a select number. Thank you for allowing me to testify. I appreciate your public service.
Thank you, Mr. Roberts. Rebecca Miller.
Good afternoon, Chairman Mendelson. Can you hear me okay?
I can. Do we have a clear statement?
I sent it in about 10 minutes ago.
I will look for it. Thank you.
No problem, no problem. Thank you again. My name is Rebecca Miller. I'm the Executive Director of the DC Preservation League. I wanted to just talk about DCPL's relationship with the Historic Preservation Office and the Office of Planning and address some specific issues, many of which you have heard before, Chairman Mendelson. Again, financial support, as you heard from Mr. Roberts, is really critical to the Historic Preservation Office. DC does receive about $550,000 from the Historic Preservation Fund that's allocated by Congress every year, distributed by the National Park Service. However, since 2010, through the designation of neighborhoods like Kingman Park, the Old West End, Union Market, and Bloomingdale, the protected status for these neighborhoods have increased the review load for what DCPL perceives and has been expressed by Mr. Roberts and others in the community as an overly overworked HPO staff. HPO is a vital department to the economic and cultural vitality of our city, and continuing to underfund this office and rely on these federal funds for HPO staff salaries is detrimental to the city's historic preservation program as a whole. Enforcement. This is something I think I've testified about for 19 years at this point. This is nothing new in the city. HPO works with DCRA on these issues, but both rely on complaints from vigilant neighbors who are frustrated by the lack of reliable follow-up on these complaints. We understand that DCRA has recently begun to track these complaints through 311 and Scout systems and hope to see improvements on that in the future. However, better coordination is needed between HPO and DCRA, which serve distinct but corresponding roles. Perhaps Chairman Mendelson, at some point, there's a discussion about the new Department of Buildings, when that will be formed, and hopefully a new strategy to combat illegal construction and demolition by neglect will come forward. So historic preservation programs to residents in the district are no less important than humanities or the arts, and these are a significant aspect of the city's identity. And despite this, there's very little investment, education, outreach, or the homeowner grant program for low and moderate income homeowners. There's about $250,000 that's allocated per year in the budget for the Historic Homeowner Grant Program. That equates to about 11 grants, and we're talking about more than 26,000 protected buildings in DC. Not all, of course, are residential in nature, but this needs to be improved, and there should be a dedicated funding source, and we would be happy to work with the chairman to find areas where this might be found. It's not well publicized because, well, there's just not a lot of money to give away, but this is a program that could very much help allow for, especially those of low and moderate income, needs to make needed repairs on their homes. The review board, as we've said in the past, we're concerned about, while there's been an improved attendance record during the pandemic because of these virtual meetings, we are concerned that once these return to a in-person format, that this will decrease. We think that there is better dialogue held between those testifying before a review board. If you're in person, you can actually have body language and look at one another. It wasn't until November that we were able to see the Historic Preservation Review Board members, and that took, we're almost 2 years into the pandemic at that point. For the Office of Planning, historically, the Office of Planning hasn't been a tremendous champion for the Historic Preservation Office. Historic Preservation has a lot of positive developments directly attributed to its work. And unfortunately, what we see from the Office of Planning is less than a forthright defense of the preservation program and longstanding policies of the DC government. Regarding the pressing need for affordable housing, study after study has shown that neighborhoods with older, smaller buildings and mixed age blocks provide more units of affordable rental housing than their new construction counterparts. And based on the Washington, D.C. Economic Partnership numbers supplied to DCPL, between 18 and 22% of all newly delivered affordable units since 2018 have been within historic districts or in landmark buildings across the city. So we hear lots of people talking about historic preservation being part of the affordability problem. Market forces are part of the affordability program. I know that one of the gentlemen who spoke earlier about gentrification, and we spoke about a study last year that was done by University of Minnesota Law School that talked about the most gentrified areas of DC. These were areas such as Columbia Heights, Petworth. Kingman Park was mentioned in there as well, and Navy Yard. Kingman Park had been designated in 2018, so that was after it had already been gentrified. And the other areas that I mentioned are not designated historic districts. So preservation of existing and historic buildings is a vital component to the city's goals to combat climate change, and buildings account for 75% of greenhouse gas emissions in DC. There's no path to a carbon-free future without rapidly and comprehensively transforming DC's building sector. We need to prevent waste, avoid unnecessary carbon pollution, and strengthen community resilience. Transformation must begin by optimizing existing buildings and neighborhoods through appropriate and purposeful stewardship. We have been working with the Office of Planning and Historic Preservation Office with their participation with our Stewardship for Climate Action series. And so we'd like to thank Rogelia Flores, Stephen Geyer, and Amania Price for taking part in our second presentation of that series to talk about the city's goals. And the preservation of historic buildings is a vital component to the economic development and resurgence of Washington's neighborhoods and downtown. Preserving the cultural and built heritage of our city provides and promotes endless educational opportunities for residents and brings in millions of visitors every year. The protection and enhancement of our historic resources should be a top priority for the mayor and the DC Council by ensuring that Historic Preservation Office is adequately funded and staffed to meet the current and future workloads that are imposed upon them as the city grows and evolves. It is far past time for the council to support historic preservation efforts as it did in 1978 when it passed the Historic Landmark and Historic District Protection Act. DC's decades-old historic preservation program should be one of the city's proudest policy accomplishments, and its continued success depends on full support of the DC government. We look forward to our continued work with both OP and HPO, and thank you for your time and attention to our comments.
Thank you, Ms. Miller. Kendall Kieser. You are muted.
Thank you. Good morning, Mr. Chairman and other members of the panel. My name is Randall Kiesler, and I'm the president of the Kennesaw Phoenix Housing Cooperative located within the Renaissance condominium at 3060 16th Street Northwest. I want to address my remarks to you regarding the Historic Preservation Office, HPO, and the Historic Preservation Grant Program. First and foremost, Mr. Chairman, I want to thank you personally and the council for adopting the temporary legislation that makes our condo co-op eligible for the HPO grant program. It means a great deal to our community. Let me provide you with some context. Our building, formerly known as the Kennesaw, straddles the Meridian Hill and Mount Pleasant historic districts. The Kennesaw, which was built in 1905, needs significant repairs to the facade and cornice and the 25 ornamental balconies which encircle it. Mr. Zai, president of the Renaissance Condominium, will elaborate on the specifics and costs of the repairs in her testimony. Our relationship with HBO has had its ups and downs. Initially, they did not show much interest in assisting us with finding the way of dealing with the daunting cost of the balcony replacements, or our alternative idea of replacing some balconies with smaller, less expensive Juliet balconies. When the Washington City paper ran an article in December of 2020 about our building and the potential displacement of our lower income members due to the costs associated with replacing our ornamental balconies, they began to listen to our concerns. The article highlighted the potential for displacement of lower income residents from the building, many of which had lived there for over 40 years. The article and a subsequent article in the DCist recounted the Kennesaw Co-op's historic 7-year fight to purchase and rehabilitate our building in the mid and late 70s, when our members remained in our building during the rehab without heat or hot water for 2 winters, rather than move out and risk never moving back in. Shortly after the City paper article appeared, we were contacted by HBO, and several of their staff came out to the building to meet with us. We explained the need to replace the balconies with less expensive ones because of the onerous excessive financial burden full balcony replication would impose on all our unit owners, including our low-income units. Given that the balconies are ornamental in nature, this can be done without compromising the integrity of the building. It will allow our low and moderate income residents, which make up nearly a third of those living in our building, to remain without excessive hardship. The HPO staff appeared to want to assist us. We asked them to facilitate a joint meeting with DHCD to assess what programs might be used to help preserve the affordability of our building and prevent displacement. They met with DHCD staff, but without us. We were told they were going to work to change their in-house grant program to be able to work with multifamily buildings. We were delighted with this news and wish we could have been a part of the process to make suggestions. Hopefully, now we can help tweak the program to make it effective for multifamily buildings throughout the city, which I will get to in a moment. As a result of the temporary legislation, which expires June the 6th, HPO worked diligently to facilitate grant applications for low-income individuals living in our building, and I've already approved 17 applications with numerous others pending. There are some challenges with the program for very low-income individuals who did not earn enough in 2020 for tax purposes due to layoffs during the pandemic and did not file tax applications, but we are working with them to get their applications submitted and approved. It is unfortunate that until recently, both the HPO and the HPRB only focused on the balconies and ignored the totality of the repairs our historic building needs to remain standing. The balconies, which are only on the 3rd floor of our 7-story building, are purely ornamental, albeit extremely expensive to replace. The work needed on our facade and cornice is needed to protect the structural integrity of our building. It cannot be avoided. We met with HPO staff again last week and are grateful because it appears they now see the full picture of the work and costs we are facing. We had an encouraging discussion about how their grant program could continue to make additional grants to us. We ask that the council ensure that the HP grant program is properly funded and structured to assist multifamily buildings like ours throughout the district. Here are several suggestions to strengthen the grant program. First, the temporary legislation needs to be made permanent. We have a mayor's agent hearing tomorrow to consider the modified balcony plan as an important cost-saving measure under the economic hardship test. Once the transcript of the hearing is released and the record officially closed, the mayor's agent will have until approximately mid-July to issue his order. With the temporary legislation expiring in June, it needs to be extended. Second, we asked that the individual grant amount be increased from $25,000 to $50,000. If we are unable to get approval from the mayor's agent for the expensive balcony alternative, the less expensive balcony alternative, some of our low-income owners would face a special assessment of between $45,000 to $55,000 for all the exterior repairs. We also asked that only households earning over 100% of mean family income be required to contribute 25% to the repair costs when those costs are $15,000 or less. Third, the income limit for the grant program needs to be restructured so that the condo or co-op can receive the grant directly. The exterior repairs are common elements that the condo association must contract for and pay directly. It is extremely cumbersome. It is an extremely cumbersome process, and one that may not get sorted out by the time the temporary law expires, to require the condo to enter into a contract for the work before funds can be released to the unit owner, and the funds then transferred incrementally to the condo association for payment to the contractor and installments. There are other complications. Each owner must be assessed the cost of the repair work through their monthly HOA fee. Once that is established, we must then credit the grant funds as they come in against the monthly fee. However, due to privacy concerns, HPO cannot advise us of the amount an individual received for us to properly record them for accounting purposes. At the same time, the condo will have to record a covenant against the property, taking responsibility for receiving the funds. That is, we have legal responsibility for proper use of the funds when we don't have full knowledge of the amounts allocated to each owner. Thank you so much for this time, and we appreciate your attention.
Thank you, Mr. Kiesler. I let you go over. Ms. Desai, you are next. If you could be more mindful of the time.
Yeah, and I think what I'll do is reiterate some of the things that Randy highlighted in his statement. We both work together jointly at the Kennesaw Renaissance Cooperative, and we have always been mindful of its history, our residents, our need for affordability. And so when this issue came up, we felt, it was onerous. And so we've been pursuing the avenues outlined by the HPRB to get redress for getting an accommodation to lower the cost overall of our balconies, or get grants. And as Randy highlighted, I think the total cost of our facade and cornice repair is nearly $4 million. $2 million is just for ornamental detail, which are the balconies. The balconies represent 30 inches by 30 inches going around our third floor of a 7-story building. So in the scale of things, very small. As Randy requested, I think what this process has highlighted is the lack of support for multifamily buildings in the Historic Preservation Fund. The fact that affordability is not really considered in historic district, as Mr. Ward has highlighted in his statement, because I don't think anyone thought when they designated us the historic building that we'd be facing $2 million in costs, nor was the fund equipped to support us until very recently. And it's still not enough. I think some of the other suggestions that we have posed are, I want to make sure we hit them all: increasing the cap, having a larger fund overall, making a permanent change to the designation, allowing more multifamily buildings to apply. I think the other thing that gets lost is streamlining the process overall. Boards, condo associations, and co-ops are generally volunteers. And so we've been at this for a year, basically, trying to get the issue resolved. And, it's volunteer time that's happening in the back of this, but the delay has increased our costs nearly 40%. So we started this last March or April. I think that was our first hearing with the HPRB. We have been navigating the process during this entire time. And one of the things that's happened, and some of this is pandemic related, is our costs have gone up 40%.
and we are still trying to get a decision to even figure out what to do next. And finally, during some of our research and trying to figure out what to do about our balcony scenario, one of the things that came up is this idea of a conservation district as opposed to preservation to maybe maintain affordability. Most of the documents about our building point to it more as a cultural milestone and less of a design innovation. And so, yeah, we're being forced to replicate a design element for preservation purposes. So we're asking the council to participate in studies of thinking about how that might help affordability overall for the district. Thank you.
Thank you, Mr. Tice. So I have just a few questions. Thank you all for your testimony. Ms. Miller, I wanted to follow up some of your testimony regarding enforcement. How much of that is a DCRA issue?
It's a great question. It's kind of unbeknownst to all of us, but there are dedicated inspectors for the historic preservation program, but doesn't seem to be enough. It's not just DCRA. I mean, I can say one example where there was in the Shaw Historic District where a neighbor had called in because he felt that the neighbor was exceeding their permit work. The permit was for changing out cabinets and not reorganizing anything or restructuring the interior of the building, when in fact the interior of the building was gutted. There's now multiple bathrooms, it's a multi-unit building, all these other things. And DCRA signed off on it and said, oh, they're not in violation of their permit. And so there's things like that where maybe whoever the inspector was is not necessarily knowledgeable about the issue, but it also comes down to follow-up as well. So what happens after the fact? So if a constituent complains about something and the enforcement person goes, and then what happens in the future? There's cases on Capitol Hill that I'm aware of that have been going on for years where people maybe changed out their windows without a permit and HPO cited them, but then it gets to the Office of Administrative Hearings and the judges there are like, well, they look fine to me.
You're going beyond my question. I'm well aware that DCRA isn't very good about enforcing illegal construction or enforcing non-compliance with permits. My question has more to do with to what extent is HPO responsible? I get that they have inspectors, but isn't this in the end a DCRA issue?
Well, I believe that once I know that OAH is beyond your purview, but once the inspector, the manager.
I'm not asking about OAH. I'm asking about HPO.
So what I've been led to believe from my discussions with HPO is part of the issue is also having the inspectors go to hearings to testify and being organized for those hearings, because there's a lot of work that's happening in historic districts that is not permitted. And I think it's just the load work that is an issue. But DCRA is, as I can say, has had issues for years about this. But I think David Maloney from the SHPO could probably answer a little bit better about what the challenges they have from the Historic Preservation Office perspective.
All right, but there are always limitations on what an executive agency can say,
right?
Because the mayor always provides them with enough resources. And if you don't agree, then I'm more likely to get the more accurate information from you than if you get my gist. So are you saying that there aren't enough inspectors, or that the HPO needs help with regard to following up with the appeal process like at OAH?
Yes, both of the questions are true. I think more inspectors are necessary, or more that are trained from the DCRA cadre to understand historic preservation regulations, and also the additional potential administrative assistance for when they are going to enforce these from a legal perspective with OAH. And in general, I just think HPO is underfunded on all aspects. we add historic districts, we had more buildings. We don't, the review time takes what it does because you have staff that's already reviewing thousands more buildings. And then you have inspectors, the same number that we've had for a decade, reviewing or going out and inspecting more buildings as well.
Okay, let me ask you. Ms. Miller, you concluded your testimony. It sounded like you were criticizing the council, which is okay. But were you said that the historic protection and enhancement of Washington's historic resources should be a top priority for the council, ensuring that HPO is adequately funded. It's far past time for the council to support historic preservation. What are you getting at there? Is it just that we need to put more money in or something else?
Yes, I think, well, Chairman, you've been very supportive of historic preservation, but yeah, funds are really important to the Historic Preservation Office. As I mentioned, they're receiving approximately the same amount of funds from the Historic Preservation Fund that they've been receiving for 15, 20 years at this point. And there are 4 staff salaries that are paid for by that. And those staff salaries have gone up and benefits have gone up, but that money has not improved. That means that there's no money in the Historic Preservation Fund for things like the preservation awards or doing inventory or doing survey and documentation work. There were grants that used to be given from the Historic Preservation Office that were given out to community groups to do survey and documentation work or to do historic district brochures or educational events. There's no money left after staff salaries in that money anymore. So the city needs to step up and fund the historic preservation program to the extent that it can in order for it to be successful, because there's lots of opportunity. There's just limited time because of the number of projects that are, I would say probably 95 to 98% of the work that they do is regulatory. And that's very unlike many other city and state offices across the country who have a very high function of doing survey and documentation work. And you'll hear people talk about for years about how they wanted a citywide survey. They don't have time to do a citywide survey because there's not enough staff to do it.
Oh, thank you. The third question I have for you is your testimony regarding the Historic Preservation Review Board brought up issues I usually hear at confirmation hearings. To what extent is there an issue today with members of the Historic Preservation Review Board not being adequately trained or ignoring the training and bringing up extraneous issues at hearings?
It still happens. There's often a lot of questions that will come from HPRB members to HPO staff to clarify the regulations. With regards to designation criteria, obviously a lot of it is subjective depending on how the person who is trained in whatever circumstance responds to it. And so you'll have we had a situation a few weeks ago where we had one board member who requested additional information on a nomination, and it was the procedure that took place, which was kind of off-putting as well, because they moved it from it was on the consent calendar to then the denial calendar, which then would mean that the building couldn't be renominated for a year, even though all they wanted was some clarifying information. It's procedures, it's looking at, you would think that the board members who have been on there for a number of years would have a greater knowledge about historic preservation regulations in the district. And it seems that the Historic Preservation Office is constantly having to coach them on it, or they're having to be clarified by land use attorneys who are there representing developers. And we've testified in the past that we think that legal counsel would be really beneficial to the Historic Preservation Review Board, like it is to zoning when they're clarifying these things. So that way they're not necessarily listening to me or somebody from Holland and Knight, for instance, or something like that to tell them, our interpretation of the law, but what is the city's interpretation of the law?
The last area of question I want to ask you is about the Historic Preservation Assistance Grants. I don't have the exact name in front of me. I think we've all been talking about the same thing. It's for lower income residents to help them with maintaining property.
Yes, it's the Historic Homeowner Grant Program. It's for low and moderate income residents.
Yeah, and we extended that to benefit the Kennesaw.
That is correct.
In your testimony, you said there are only 11 grants. My recollection is we budget around $250,000.
Yes.
We've been pressing them to try to get more money out the door. What do you think the problem is? I know you touched on it in your written testimony because I'm looking at it, but what do you think the problem is? And should we increase the grant from 25 to 50?
I think that that's certainly something that can be looked at. I think the issue comes down to staffing as well. I mean, you have a very capable staff member working on this, but they also are reviewers for Mount Vernon Square and Shaw and the Bloomingdale Historic District, and so has a lot of regulatory review to do. There's also not necessarily, the money's not guaranteed every year. So at some point it could be zeroed out. I mean, there's no dedicated funding source for this money either, which I think is important. It's not advertised because there's only, when we say 11 or so grants every year, you can get up to 30 if you're in Anacostia, historic Anacostia, 25 if you're in one of the other targeted historic districts. If we went to 50, I mean, potentially that could go down to 5 grants if there were 5 eligible applicants who met those criteria. So
But
because of course
they're not spending the $250,000 a year now, are they?
I think in some cases it's been difficult to do. And I think that that's probably another issue that could be maybe asked of HPO, but I do believe that it comes down to the administrative abilities of the office and that their focus is on regulatory because they are required to review projects in a certain amount of time.
So I think I had a question there. So you're saying that the HPO could do more and it's not doing more to get more grants.
Well, it's not advertised. And I think it's not advertised because they have a limited amount of money to give out, but they also have a limited administrative ability for it as well.
So let me turn to, I don't know if I want to ask Ms. Desai or Mr. Kiesler. I don't understand the legal arrangement. I'm saying that as if that's a problem. I don't mean that at all. I know the building. The building's off of 16th, south of Irving, between the 16th and Mount Pleasant, if I remember correctly.
Right.
And that triangle. It's a condominium. It's a cooperative. It's two.
It's a condo. It's a condo. So the cooperative created a condominium regime. So the entire building is a condominium. The cooperative owns 29 units within that condominium regime. It's unique.
Well, yeah, well, and the building's unique. And I remember in 1979, I think, or 1978, I think you all were the first to exercise the tenant first right of refusal.
That's correct.
To buy the property. How many units overall in the building?
87. 87 residential. There's 3 commercial.
And the 3 commercial are part of the condominium as well?
I think one of them is managed by the co-op and 2 are condominium individuals. One of them is a daycare center, the Barber Chambers Daycare Center. The other one is DC Accesso Bank. And the third is a small business, Frugalista.
And then of the 87 or of the 90, 29 are the cooperative?
Mm-hmm.
Correct.
And the 29 includes one of the commercial units?
It's managed. I don't actually, I don't think, Randy, does the co-op,
Yeah, the unit's owned by CIH Properties, which was the partner that developed the building with us.
Okay. Probably a little bit more detail than I really need. So the co-op, is that the, how do I want to put this, the more affordable units?
Well, the majority probably of the affordable units are within the cooperative, but there are affordable units in the condominium as well.
Yeah, and Randy, you can speak a little bit more. I think what happened is a long time ago, the residents were given the option of co-op or condo to purchase into, right? Because we have a few longtime residents that came out of the tenants.
The co-op formed the condominium with the members that we had at that time, which were 29. And then we marketed the rest of the units in the building to raise the funds to pay for the rehabilitation costs, because we had a nonprofit developer that had done the rehabilitation, the DC Development Corporation, and there were a lot of cost overruns. So we had not foreseen what those cost overruns would be. So we had to raise that capital. And that's what led us to the CONDOP structure. So those those other units were marketed originally as condominium units to raise that capital to make the project work. And then the co-op remained as a part of that condominium.
And the 29 were how many residents were still there when all this happened back in 1979?
How many of the present residents?
No, the 29 units that there are the co-op.
Right.
Were 29 units that were still occupied at the time back in the 70s.
Yeah, back in the day. Yeah, they were all occupied back in the day when we started the condominium.
So the issue here is.
So, I mean, I think that the main challenge is the grants are made to individuals the way that they might work for single family homeowners. The association is the one that undertakes the contracts overall for projects like this, because it's part of, the co-op is part of the condominium. And the structure of the program, which was, I get it, it was put together last year to fit us in, makes it really challenging to get an understanding of how much is being awarded, when it's going to be awarded, currently the discussion that we've had is we can't get the grants without committing to doing all 25 balconies at once. And so when you say commit to $2 million of work without that kind of knowledge, it puts us in a bind. It puts us in a bind, number one, with our moderate income owners that may or may not, that have fell through the cracks. And when you do a special assessment, it basically goes assessed to the unit. So that owner is responsible for their amount. They'll be asked to give that amount to us within a 36-month time period, which right now averages around $30,000. And there are big and small units in this. So I don't want to say that everyone's going to be paying that. It's just an average. And so it puts a lot of stress on households if we commit to this as it's structured.
Okay, thank you. I don't have any more questions. I should, but I want to thank each of the witnesses. We're going to turn to the. Hold on a moment. I'm being reminded of something.
You're muted.
Chairman, can I get a quick question in while you're pondering over there?
Yeah, I'm
Thanks.
being told a couple of different things. There actually was one more witness I didn't call. And
okay.
I want to hear from her, but Councilmember Lewis George, why don't you ask whatever questions you have? And then
Thank you. I appreciate it. Thank you to this panel. Bob, can I come to you first and ask you sort of about new racial equity approaches to historic districts?
Yeah. So my whole point is that there are questions out there that we're not asking about historic districts and their impact. There is some academic research on this that shows that when you create a historic district, it gentrifies. That's probably the case in DC, but we don't know. The data exists, the maps exist. We're not putting them together, and we should be. It should be a priority. I'm not going to prejudge what the answer is, but I think it is something that if we're going to take a racial equity lens, as we should be doing, to the administrative aspects of our government and the impacts that they're having, historic preservation needs to be part of that mix, and it's not. And I haven't heard anyone talking about it.
Got it. What should Office of Planning be doing around this?
They just came out with their preservation plan for the next 5 years, and it wasn't included there. And I think that's a missed opportunity.
All right. Okay, I'm going to follow up with them on it. Thank you for bringing that in. I want to go to Alex Baca from Greater Washington. Question for you: what does Greater Washington consider affordable housing?
Great question. One of my favorites to answer. We actually align pretty closely with the definition that Office of Planning uses in the Housing Framework for Equity and Growth report, which I'm happy to send over. That breaks the definition down into dedicated affordable housing, defined as income and rent restricted housing supported or subsidized by local and federal programs. And then it uses naturally occurring affordable housing. I want to focus on the first part of that because I have some opinions on the concept of naturally occurring affordable housing that are not easy to talk about. But dedicated affordable housing that is subsidized and income restricted is what we consider to be affordable housing. Sometimes I refer to that as capital A affordable housing because it's there's a hard subsidy in there, and that may be public funding, whether that's through HPTF or LIHTC credits or other stuff like that. Inclusionary zoning fits in there also because it's income restricted. But I want to note that IZ is funded by developers only. As soon as you start adding public subsidy into that, it's not IZ anymore. IZ, we consider that to be value capture of private profits from developers. That's and so as soon as you start merging the public funding into that, it's still affordable housing, but it's not IZ, right? So there's those two subcategories. Beyond that, there's, and this is my issue with the naturally occurring affordable housing stuff, is that is all it's, those rents are not below market rent for any subsidy reason. It's often because the properties themselves are in bad shape. They're slumlords, they're further out, they're less lucrative. So that's kind of cheap housing, right? But it's still on the private market. It's privately owned. It's not subsidized. Maybe tenants in that have tenant-based vouchers, but the housing itself is privately owned, not subsidized. So we kind of break it into those subsidized and not subsidized. And if it's subsidized, then it's income restricted. And that's based on sort of my work in the past on this. And I find that to be a really good way to break it down. And that tracks generally with the definition that OP uses, which I find just helpful for consistency.
Yeah, I appreciate that. And so I think based on sort of those definitions, what does Greater Washington believe needs to happen to make more of that happen?
Yeah, and my DHCD testimony spoke a lot to this because I think the Housing Committee's oversight of DHCD, frankly, has been poor. And so when you see sort of reports on DHCD's misspending and not spending enough on 0 to 30%, that's really frustrating. And it's that is a DHCD problem, but it's linked, of course, to OP and sort of what we permit and what we enable in different places. And so, linking that to land use, with especially subsidized housing, if you're looking in neighborhoods with really high land costs, like Rock Creek West, like Capitol Hill, where we need to build more housing and especially more subsidized affordable housing to hit those targets, it's going to cost more. We are totally fine with the cost of that, but it's going to cost more. It's going to require more than IZ. pushing IZ down to requiring 30% IZ is not like, it's ideologically, I get it, but we're going to need public subsidy for it, which kind of like kicks it out of what IZ is. So it's permitting more structures in more places that we can then subsidize, or like subsidize people. And that's kind of the project versus tenant base. So for the land use question, when I talk about changing zoning, or, you know, with the comp plan conversation, increasing density through the future land use map, we're not having that conversation anymore. But that was the basis of this, is like enabling more housing in more places so that we can put that subsidy in more places, because we're not gonna get truly affordable housing without the subsidy.
Right.
But if you can apply the subsidy, like you need the thing to apply the subsidy
Yeah.
to exist in the first place.
Yeah, absolutely. So, and I'm curious, what are your thoughts of OAG's proposals? I've already asked Office of Zoning. I'm going to ask Office of Planning. What are your thoughts on the proposals?
They're fine. You know, I get where they're coming from. My biggest issue, and OAG knows this, is that, and I have asked OAG this, is that like a lot of their materials have said that they are, you know, working in the public interest, but they haven't determined what the public interest is. And I don't think that we can reasonably just like trust any given attorney general to make a consistent decision in the public interest. I think that's really opaque and not transparent, and kind of runs counter to some of the stuff that OAG's office has promoted in the past. So that's kind of a frustrating top-down thing. I love eliminating parking requirements in affordable housing. I think we should eliminate parking requirements in like all new development. I do believe the zoning commission approved that. So like, that's one thing that they have actually like worked together on. The 30% IZ thing is frustrating. When I've talked to OAG about this, like we've sort of all said like, oh yeah, that's probably going to need additional public subsidy and can't just come from the developer because land costs are really high. And then the conclusion is, well, that's not IZ anymore. It's publicly subsidized housing, which is important and I believe in. But it was like OAG has kind of promoted this as just, we're going to knock IZ down to 30%, which is a little bit weird. So I think there's some inconsistencies in this. I suspect, but not working for either of them, I can't say, that OAG and OP are not talking, and that's like frustrating. And I would like to see more collaboration from both entities there.
Yeah, I think there's a reoccurring theme of collaboration across branches of government. That's for another time, another day. Let me ask you this: Are planned unit developments, PUDs, the only path forward for getting more housing than by right?
Right now, I think so. Yeah, I wish that weren't the case. And you know, I mentioned in my testimony that like I am a big fan of the idea of approving something if it has a certain percentage of affordable units in it, and just having that approved by right, especially in planning areas where we know that we need those affordable units, like Rock Creek West, Capitol Hill, near Northwest. So that's a big one. You know, right now, PUDs are the systems that we have. I've written a lot about how those consistent negotiations can be really powerful, but more often than not are really frustrating. And so I would love more options that kind of allow for more than what we can build under current zoning, you know, up to the future land use map without having to go through the PUD negotiation. IZ Plus does this to some degree with map amendments, which I think is really important. But I think that this is an area that we have sort of left untapped because everyone likes the idea of discretionary development more than they like the idea of by right development, right? Like people get understandably nervous if it's like, oh, this thing is just getting built and we don't have input. But
yeah,
you know, at the same time, like there's been a lot of input, and like elections in some ways are input on what our development politics are. Like the comp plan, most people on this call, or not call, on this hearing, participated in the comprehensive plan process. This is a high information group, right? Like we've provided a lot of input, and change, like embracing, I think, more of a mentality that PUDs are not always like, you know, it's important to get them moving, but we shouldn't stop there, is sort of how I feel. I'm heartened to hear that the zoning commission feels that they are moving in a positive direction after a rough few years, but I also don't think that that should be the stopping point.
Yeah, okay. I appreciate that. Parisa, I wanted to come to you for a second, if you're still here, and to see sort of what you think the Office of Planning should be focused on, should be doing to create affordable housing, and what ways you think they could be engaging better around planning for with the community.
For the question. You know, we can't have an equitable outcome if we don't have an equitable process. And I think the Office of Planning, first and foremost, is responsible for stewarding an equitable process to make sure that communities are heard, have the information that they need, and that we're looking at impacts cumulatively, not looking at one individual project here, one individual there. We don't have the data that we need to really assess what's happening on a hyper-local level. We don't have the environmental data, the displacement data, the housing need data. You know, how many residents need 30% AMI housing in the city as a whole or in this area? How many returning citizens are going to need housing? How many people with disabilities are going to need housing? How many families? So I think first and foremost, the Office of Planning should be stewarding that piece of it more. It was interesting to hear Sarah Barden say that they were going to implement a GIS mapping system with racial data. Well, data is really necessary. We need it for the environmental justice community. We're challenged with this because we have no way to layer on the health equity data with the pollutant information, with the land use information to show that when you're in an area that it's heavily concentrated with these polluting facilities, it is impacting your health, you know. And so then we, you know, the community is constantly at a disadvantage because they know these things are impacting them, yet they don't have the data proof. So I think that's one thing that the Office of Planning, you know, could really steward. I have to say this year, they're going to be doing 3 plans that we're really going to be following closely that dovetail: the Ivy City Small Area Plan, the Industrial Land Use Study, and the New York Avenue Vision Framework. And none of those are going to be of any use if we don't incorporate some level of health and racial equity analysis, data, and outcomes. These are communities that have been heavily impacted, land use racism over decades. You know, the over concentration of industrial sites in certain areas. And I'll just say this: we have to change what we're doing, or the outcome is going to be the same. You know, like, we can talk about equity all day, but if we're not making different types of change, you know, land use decisions, if we're not investing in things differently, if we're not like taking away harmful things like trash transfer stations and asphalt plants from the middle of residential neighborhoods, we're not going to have, you know, equity at the end of the day.
Yeah. Thank you. I appreciate that. I got it. My time's up. Thank you.
Thank you. And I overlooked calling Ms. Neruzzi to testify. Did you have a statement?
I do. Yes.
Please.
May I? Okay. Thank you. I'm Parisa Neruzzi, Director of Empower DC. It's a grassroots nonprofit organization founded in 2003. We do a lot of work around equitable development, racial equity, and environmental justice. I have concerns both about the Office of Planning and the Zoning Commission that I want to share today. And a lot of it does echo what has been stated about the failure to implement the key policies that we all fought for and we're excited to see added to the comprehensive plan. And I want to remind us what the comprehensive plan says about the racial equity lens that is supposed to be implemented for planning and development decisions. It specifically, the implementation element says that it must identify and consider past and current systemic racial inequities, identify who benefits or is burdened from a decision, disaggregate data by race, and analyze data considering different impacts and outcomes by race, and evaluate the program activity or decisions to identify measures that reduce systemic racial inequities. So as we heard from the zoning chair and the zoning commission, and when you speak to the Office of Planning later, they have not articulated an approach for this at all. And I just mentioned the issue of even just the data we're not seeing disaggregated by race and analyzed to identify the different impacts. The comp plan is also very specific that there shall specifically include a process for the zoning commission to evaluate all actions through a racial equity lens. So again, this is not just, hey, we talk about equity. Chairman Hood is very frustrating to me. Oh, I've been talking about housing. I've been talking about gentrification for years. Yes, you've been talking about it. You've been saying things. That does nothing. It does nothing to show any real analysis or effect in the decisions that are being made. So I just urge the council on two fronts. When, as we look at the new Office of Planning Director and confirm that person, to ensure that that person has demonstrated experience in racial equity approach and can articulate what that will be. So far, the Office of Planning has not articulated what their racial equity approach is. And we've met with them as recently as yesterday. And still, you know, over the course of the last 6 months, they have not, it does not appear that they've gotten any further in their ability to articulate that. Chairman Hood is up for reconfirmation. He's been at the Zoning Commission at least 20 years. He's been the friendly face at the front of it that has said the things that we want to hear, yet rubber stamped the same developments that displaced over tens of thousands of Black residents during his tenure. We believe that he should not be reconfirmed. And I would ask, Chairman, that at the very least you hold a hearing on his reconfirmation so that we can talk publicly about that. We're really concerned about Office of Planning eliminating public input in their map and text amendments that they've submitted to the Zoning Commission. So when you submit something for a map amendment, like they've done in Berry Farm, or for a matter of right, like they've done with the recent WMATA facilities, you are thereby eliminating public input down the line. And we're very concerned about that, especially in cases like this that impact public housing residents going through a decade plus redevelopment, or in adding a facility like a bus facility into a residential area that has environmental and racial equity implications. And then I would just add, Chairman, that I hope you will really do a lot of work to track the implementation of the comp plan, make sure that the Office of Planning does the reports that are required, which it has never really done in the past. Make sure, hopefully, that we have hearings to really be up to date on what the implementation is. And I would ask, as we go into the budget, that you consider adding funding to implement the anti-displacement strategy that is articulated in the comprehensive plan. It talks about really analyzing the forces of displacement and creating interventions in neighborhoods that are most at risk, anti-displacement zones that has been discussed. So we would need to fund that. Just lastly, on the PUDs that we were just talking about with Councilmember Louis George.
You're over your time, so if you could wrap it up, please.
This will be my last point. We can't have effective community engagement around any development at the Zoning Commission if there has been no planning for that area. So the way that I see it is, first we have a community plan, we have the data that's available, we understand what the community wants in terms of negotiating benefits. Then when we evaluate developments, we're not looking at them as just one-offs. We're looking at them in as a cumulative impact on the community. And so I think that planning process is integral then to the zoning process. Thank you.
Thank you. I'm sorry I didn't call you earlier. I don't have a copy of your statement. Would you submit that, please? And Mr. Roberts, I don't think I got your statement. If you would submit that.
Okay, very good.
Thank you. I don't have any further questions, so I'm going to I've already thanked you. I'm going to excuse you and then call Barney Keith and Anita Cozart. So thank you again. So I have two government witnesses. I've got Ms. Cozart and I have Ms. Heath. And my witness list has Ms. Heath going first. Is that okay with both of you?
Yes, it is, Chairman.
Although it looks like Ms. Heath dropped off. Keith, do you want to go first, and then we'll hear from Ms. Cozart?
Sure. Thank you. Somehow I was in as a panelist and then I dropped out again, but thank you for allowing me to speak. Good morning, Chairman Mendelson, council members and staff of the Committee of the Whole. I'm Marnique Heath, Chair of the DC Historic Preservation Review Board. I'm pleased to appear today to share the perspectives of the Historic Preservation Review Board on our interaction with the Office of Planning, and in particular, its staff in the Historic Preservation Office during the past year. This is the first time that I'm providing testimony at an oversight hearing for the Office of Planning. For some time, beginning with my predecessors, it has not been an established practice for the HPRB chair to testify at these hearings. This year, however, with the continuation of virtual hearings at the council, HPRB, and other city boards and commissions, I thought it would be particularly appropriate to participate in a forum that has become a familiar and effective way to reach a wide audience of district residents beyond a single hearing room. This also gives me the opportunity to respond to your suggestion at HPO's oversight hearing last year, Mr. Chairman, that HPRB should ensure that our members appear on the video feed of our public meetings as we discuss the cases presented to us. I'm pleased to let you know, as you heard earlier today, that we have worked with the Office of Planning staff to enhance our virtual meeting setup so that board members do now appear on camera as we conduct our reviews. We believe that has helped to improve the user experience of our meetings, and we appreciate your making the recommendation. I'm pleased to report that we have a full complement of HPRB members, representative of the district's residents, and meeting the National Park Service's requirements for professional representation on state review boards. All of our board members actively participate in our deliberations to ensure that we benefit from the expertise of professionals qualified in architectural history, and archaeology, as well as the important perspective of informed public members engaged in preservation. We also benefit greatly from the professional expertise of the Historic Preservation Office staff and the detailed staff reports that they submit for each case we consider. These reports are always well prepared and well reasoned, giving our members a solid foundation for conducting our review and deliberation, whether the case involves an application for historic designation or a project review. The staff reports are only one example of the excellent support we receive throughout the year from the Historic Preservation Office. The staff helps to orient and train new board members before their first meeting and arranges for periodic training on preservation topics by experts in the profession. In 2021, we had a briefing from the National Register staff of the National Park Service on criteria for nominating projects to the register. We also had recent training from OP's counsel on conflict of interest issues and equity training from Dr. Amber Hewitt, the mayor's chief equity officer, in a joint session with the Zoning Commission and the Board of Zoning Adjustment. This past year, the HPO staff expanded on a new opportunity that virtual hearings provide. We've long recognized that board members can learn from experience, and now the staff schedules periodic sessions at our public meetings to consider photographs of completed projects that we reviewed. This allows our members to discuss what makes preservation projects successful and to draw lessons learned about how designs can be improved. We think these on-the-record discussions increase public awareness of the board's careful application of preservation standards in different contexts. They have been well received also by the audience. Finally, Mr. Chairman, I would like to mention the large number of housing projects that we have reviewed in the past year. They constitute an increasing percentage of what we evaluate. While our charge in historic preservation and providing recommendations on the compatibility of building designs with the character of historic districts, this does not mean that we are unaware of the broader importance of these projects to the district's planning goals. We are in fact acutely aware that adequate and affordable housing and equitable development are among the most important challenges facing the district today. As the mayor's expert advisors on historic preservation, we fully support the district's housing policies and seek to do our best to ensure that new housing projects enhance our historic neighborhoods and help to bring the new vitality throughout our community that we all seek. Thank you for the opportunity to present my testimony. I would be glad to answer any questions you may have. Thank you.
Thank you, Ms. Heath. Ms. Codes.
Thank you. I'm glad to be here. Good afternoon, Chairman Mendelson, Councilmember Louis George, and staff of the Committee of the Whole. My name is Anita Cozart. I serve as the Interim Director of the DC Office of Planning. I'm very pleased to share with the committee the activities and accomplishments of OP during fiscal year 2021 through the first quarter of fiscal year 2022. In March of 2021, at our last Performance Oversight hearing, we identified 4 priorities for the fiscal year: enactment of the comprehensive plan update, neighborhood vibrancy, housing, and public and civic life. I'm pleased to report OP made significant progress towards the goals we discussed last March across those priorities. In August 2021, Mayor Bowser's comprehensive plan update was enacted after unanimous council approval and review by the National Capital Planning Commission and the US Congress. Subsequently, the council approved the comp plan's future land use map and generalized policy map. Enactment of the comp plan was a crucial step to advance the district's work in housing, economic recovery, resilience, and racial equity. All of OP's work that I will discuss throughout this testimony is guided by the policies and actions included in the comp plan. The final print of the comp plan has been delivered to each of the council members and is available at each library branch and a electronic copy online at planning.dc.gov. Small area plans and other neighborhood planning initiatives support comp plan implementation and provide targeted guidance at the community level. In FY21, OP collaborated closely with the communities of Congress Heights, Pennsylvania Avenue Southeast, and Chevy Chase on the development of 3 small area plans. The Congress Heights Small Area Plan focuses on how improvements to the public realm, community facilities, and housing can improve life outcomes for Congress Heights community residents, with a focus on Black residents, people with disabilities, older adults, and youth. Additionally, the small area plan highlights how Congress Heights residents can benefit from and participate in the ongoing and future development of the St. Elizabeth's campus. The Pennsylvania Avenue Southeast Small Area Plan is guided by 4 themes: housing to support rental and homeownership opportunities across the income spectrum, transportation and connectivity to establish Pennsylvania Avenue East as a gateway, vibrant public realm to distinguish the corridor as a destination where all residents can live, work, eat, play, and connect with neighbors. And lastly, economic development to support a retail destination and attract and retain businesses. The Chevy Chase Small Area Plan presents a vision for equitable growth along a gateway corridor. The Small Area Plan explores how the Chevy Chase Library and Community Center sites can be redeveloped with a residential component, including a significant share of affordable housing. Once completed, this Small Area Plan will support affordable housing production, as well as vibrant public spaces, retail, and other amenities along an established Main Street corridor. OP anticipates releasing all 3 draft small area plans for public review and comment in the 2nd and 3rd quarter of this fiscal year, followed by a submission to council. Additional neighborhood planning initiatives in FY21 included a technical advisory panel with the Urban Land Institute to envision the future of Friendship Heights, the North Capitol Cloverleaf urbanization study to help redesign the Cloverleaf interchange at North Capitol and Irving Streets, partnering with the Office of the Deputy Mayor for Planning and Economic Development and the Coalition for Nonprofit Housing and Economic Development on a comprehensive community development model for Deanwood. Throughout FY21, advancing Mayor Bowser's housing goals and initiatives was a key priority for OP. Since the release of the housing goals in 2019, OP has collaborated with our agency partners, including DMPED and the Department of Housing and Community Development, to move the district closer to 36,000 new housing units by 2025, with 12,000 of those units being affordable and equitably distributed throughout the city. In December 2021, OP, DMPED, and DHCD released the Rock Creek West Roadmap, a framework identifying opportunities to add 2,000 affordable units in a high opportunity areas west of Rock Creek Park. The roadmap outlines how OP's planning efforts along Connecticut Avenue and Wisconsin Avenue, as well as the district's housing tools, programs, and investments can help us meet and exceed the planning area's housing goals. OP's neighborhood planning initiatives in Rock Creek West will explore how we can leverage updated comp plan guidance to maximize the production of affordable housing in the planning area that has seen the fewest dedicated affordable housing units. In FY21, OP continued to advance updates to zoning regulations that support market rate and affordable housing production. Updates to inclusionary zoning known as IZ Plus and IZ Excel accomplished two important outcomes: higher affordability requirements when properties take advantage of additional density through a zoning map amendment. And secondly, applying IZ requirements to areas of the district and types of buildings that were previously exempted. In November 2021, OP launched an initiative to recommend zoning amendments that will allow faith-based institutions to develop affordable housing on their land. OP will coordinate this initiative with DHCD's pilot program for supporting faith-based institutions in developing affordable housing. OP continues to manage the district's historic homeowner grants, which assists low and moderate income homeowners with the costs of repairing their historic homes. In FY21 and FY22 to date, OP reviewed 41 eligible applications and managed 28 grants totaling $443,000. This included 10 projects in the recently eligible Kingman Park and Bloomingdale historic districts. It also included the first awards in a multifamily building to 16 homeowners in the Kennesaw Apartments, totaling $224,000. OP is working with homeowners to execute the grant projects. Public and civic life was another of OP's key priorities in FY21. This included supporting the infrastructure of our democracy through work on the US Census and redistricting. OP provided technical support to the council as it conducted the redistricting process for the district's ward boundaries, including procuring a mapping tool, facilitating training, providing data and maps, and ensuring submitted plans met legislative requirements. In FY22, OP will support council's redistricting of advisory neighborhood commissions and single member districts. In FY20, OP led the district's effort to ensure a complete count in the decennial census. Since the 2020 census data was released, we have received several inquiries about its accuracy. The district is looking closely at the option to challenge the 2020 census data. Once additional data is released by the US Census Bureau in spring 2022, OP will complete an assessment of the accuracy of the 2020 census. The COVID-19 public health emergency has highlighted the importance of the district's outdoor spaces and commercial districts. In FY21, OP worked with the Urban Land Institute on an advisory services panel for the Central Business District, which explored the impacts of the COVID-19 pandemic and examined ways to support the Central Business District's vibrancy, equity, and economic resiliency through public space interventions and innovative economic approaches. OP staff also worked with the District Department of Transportation to review public space permits for outdoor seating and events to make sure district residents and visitors could safely enjoy the outdoors during the pandemic. In a survey administered by OP regarding the district's program for outdoor seating and events known as the Streetery program, 78% of business respondents said that the program allowed them to rehire, retain, or expand their staff. OP leads the Commemorative Works Committee, which is tasked with developing criteria to review, evaluate, and provide feedback on applications for placement of commemorative works on public space. In FY21, the committee held 6 public meetings and recommended to the mayor and council the district's first commemorative work since 2017, titled Lincoln, the Emancipation Proclamation, Freedom and Union. In FY22, we anticipate the committee will work with 3 to 6 applicants proposing commemorative works. OP released a draft location strategy this year, which identified 40 potential locations for commemorative works in public spaces across all 8 wards. OP plans to release the final location strategy in April of this year. In FY22, OP will also explore how a commemorative works vision plan can help to advance the Diverse Washingtonians Act. In FY21, OP conducted an update to the district's 5-year historic preservation plan entitled Celebrating Our Diversity. The plan builds upon the previous 2016 and 2020 plans and the comp plan's update for a refreshed vision of historic preservation. The 2025 Historic Preservation Plan was informed by nearly 2,900 comments from 660 respondents through an OP-led public survey. These responses confirm support for the plan's renewed focus on exploring neighborhood history in all 8 wards. The document is currently under review at the National Park Service, and OP anticipates releasing the final plan in the 3rd quarter of FY22. Finally, I want to highlight racial equity, which is a major theme of the comp plan and a guiding principle for OP's work. The comp plan recommends several racial equity lenses that the district will use to advance investments, policies, and programs that seek to improve the lives of residents who've been most marginalized by systemic racism and structural inequity. OP began to develop and apply 3 racial equity lenses in FY21, including our assessment of consistency of the Zoning Commission applications with the comp plan, in our evaluation of consistency of capital improvement plans with the comp plan, and in the development of neighborhood plans. While racial equity has been central across OP's work, there are 3 additional projects I will highlight. First, OP's food policy team released a 2021 update on the food access and food security in the district, which discusses the disproportionate impact of food insecurity on Black and Latinx households and evaluates ambitious steps that the district has taken and the progress that's been made to address food insecurity. Second, OP and DEMPED have partnered with the Urban Institute on the DC Upward Mobility Project, an interagency effort that aligns district programs, policies, and investments to move residents from poverty towards prosperity. Lastly, OP's historic preservation team has continued its projects to research underrepresented communities. In FY21, this included work on historic context narratives for women's suffrage, the district's Chinese and Korean communities, and an application to the National Park Service for a grant to study DC Latino heritage. OP's racial equity work in FY21 was rounded out by releasing its racial equity narrative, which expresses the agency's commitment to applying a racial equity lens in both internal operations and external work. To live up to this narrative, the OP will continue to work with the Mayor's Office of Racial Equity to strengthen our community engagement and evolve the practice of racial equity impact analyses. Now that the comprehensive plan update has been enacted, OP is excited to fully transition the agency's resources to implementation. Our work plan for FY22 centers around 3 priorities: housing equity, economic vibrancy, and sustainability and resilience. Across these areas, OP will prioritize racial equity. OP will continue to advance Mayor Bowser's housing goals through neighborhood planning and zoning. In FY22, OP's neighborhood planning initiatives include the Wisconsin Avenue Development Framework in Friendship Heights and Tenleytown, the Connecticut Avenue Development Guidelines in Cleveland Park and Woodley Park, the New York Avenue Vision Framework, the Ivy City Small Area Plan, and the Deanwood Community Plan. Each neighborhood plan will identify opportunities to add market rate and affordable housing to maintain existing affordable housing. The plans will also advance community priorities related to urban design, public space, transportation, economic development, resilience, and historic preservation. OP will further assess opportunities to amend the zoning regulations in alignment with the comp plan update to support the mayor's housing goals. In FY22, OP will pursue further changes to the zoning regulations to support the development of affordable housing, remove barriers to the conversion of underutilized office buildings to residential, and to promote new accessory dwelling units and alley dwellings. Finally, OP continues to examine the zoning regulations to make them clearer and easier for the public to use. In FY22, OP will continue to prioritize economic development and public space projects that support the district's recovery from the COVID-19 pandemic. A key project to highlight is the $2.8 million Streets for People program. This grant will fund business improvement districts to temporarily retrofit streets, sidewalks, and alleys to host events where people can safely enjoy civic spaces, cultural amenities, outdoor dining, and retail located downtown. OP will also launch a public realm plan this spring and identify and prioritize opportunities to improve the design of streets, sidewalks, parks, and plazas to support economic recovery. Another aspect of recovery from COVID-19 is strengthening the district's food system. In FY22, OP will continue to address these issues through the work of our food policy team, which is led by Ona Balkas. I direct you to her performance oversight testimony from earlier this month for more information on the activities of OP's food policy team. In FY22, OP is pursuing several projects that will enhance the district's sustainability and resilience. The New York Avenue Vision Framework will develop strategies to mitigate flooding and urban heat islands, improve air quality, reduce emissions, and support renewable energy along that corridor. A related study will examine the distribution of the district's production, distribution, and repair land and evaluate the benefits and trade-offs of retaining these uses, along with important factors such as environmental justice. OP will continue work with our agency partners to move the district towards achieving the targets set forth in Sustainable DC. OP coordinates with the Department of Energy and Environment to encourage development projects to support resilient outcomes in the built environment and provides review to ensure proposed stormwater, wetland, and floodplain regulations are consistent with zoning regulations. OP is also serving as a member of the Office of the City Administrator's Flood Task Force, which is working to develop an action plan that identifies equitable ways to reduce the risk of water damage from flooding in the district. FY21 was a productive year for OP, and I want to take a moment to thank our staff who have been critical to this agency's success. I also want to take the residents that have engaged with OP on our various planning efforts, especially in light of our public health emergency. If residents are interested in learning more about our upcoming work, they can certainly visit our website or give us a call at 202-442-7600. Lastly, I want to thank the committee for this opportunity to discuss OP's work. We look forward to working with you, Chairman Mendelson, and members of this committee on continued progress for the District of Columbia. I'm happy to answer any questions you might have.
Thank you, Ms. Cozart, and thank you, Ms. Heath. I'm going to try to get through some questions fairly quickly. The small area plans that you're doing, one of them is Pennsylvania Avenue Southeast. What are the boundaries for that? And when I say boundaries, I mean the segment of Pennsylvania Avenue.
So we're looking at the Pennsylvania Avenue east of the Sousa Bridge all the way to the district line. And we're essentially kind of looking at, you know, kind of a half block north and south of the avenue.
Sousa Bridge to, did you say Southern Avenue?
Yes.
In your statement, you spoke briefly about the PDR study. We required the study to be completed by January 2024. We funded it in last year's budget. Are you on track to complete it?
Yes.
In your pre-hearing responses, you indicated that you have an MOU with DCRA to, and I quote, provide contract personnel to help fast-track plan review for historic preservation and public space. Unquote. There's no amount associated with the MOU. Can you explain this contract personnel agreement?
Yes, I think I'm actually gonna call on our Associate Director for Finance to help out with this, but so Ed Giefer is on the line. Would you weigh in on this? Thank you, Ed.
Sure, Mr. Chairman, thank you. I'm Edward Giefer with the Office of Planning, and we have an agreement with DCRA for them to provide some contractors to help us both in the public space and for HP. DCRA is paying for 100% of it, so I think it's $300,000 for contract personnel in FY22, and it's renewable for 2 years, I think, after that. So this is funded by DCRA.
So DCRA is paying OP to do plan review?
DCRA is using its own money to hire contractors that they will provide to OP to help expedite HP and public space plan review.
And is this a new contract with this year? When I say contract, it's an MOU. Is this a new MOU that we said has option renewals, but this is the first year?
Yes, sir.
Thank you. Ms. Cozart, has OP done any planning or design work related to proposed transfer of jurisdiction for the RFK Stadium to the district or future development of the site to include a football stadium?
No, not at this time.
Has OP been involved in any discussions regarding that?
I'm sorry, any discussions regarding the transfer?
Regarding the transfer, your answer is no?
Correct.
Regarding future development of the site to include a football stadium?
No.
Can you briefly discuss the status of the Pennsylvania Avenue initiative that was presented at the National Capital Planning Commission earlier this month?
Sure. It's something that has been long in the making, and we're very excited about it. It really creates a wonderful opportunity to do some of the work of downtown economic recovery through public space. And it looks at it creates some ambitious kind of plans for reimagining Pennsylvania Avenue. And we think it very much fulfills a lot of the actions and policies that are in the comp plan around revitalizing Pennsylvania Avenue and also creating spaces for folks for district residents to be able to engage in culturally relevant activities and other entertainment and gathering spaces.
What do you see as the next steps?
My understanding of the next steps is it's supposed to be presented before the National Capital Planning Commission, of which you are a member, Chairman, and that the commission is supposed to be giving some feedback on that, and that it also will be released for a public review period. I am not certain of how many days that public review is, but that's some information that I'm happy to get to the committee after this hearing.
So OP will be releasing it for public feedback.
It'll actually be released. My understanding is that our National Capital Planning Commission will be releasing it to the public because it is a National Capital Planning Commission initiative of which we are a participant.
And you don't know when that will happen?
I am not certain. I may be able to get that answer for you while we're having some questions and answers.
Okay. In your statement, you said that OP has been supporting the mayor's call for 36,000 new housing units, of which 12,000 would be affordable. Does OP maintain on its website a calculator, if you will, of these units, the production of these units? There used to be something on DEMPET. I don't know if it still is.
My understanding is that it's still there and
still where?
It is still on a website that DEMPET maintains. And I think my team is helping to find that, and I'll be able to say on the record where it's located and to also send it after the hearing as well.
Okay, I'd love to hear the if you can get the address. In testimony, there was this statement. We remain concerned, however, that less ambitious housing plans are going forward without the public process or benefits of a PUD or a rezoning due to the risk of being delayed for years on an appeal that has little merit. Also, we are concerned that affordable housing projects that are proceeding as a PUD face costly, perhaps crippling delays as one or two unhappy nearby homeowners can veto or stall new affordable homes, despite broad community support and comp plan guidance prioritizing more affordable housing. We asked the DC Council to continue to work with OP and the Zoning Commission to address these challenges. What's your response to that?
So first and foremost, I would be OP would be happy to work with the council and others to think about how to address this issue. I would say, and we can think together about sets of priorities. Certainly the case of nonprofit housing developers seeking to try to put more affordable housing and more deeply affordable housing. We might think about setting priorities that way. We might also think about setting priorities as it relates to kind of the number of units that are possible somewhere. I think I'm interested in exploring every tool, every site, engaging every resident, landowner, and partner to really make strides and reach our goal.
Well, is it as much of a problem as the witness had stated? When the Office of Zoning was before us an hour ago, they said that the number of PUD cases is ticking up and that the number of appeals has dropped dramatically.
So that is our shared understanding as well. I think that those are facts. There's also a perception that may be present. and that amongst residents, landowners, other stakeholders about the challenges related to appeals. And I think that's one piece where we do need to think about what are the ways to signal to those who might be reticent to provide more affordable housing and take the pathways related to PUDs and zoning amendments. But I think it's complex and nuanced, and it does require a lot of conversation and thinking about what the next steps would be.
In developing your budget for next year, did you ask for additional funding for the historic homeowner grant program?
So the mayor is currently developing the budget and will release it soon. And we're really happy to work with the council as it relates to kind of the approval of that budget as it goes forward.
Did you submit a enhancement request? I think we call them Form Bs.
With regard to the homeowner program?
Yes.
So I'm going to need to consult with my staff about this, whether we use that process or whether or not we I know we've been in conversations as it relates to how to potentially expand that program. I can get you, following this hearing, I can get you a more detailed response.
Would you please?
Yes. And if it's helpful, I have the other two responses that I had deferred. The first one around where you can find information about the progress towards the 36,000 units. It's at open.dc.gov/36,000 B as in boy, Y as in youth, 2025. And that's where that'll be. And we'll certainly send this to the committee in writing. And then the second piece is that for the Pennsylvania Avenue Initiative, there will be a 120-day public review period initiated by the National Capital Planning Commission starting in early March.
Okay. So you'll get me additional information on the historic homeowner grants.
Yes, I will.
Because there was quite a bit of testimony about that the DC Preservation League, the program awards on average only 11 grants a year, scarcely enough to recognize the real need or demand, that it's not being well publicized, that, well, there were comments like that. Can you respond?
So we have had a strategy of going to community groups in those historic districts and letting them know it's available. We do receive more applications than we can approve and the budget allows us to approve. So that's one piece. We'd be happy to work with Ms. Miller in identifying some additional strategies that we should think about employing as we go forward.
So you are receiving more applications than the budget will support.
That's correct. There's also whether or not there's readiness of the applicant to move it forward.
Sure, but that's a different problem.
Sure. I just want to provide the context.
There was this testimony regarding the Kennesaw. However, due to privacy concerns, HVO cannot advise us of the amount an individual will receive for us to properly record them for accounting purposes. Why would that be? If I asked you for a list of the grants and the grant recipients, you could tell me. You better tell me if I.
So,
why would HVO be telling the Kennesaw, which has to pay for all this, that it, due to privacy concerns, you can't even advise us of the amount?
So what we were trying to do was respect the individual privacy of the homeowners who applied for the grants. There's information about their income that's associated with us moving forward with these grants. And so it was out of deference to that privacy. We were that was the judgment call that we made there.
Well, but the statement wasn't due to privacy concerns, HPO will not give us the grant applications. It was HPO cannot advise us of the amount, the grant amount that the individual will receive.
So again, it was a call to respect the privacy of the individual homeowners. They did not all make the same income. They did not all have the same conditions. We advised what the upper limit, certainly we advised that. And so that's kind of essentially where we are.
Okay, now I realize that Kennesaw is unique in this program because it is a multifamily property, but the Kennesaw, and I don't know if that's, I guess that's the condominium is going to have to pay for the work, the repairs. So they need to know how much money they're receiving and how much money they will have to, I guess, borrow or raise on their own. How are they to do that if you're not telling them?
So each of the grants are up to a certain amount. So in the aggregate, we can certainly provide information in the aggregate. The request was individualized to homeowners, and we just thought that would not support the privacy. Our understanding is that the association does know that aggregate amount, and that request for individualized name of homeowner and amount was one that we wanted to keep their privacy.
Well, I'm looking at this paragraph. The income limit for the grant program needs to be restructured so that the condo or co-op can receive the grant directly. The exterior repairs are common elements that the condo association must contract for and pay directly. It is an extremely cumbersome process and one that may not get sorted out by the time the temporary law expires. To require the condo to enter into a contract for the work before funds can be released to the unit owner and the funds then transferred incrementally to the condo association for payment to the contractor in installments. There are other complications. Each owner must be assessed the cost of the repair work through their monthly homeowner association fee. Once that is established, we must then credit the grant funds as they come in against a monthly fee. However, due to privacy concerns, HPO cannot advise us of the amount an individual will receive for us to properly record them for accounting purposes. At the same time, the condo will have to record a covenant against the property taking responsibility for receiving the funds. That is, we have a legal responsibility for proper use of the funds when we don't have full knowledge of the amounts allocated to each owner. Can't OP sort through this and make it easier for them?
So I've asked our State Historic Preservation Officer to come on to opine on this question and provide additional context. David?
Thank you, Anita. Mr. Chairman, for the record, David Maloney, Office of Planning. I think perhaps, well, first let me say that our attorney and the attorney representing the Condo and Co-op Association have had a lot of discussion about this point. Since it is a legal issue about disclosure of privacy information, we on the preservation staff have felt it's best for our attorney to deal with that issue directly with them. However, we did tell the condominium and co-op associations that our grant awards, the amount of our grant awards, was based on the information that they provided to us in their mayor's agent's hearing filing. They gave us a breakdown of the assessments for each unit in the building for the cost of the work that they were planning to do. And since our objective was to cover the costs for the low and moderate income homeowners who were eligible for the grant program, we used the numbers that the building provided to us as the basis for determining how much we should award to each unit holder.
So that explains the process, but I think my last question was, can't OP make this easier for the condo?
Well, all we can do, all we as the preservation staff can do is to follow the advice that we are being given by our attorney and about the privacy issues. And as I said, it's been talked through at length, and we have tried to make it very clear to them that it is a very simple calculation for them to look at the numbers that they provided to us, and the amount that they assessed to each income, to each unit owner is the amount that they assessed to that owner for the owners who qualified for the grants. And we have told them which unit owners have qualified for the grants. We have given them the unit numbers, so they know which of the owners are getting support from us, and the support from us is equivalent to the support to the assessment that the association put on each owner.
I hear you, but what I also heard was testimony that this process is very hard for the condo association. And it seems to me that a government agency has a duty to try to minimize the burden. And I'm not hearing that. And I'm hearing that some of this is due to your general counsel. And that doesn't solve the problem.
And maybe this will help perhaps explain the situation. The law provides that the Office of Tax and Revenue shall certify the income of the applicants for the grants. They have advised us that they are not able to do that. So what it means is that we must request from the applicants copies of their tax returns so that we can make that determination, because OTR will not do it. So I think our attorney and we are very, very sensitive to the fact that people are providing us with their tax returns, and that it really isn't our place to disclose that kind of information to anyone. I mean, it is provided to us.
Does OTR not provide this information for other homeowner grant applicants?
They do not provide it to us. They said that they are not able to provide it to us.
It's for anyone, not just this project.
Correct. They don't provide it to us for any homeowner grant project. They said they are not authorized to disclose tax information to us for this program.
Chairman, we've been spending a little bit of time on this point, which actually was highlighted as a real challenge by the folks who gave testimony. They highlighted some other things. I want to interpret the spirit of your question and the spirit of their testimony that we heard as, how can this be made easier?
Correct.
And I will say that what we will do is spend time as a staff really thinking about that question and thinking about, are there legislative pieces, are there operational pieces, et cetera, other capacity pieces, and where we can do better with this. Certainly the program was not necessarily built around the complexity of this. The beauty and the challenge of this is that this is pretty complicated. So if we can figure out how to make it work here, we can certainly figure out how to make it easier for other multifamily buildings and single family homeowners as well. So you have our commitment that we will spend some time over the next couple of months thinking about how to make it much easier, even as we move through the process with the Kennesaw Cooperative.
I appreciate the spirit of your offer there. I do. I just want to go back to, I don't believe it is a secret or confidential when the district gives a grant, what the amount is. And yet the testimony from one of the representatives was that HVO cannot advise us of the amount an individual will receive, which is to say cannot advise them of the amount of the grant. When we originally drafted the legislation last summer, your general counsel insisted that it be individual grants as opposed to a grant to the entire property. So we followed that advice. And now maybe the representative has got it wrong, and maybe it's not as problematic for the condo as is being told us, but I have no reason to second guess that. I think maybe some conversations that get beyond just, I hate to say this, but what's going through my mind is sometimes lawyers make things more complicated than they need to be in the interest of making things as safe as possible, but safe as possible for the agency isn't necessarily as friendly as needed for the private individuals. So maybe I was doing a little venting there, but we went the route that the general counsel advised. And now we're getting testimony that the condominium association, which is responsible for the payment, for the construction, is more difficult. I had one last question for Marnie Keith, and that is, I'm looking at the testimony from the DC Preservation League, and they've been concerned about adequacy of training and members adhering to the standards for historic preservation in cases before it. How do you, how do I want to phrase this question? What's your take, Ms. Heath, on whether you think there's enough training, whether there should be more done, whether the board is adhering more appropriately to the standards?
I think that the board has been, I'll say, I think the board is more prepared in the past 1.5 to 2 years since we've been doing more training. So while I've heard this comment from Ms. Miller with the Preservation League in the past, I think the HPO staff has done a great job of helping to improve board training and to make it more frequent. We've had training, as I said in my testimony, in a number of different areas that I think has been beneficial to the board. I think particularly, several times a year reviewing past projects so that the staff can present to the board the outcome of the project has been really helpful, both for new and long-term board members to see the impact of the decisions that we're making. It helps us to improve how we review projects and how we apply the criteria under the regulations. And I think all of those things together have made us better prepared as a board to do the work that we have to do.
There's more training in the works?
It is, yes. It continues.
And participation by members is, universal? All the members are participating?
Correct. All members are participating.
Thank you. Let me turn to my colleague, Councilmember Lewis George.
Thank you, Chairman, and good afternoon, Director Cozart and Heath. I'm glad to be here with you both. I want to ask some questions very similar to what I posed to the Office of Zoning, and that's around solutions to the housing crisis and OP's role in responding to our affordable housing process. Can you talk to me about sort of what do you view OP's role is in responding to the housing crisis, and sort of what steps is the Office of Planning taking to sort of ensure transparency and effective participation in the rulemaking process?
Sure, that's a great question. And in many ways, our work on housing is really driven by what was in the comp plan that the council adopted and the housing goals that are there district-wide, but then also at a planning area level. So we see several opportunities, right? There's parts of the comprehensive plan where there were recommendations and policies and actions about supporting the creation of zoning regulations that spur more economic development and housing and that kind of thing on key corridors. And so we're moving forward in places of the city with zoning changes and proposals that spur that as well. We're also examining ways that we can think about, accessory dwelling units. We can think about alley dwellings. These can provide more affordable options. And what are the ways that we can pull back constraints that allow homeowners to make investments in that? We're also, we see great opportunities with our community planning efforts along Wisconsin Avenue and Connecticut Avenue. Through the roadmap, we identified some opportunity sites that exist in Ward 3 that really, in a place that's transit rich and has a lot of amenities. We're identifying ways to both those sites, and then what are the kind of using a planning analysis that we're engaging the community with along those corridors to understand what are the zoning regulations, and in the case of where there are historic districts in Woodley Park and Cleveland Park, what are the kinds of urban design tools that are needed to support affordable housing? Because that is a key piece when we think about rezonings or even the desires that we want in terms of matter of right development. So those are some key pieces. New York Avenue is another place where there's opportunities to integrate more affordable housing. We have to use urban design tools to be careful that we're making sure that those uses that are production, distribution, and repair have compatibility through some urban design tools. So that's a little bit.
Great. I appreciate that. And so thinking of Ward 4 for a second, do you have plans to rezone areas designated for more housing in the FLUM to ensure more IZ, for example, Tacoma Metro area?
I would say not at this time. It's something we could take back and investigate based on what was approved in the future land use map. That there weren't significant kind of changes that would be necessitated through a zoning change. There's so the FLUM didn't kind of drive big changes in Tacoma, but we can take a look and see if there's any very specific sites. If there are any, it would be just only a handful, and I'm happy to provide that as a follow-up to this hearing.
I appreciate that. Is OP looking at how to reduce risk for PUDs, especially affordable housing proposals? For example, we have the Dance Law of Helios project in Ward 4 with lots of 30%. And so just wanted to get a sense of what you're looking at to reduce some of the risk for PUDs.
So I would say that what we're trying to do is create an environment of more predictability, both for residents and landowners and people who work in a community, to understand, okay, what are we wanting to see? What are our goals around housing? And let's get alignment on those so that when it comes to a particular project, we can go back to the alignment we have about goals. And that's why it's so important to have these goals by planning area. We're the first in the nation to do that. And so that starts the alignment. I think community planning efforts can continue to provide that alignment as well. And so we're happy to kind of be invested in those kinds of things. I wouldn't say that they formally reduce the risk, but I think they create a little bit more of clarity around goals and outcomes that would be amenable for the community, the landowner, and other stakeholders.
Yeah, I agree with you there. when are you all hiring a lawyer to figure out what is possible for racial equity via zoning and other land use regs? I gotta ask.
Well, thank you for that question. We do have a general counsel on board, and we are looking to hire somebody, and hopefully we're in the interview process. Hopefully they'll be able to come on within the next month or so. So that's going to help a lot. I would say, I think that we've been really utilizing a lot of tools that we've gotten from the Mayor's Office of Racial Equity. We've been using our racial equity impact assessment tool that has been created by that office and applying that to our current crop of small area plans. We'll be looking to embed a similar tool into the plans that we're doing in this fiscal year, FY22. And we'll also, having that additional staff capacity is going to help us as we think about kind of the reports that OP submits to the Zoning Commission, deepening the racial equity analysis that we provide already and have been providing since October 2021. We'll be able to deepen that with that additional capacity.
Okay. I want to ask about, I asked this already, inclusionary in the planning, but about inclusionary zoning in downtown zones. You know, maintaining the inclusionary zoning exemption for downtown zones appears to condone converting these central regions into exclusive high-income enclaves. Why has the Office of Planning been reluctant to remove the inclusionary zoning exemption for certain downtown zones? And, you know, I think the Zoning Commission has been asking Office of Planning to propose an end to the IZ exemption in downtown zone for over 18 months, but you all have yet to submit any proposal. Why is that?
So I guess what I'll say to this is that there's, with the downtown zones, essentially, if inclusionary zoning is intended to capture bonus density. Downtown zones are different in that the bonus density that would exist in many parts of your ward is just not there because of the zoning category. So it really requires a retooling, a complete retooling of those categories in order to apply inclusionary zoning.
Okay, so let me ask you this. I know your office has referenced potential adverse financial impacts of IZ on downtown property owners, but I'm just wondering, are these financial impacts being prioritized over the need to create more affordable housing?
I would say no to that question. I would want to review what you're saying as it relates to, and maybe contextualize it a little bit as it relates to adverse financial consequences. Certainly there may be some. That said, you know, priorities of making sure that we're achieving our affordable housing goals across the city is very important. It really is a matter of, you know, kind of the zones being very different than other zones around the city. It's not impossible, but it requires some analysis. And so we're happy to, we understand the Office of Attorney General is doing some analysis now. We had done some previously. We're happy to bring that into the conversation. I think the challenge that we really need to recognize is that the analysis from certainly pre-COVID health emergency and even in the beginning of the COVID health emergency, that analysis is not quite as useful to us and not necessarily dependable as some that we would do right now, given the economic conditions and those changing economic conditions in downtown. I hope that provides some context.
It does. I want to, and I'm, you know, I think the Attorney General's office is working on that, but I do think this is an area, and I said that to planning, where we're missing out on the opportunity for affordable housing, and I think it's a huge disservice to the city for us to do that and to maintain the status quo there. I want to turn to a recent action related to Maple View Apartments in Anacostia. The mayor's agent determined that the project was one of, quote, special merit that permitted relocation of historic structures. And I think this determination was based on the plan to offer Class A ground floor retail at the project, which is greatly needed in Anacostia. However, it was recently announced that this retail is being replaced by other uses. I want to ask you, does this move away from retail undermine the mayor's agent's determination of special merit, and what can be done to prevent similar situations in the future? For instance, could preferred uses like retail be included as mandatory conditions?
Let me make sure I understand both of your questions. One about kind of the removal of retail, does that kind of undermine the designation of special merit? And then the second one, can you say the second one more time?
What can be done to prevent similar situations in the future? For instance, could preferred uses like retail be included as mandatory conditions?
So, certainly with decisions that are made by the Historic Preservation Review Board, they have to really align with historic preservation guidelines. And so they have to think about that. So uses, unless it's really tied to a preservation policy, are something that are really more the purview of a zoning commission, for example, right? And so that's something, really to think about. So whatever would need to happen would, we need to think about, kind of roles and responsibilities appropriately. That said, I think the piece about special merit, I think I'm going to have to get back to you, send you a written response about that one, because I think there's some nuances and want to be sure that we're citing historic preservation law and policy appropriately.
Okay. Can I ask you why the Office of Planning recommended not to apply increased inclusionary zoning requirements for several recent amendments in Ward 8?
So one of the things, this gets back to the planning area goals. Ward 7 and 8 have been providing affordable housing for the district and kind of supporting the affordable housing goals and needs of the district, even more so than other parts of the city. And so the determination there was really thinking about, are there other, and we've heard calls from community members about desiring to see more units available across the income spectrum and even at some of the more moderate and market rate units. And so that was some of the determination as it relates to that.
Okay. And was the Office of Planning asked to provide a racial equity analysis of the recommendation to waive additional inclusionary zoning requirements? And if so, was that completed?
So a racial equity analysis around waiving or around not making a recommendation around that?
Right.
That's another one that I'm gonna, because I have to think about this language appropriately, right? The waiver of it and what's the right language. So let's, I'll provide a response to you following this hearing and writing regarding that.
Okay. And last question, has the Office of Planning sought input from the Council's Office of Racial Equity or other district organizations working with the issues around racial equity?
Yes. I'm sorry.
And if so, like, what is the status? What has been happening around that? Just rounding this out on sort of the racial equity analysis that is needed moving forward.
So sure. So we have engaged the Council Office on Racial Equity. Where we engaged them was on their review of the comprehensive plan update. That's been the most recent engagement. We anticipate there being some engagement as we move forward with some of the small area plans, as it is their duty for things that are legislation to take a look at that. We've also been working very closely kind of across a number, kind of a multi-pronged effort with the Mayor's Office on Racial Equity. I mentioned the Racial Equity Impact Assessment tool that we've been working to implement. We've also been working with them as we think about disaggregating data by race. And we've been presenting that disaggregated data in our small area plans, and we're trying to figure out how can we do that in a more fulsome way. and learned lessons from other agencies that have been doing that and community members that have been doing that. And then through kind of community engagement, you heard Commissioner Rhodes and you heard Ms. Neruzzi talk about the conversations that we've been having as it relates to racial equity, and hearing from them, especially about equitable processes, and having sets of listening sessions specifically in Ivy City around what an equitable process looks like, as well as the outcomes that are, because equitable outcomes, you can have an equitable process, but still you need the equitable outcomes too, right? And so we're also talking about those outcomes as well. So that's been a bit of the conversation. We've also had conversations about racial equity in the context of what was shared by several folks who testified about Ward 3 and the legacy of segregation and exclusion and forced expulsion. And so that has been something that we've been reflecting in the forthcoming drafts of some of our small area plans. So that the public and council will see very soon.
Yeah, I hear you, and thank you for that work. I think it's so important. You know, Chevy Chase is working on a small area plan and doing that work. And I think, you know, sometimes we hear feedback of them not feeling, I guess, I don't know, included or feedback. And some of that is people just saying, you know, I disagree with any type of you know, more affordable housing. And others of that is really like legitimate. I think people want to be engaged more and understand the process. And I think there's a fine line there for us to, you know, parse out and do the work that needs to be done. And I think the more we engage community and make this process more understanding, I will say, you know, we talked about Helios dance loft in Ward 4 and what a great project it is. And I think what I'm experiencing is, I'm sure what you all experience on a grand scale across the city, which is people not really understanding sort of how this process works and the sort of importance of it. And I think sometimes we just use language that may not, you know, express it, you know, the right way. And I try to do my best as ward council member to like have my input and really, you know, be a part of the conversation to you all and to zoning when these great projects come that we can support and do this work around community. So thank you for your time. I'm looking forward to the hiring of the racial equity attorney. And also thank you for your office's help and support on redistricting. The wards are in the redistricting process and your office has been supporting us greatly. And so I just wanted to throw that thank you out as well. Thank you.
Thank you, Councilmember.
Thank you, Councilmember. I think that's going to conclude the questions we have for you. We will see you in about a month. I believe March 24th with regard to your budget.
Wonderful. I look forward to it. And thank you.
I do too. And I think there was one thing you were going to follow up on. I hope your staff took notes.
We took notes and I think there are more than one thing, but we took notes of those things and we'll get them to you.
Great. Thank you. Thank you, Ms.
Thank you.
We're going to turn now to the next agency, which is Department of Consumer and Regulatory Affairs. I think what I'm going to do is we'll let folks in. I'm going to like stand up and stretch, so maybe like a 5-minute break, but let's call folks in. I'm going to call in the first 15, Eleni Christidis, who's with the Legal Aid Society, Kathy Seisel, who's Senior Supervising Attorney at Healthy Together at DC's Children's Law Center, Chuck Elkins, who's a commissioner with ANC 3D01, Evan Lukadakis, who is with the DC Association of Realtors, Melinda Fieldler, who's an organizer with DC Jobs for Justice, Amy Fisher, Danita Coleman, Felicia Dantzler, who's president of AFSCME Local 2743, Tappan Parker, who's chapter chair of Climate Reality Project DC, Kate Talmore, Blair Lapras, Dorinka Komjanovic, who's vice president at 4022 Georgia Homeowners Association, Eric Moreno, Sarah Bagge, I believe it's Bagge, and Desiree Tillinghast. That'll be the first 15. They're being let in. I'm going to just stretch. I'll be 125. let's get started. So the first witness will be Eleni Christidis, and she'll be followed by Kathy Zeisel, and then Chuck Elkins. Miss Christidis, please be mindful of the clock. We have a lot of witnesses, so it's a 3-minute clock. And please proceed. Good afternoon, and thank you for waiting.
Good afternoon, Chairman Mendelson, council members, and staff. My name is Eleni Christidis. I'm a Ward 1 resident and senior staff attorney in the Housing Law Unit at the Legal Aid Society of DC. In my job, I see firsthand how DCRA routinely fails to protect tenants' basic health and safety by failing to enforce the housing code and hold problem landlords to account. Instead, DCRA's lack of strategic enforcement sends the message that there are no meaningful consequences for landlords who routinely ignore tenants' complaints and who allow things like mold, inadequate heat, rodent infestations, leaks, and broken appliances to persist for months and years. In the broader context of landlord-tenant law in DC, rather than fix code violations, many landlords allow poor conditions to persist because it is more cost-effective for them to do so. DCRA's inability to recognize this inverted incentive structure has produced the abysmal status quo, where every few months the press shines a light on another problem property where a lawsuit or tragedy has revealed years of landlord neglect and DCRA failure. This pattern is playing out in 2 buildings in Columbia Heights, where legal aid is working with tenants to challenge rent increases of 34% and 64%. Both properties have widespread mold and other violations like inadequate heat and water damage to walls and ceilings. Within the last 2 years, DCRA inspected and fined the landlord for conditions at both properties. But even after those fines were paid, DCRA's enforcement did not result in either property being flagged for subsequent reinspection or in actual remediation of the persistent mold and other conditions at the properties. Neither property has had a proactive inspection in a decade. If the proposed 34% and 64% increases are implemented, the landlord will reap a windfall and the tenants at both properties will be displaced, despite having lived in substandard and unhealthy conditions for years. These tenants would like to invite every member of this committee to visit these properties, meet with them, hear their stories, and see the conditions that they have been living in for years. DCRA's current performance measures and its transition plan for the Department of Buildings do not put tenant safety and health at their core. In the absence of a strategy, the council must act now to avoid another era of agency failure under DOB. This means hiring enough inspectors to achieve a 1 inspector for every 2,000 rental unit ratio, placing inspectors in landlord-tenant court, and codifying into law a proactive inspections program and clear enforcement timelines and consequences, including suspending or revoking landlord basic business licenses when violations are found. Tenants are consumers too, and they deserve to be protected from harmful products that endanger their health and safety. While DCRA has not sufficiently demonstrated that it takes this principle to heart, we hope the council and the future DOB will. I am happy to take any questions you may have.
Thank you, Ms. Christidis. Kathy Zeisel, and you'll be followed by Chuck Elkins.
Thank you and good afternoon.
Good afternoon.
My name is Kathy Zeisel. I'm a DC resident and a senior supervising attorney at Children's Law Center, which fights so every DC child can grow up with a stable family, good health, and a quality education. We are here once again to testify about DCRA to tell you nothing has meaningfully changed with the agency. This is especially concerning this year since DCRA is setting up the Department of Buildings, and we have to consider the failing of DCRA's Housing Inspections Unit in that light. DCRA continues to fail to ensure that DC residents live in safe and healthy housing. For instance, this year we've had several clients who had inspections where the landlord was cited for no smoke detector, but no follow-up was done and no smoke detector was provided by the landlord. 2 of our clients experienced life-threatening fires and barely escaped with their children, experiencing serious damage to their belongings. In a functioning inspection and enforcement system, the agency should have utilized their authority to fine the landlord at the $2,000 a day level or even the double fine permitted for life and safety violations. If the landlord did not quickly remedy the issue, DCRA should have made the repairs from its abatement fund and sought to recoup the fines from the landlord. Since the Kennedy Street tragedy, we've observed that DCRA is instead shutting down the unit and requiring tenants to move out of the unit immediately when they do take action. They go to an OTA-funded hotel for 2 weeks, but if repairs are not done, the tenant is left homeless. If the landlord, what should happen is if the landlord does not make repairs, DCA should abate the conditions and recoup the costs. Otherwise, we have simply created a way for landlords to constructively evict tenants, evade court, and do so with the aid of a government agency. The current KPIs that DCRA has do not incentivize DCRA to do anything except inspect, because it's the only standard by which they are measuring themselves. If we want to actually measure outcomes that are meaningful, we need to measure not only whether inspections happen, but we need to look at actual outputs that we care about. While we don't have those KPIs now, the oversight answers provide us some information. We can see that DCRA did 4,017 inspections resulting in violations in FY21, and only 861 repairs happened in the same year. In FY22 so far, 1,321 complaint-based inspections resulted in violations. Only 245 violations were abated. And remember, these can be self-reported abatement by the landlords. DCRA doesn't even confirm that the repairs are made for the vast majority of violations found. We don't know that these are high quality or long-lasting repairs. Timely repairs are important to both the health and safety of the individual tenants and families, and to ensure that we preserve our affordable housing stock. The picture of long delayed repairs, if they even happen, from the oversight answers in the dashboard highlights that the council cannot simply allow DCRA to recreate a mirror image of itself in the Department of Buildings. Thank you, and we can't allow these problems to continue to persist.
Thank you, Ms. Seisel. I made a mistake at the beginning of the hearing. I promised Councilmember Lewis George she could make an opening statement before we started the testimony on DCRA. So, Councilmember, do you want to make a brief statement now? And then
yeah, I can do it now. Or I can do it at the end of the witnesses before the director. You want me to do it now?
Yes.
Okay, we'll do. That way I can hop over to DHS. All right, thank you, Chairman, and thank you to our witnesses who've made time to speak with us today. My statement is going to be directed to Director Chopra. You know, when we say there is no sense of mission within your agency, what we mean is there is no sense of true partnership among DCRA and the district. As a director, we hear you make statements about council members and community members not understanding DCRA's role, and we continue to see your lack of accountability at these hearings for undeniable and preventable issues that affect the lives of district residents. The district has been asking DCRA to work in partnership to address preventable community concerns, and DCRA's response is often deflective and disconnected from reality. Whether you agree or not, DCRA is more than an agency that reviews codes, issue permits, and licenses to people and businesses. And in my view, DCRA is a leading public safety agency. 3700 14th Street Northwest is a blighted property that has been in DCRA's system for almost a decade. This blighted property is wide open to the public, has metal bars sticking out from the ground, is a dumping ground for hundreds of liquor bottles, has a pile of bulk trash that's growing each week, and is infested with rodents. Not even a half a block from 3700 14th Street Northwest is 1402 and 1410 Quincy Street Northwest. These multifamily apartment buildings have multiple code violations, translating into families living in poor and dangerous conditions. These buildings have been flagged to DCRA by several partners in Ward 4 throughout the years. Your agency became temporarily responsive after an MPD officer was injured during a shooting on January 23rd, 2022. The shooter was able to run inside 1402 Quincy Street Northwest and hide, partly because the main entrance to the building was broken, an enforceable DCRA code violation. On January 24th, my office and community leaders asked for your partnership to erect a fence around 3700 14th Street Northwest and inspect 1402 and 1410 Quincy Street Northwest. A month later, only 2 units at 1402 Quincy Street have been inspected, and 1410 Quincy Street has yet to be inspected. These buildings cover an area of 1,237 square feet, but have ripple effects in the surrounding 2 miles. At DCRA's Vacant and Blighted Roundtable earlier this year, hosted by the Committee of the Whole and the Chairman, Commissioner Elkins at 34G shared with you a thoughtful presentation on how DCRA can be in partnership with the district, and he shared with you how we can work as a community to identify properties and for vacant and blighted properties. I continue, and yet, in that instance, individual families, businesses and areas are affected, and we can solve these problems with our laws, regulations, and processes, and we have yet to have your partnership and urgency. You are leading an anti-tenant and displacement and health agency. DCRA's role in ensuring tenants live in safe and sanitary conditions by making sure dwelling units meet our basic income code standards have been more critical. We are 3 years into the pandemic, and many of our families continue to struggle to meet the rent. Tenant-landlord communication to ask for essential emergency repairs has become a source of anxiety for many district tenants who have to engage with landlords who want them out of their buildings. You'll hear today from tenants and tenant advocates about how some landlords use poor housing conditions as a tool of harassment and displacement by delaying or refusing to make basic repairs. When DCRA fails to conduct a housing inspection and appropriately follow up, tenant displacement happens. I continue to be concerned about the lack of follow-up from DCRA housing inspectors. Tenants and tenant advocates will illustrate for this committee how DCRA inspectors fail to come back for a re-inspection, placing tenants in unnecessary long waits to get basic repairs that greatly impact their health. DCRA's dashboard illustrates this concerning and chronic issue with numbers. In fiscal year 21, DCRA conducted 5,983 housing code inspections in the district where violations were found. However, DCRA only confirmed 2,520 repairs. That's 42%. In Ward 4, DCRA completed 507 inspections with violations found, but only confirmed only 154 repairs. That's 30%. And fiscal year 2020, as of last week, DCRA conducted 2,233 housing code inspections in the district with violations found, but only 764 repairs. That's 34%. In Ward 4, DCRA has completed 207 inspections with violations found, but has only confirmed 39 repairs. That's barely 19%. According to the pre-information your office sent over, DCRA has 49 inspectors for fiscal year 21 and has 55 inspectors for fiscal year 22, a mix of full-time, part-time contractors. Ward 4 has over 500 registered landlords, which translates to roughly 10,000 rental units. The district has over 100,000 rental units and only 55 DCRA housing inspectors to regulate bad conditions. Thousands of families are living with confirmed housing code violations, threatening their health, safety, and displacement by issues we can solve with our laws, regulations, and processes if we had your partnership. And lastly, you are leading an agency that should provide peace of mind to anyone that uses or occupies a building in DC. On July 21st, 916 Kennedy Street Northwest, a 5-story condominium construction project collapsed, displacing the Constable Calendio family at 914 Kennedy Street Northwest, the Moses family at 912 Kennedy Street, and injuring a construction worker who is lucky to be alive after 3 stories of rubble fell on top of him. 4022 Georgia Avenue Northwest is home to 3 families, the Comoder family, the Njoko family, and the Sashevich family. These families evacuated over the holidays because of structural issues that threatened a second building collapse in Ward 4. It's hard to understand how building collapses can happen when DCRA has been involved with issues permitting, approving engineering designs, and inspecting construction projects. Right now, we have families in Ward 4 that live in fear that their homes will collapse to the ground while they sleep because of issues we could have prevented with our laws, regulations, and processes. Literally, when the wind blows, these houses are blowing in the wind. I have seen it personally. And so when people ask me how we have houses in our ward blowing in the wind, it goes back to DCRA. And lastly, you are leading an agency that should place its regulatory responsibilities on affected neighbors. This literally, the R, it literally is the R in DCRA's acronym. For 6 years, the Coleman family living at 416 Shepherd Street has been dealing with critical damage to their home caused by construction in the home next door, 414 Shepherd Street Northwest. The Coleman family has a cracked wall that floods their basement every time it rains. Your team shared with my office the developer had multiple inaccurate permits and questionable construction workers, several complaints, multiple stop work orders, and revoked abilities to get future permits. Later, the construction halted by the Colemans still have a cracked wall that floods. The Colemans had to hire expensive professionals to defend themselves from something that DCRA should have regulated before the damage took place. The same example is with Ms. Gloria Wiggins, a senior who has been part of our community for 60 years at 5728 5th Street Northeast. Ms. Wiggins has been living in fear that her foundation has been washing off for the past 6 years because of the lack of regulation that took place next door to her at 5732 5th Street Northwest. And Ms. Wiggins has been washing basically away her foundation all these times. You know, I can add a lot more here, such as district residents reporting concerning illegal constructions and being unable to get DCRA inspector in less than 72 hours, or persistent glitches in DCRA system, which wrongly classifies occupied properties as vacant, triggering the Office of Taxes Revenue to charge a district resident tens of thousands of dollars in property taxes, or DCRA's inability to issue a notice of violation to groups boldly violating our noise regulations at like Petworth Metro Station. I do not dispute excellent district employees are working at DCRA. My team and I are grateful for our interactions with your team. However, an agency without a mission to improve by and collaborating with others cannot effectively serve DC. This is why I supported the DCRA being split into two smaller agencies. What I think I will hear in your responses today are statements highlighting how people don't understand what DCRA does and other defensive responses that deflect your responsibility as a district leader. What I hope I hear is a sincere commitment to collaborative work to address the issues affecting our communities. Thank you, Chairman.
Thank you, Councilmember. Chuck Elkins, and you'll be followed by Mr. Lukadakis.
Thank you, Mr. Chairman. I'd like to share my screen if I can. Basically, I think you and I and others are waiting for and anxious to see the new Department of Buildings come online and take care of a couple of programs that have already been talked about today, namely the vacant and blighted properties and the housing rental program. And I think that one of the biggest favors that this council can do for this new building is to help it to develop new key performance indicators that are better than the ones than we have for the DCRA. I want to show you the ones for DCRA now on vacant and blighted properties. Here they are. These are the two that they send us. All they basically are telling us that for the exempted properties, they re-inspect them after 90 days, and they've got a 97% performance on that. And on they also say that within 38 days of learning of a vacant building, they will go and inspect it, and they have almost 100%. But these high ratings, of course, don't show any of us what we know about this program, and that is it is a dismal failure with regard to getting these properties identified and taken care of. So in my attempt to try to provide perhaps an alternative, I'm suggesting that that we have a KPI that would address first the nuisance side of the house, which is those problems with buildings in the neighborhoods, the number of requests for abatement and mitigation that have been addressed by the department. And then with regard to the database, which we know is inadequate and inaccurate as well, the number of complaints that they receive from people other than owners, and also how many of these new complaints submitted by all parties are new identifications. I think this would help the new department reach out to try to get more of these complaints registered and then match them up with their list, their database. Turning to the KPIs for housing units, the present ones basically from DCRA basically say they will respond to a problem within 15 days, and then within 2 days they'll take the inspection and turn it into an NOI. Once again, you can see that they're rating very high on their KPIs, but we know from testimony we've just heard today that this program is really not working because these aren't really KPIs in either of these cases, which go to what the mission of the program is. We need to turn this program around so that it addresses the mission. So just to finish up on the housing rental program, I'm suggesting a KPI, the average time between the NOI and when the violation is abated. And teeing off from a Washington Post article recently about heating, that when an average, give us the average time between the heating complaint and when the heating is restored. DCRA was quoted in that article as saying they didn't even know how many heating complaints they'd gotten, much less how many cases the heating had been restored. So I hope that this committee will work with the new department and get KPIs that are tied to the mission of these programs in contrast to what the situation is now with DCRA. Thank you very much.
Thank you, Mr. Elkins. Evan Lukadakis.
Good afternoon, Mr. Chair, council members, staff. Mr. Evan Ladadakis will not be testifying. I will. My name is Jean Poitvien. I'm a Ward 8 resident, and I've been living in DC for about 16 years. I'm providing comments on behalf of the DC Association of Realtors, the state level association representing over 3,000 realtors, real estate professionals, home buyers, sellers, homeowners in the district. Our members likely interface with DCRA more than any other local agency. The services they provide underpin how we operate and conduct business. First, we'd like to acknowledge and commend DCRA's customer service and communication in 2021. From our perspective, the agency has increased efforts to accommodate customers' needs during the pandemic. To address customer issues, DCRA implemented a 3-day response time via their direct customer service email. Further, last year, DCRA provided the DC Realtors with an official statement regarding the transition complications resulting from the switch from an in-house to an in-house professional licensing process. This type of direct, transparent communication is essential because it helps alleviate the flood of inquiries both out to our agency and to DCRA. Moving on, some steps of modernization systems are providing to be helpful. The implementing of the permit wizard was a move in the right direction. The tool helps demystify the permitting process for residents seeking to start a residential process. And to tie in the inspections, DCAR welcomes the new flexibility to reschedule inspections. I'm referring to BBL inspections with the assigned inspector. Before this change, the no access fines of $1,047 were being levied if residents had to reschedule an inspection. As DCRA branches off into the Department of Buildings and Department of Consumer and Licensing Protection, we strongly urge that DCRA assemble a stakeholder working group to help facilitate the recommendations throughout the transition. If a group is convened, DCAR respectfully requests to be included. Next, I'd like to emphasize 2 areas that have caused significant concern among our members. The Tetris platform has the potential of providing transparency, accountability, and value to the district, as well as the real estate industry, but the platform rollout was fumbled. To facilitate payments from homeowners to the inspector, DCRA imposes itself as a third party, collecting 10% processing fee on all transactions. DCAR contends that this is a critical misstep. DCRA, being a party to the transaction, can have consequential legal implications, and depending on the work performed, the 10% fee can substantially be a cost burden to the homeowners by the contractors tacking on that additional fee. Secondly, we're deeply disappointed that DCRA is limiting homeowners from using their primary area of residence as a short-term rental while they stay in the accessory unit, for example, an English basement. Nothing in the Short-Term Rental Act of 2018 or the zoning regulations dictates which part of a residence a homeowner must use as a short-term rental. We encourage DCRA to work with the council and homeowners to find an appropriate solution. As always, DCAR is more than happy to offer itself as a resource when seeking to improve necessary functions of DCRA. DCAR would like to thank the council for performing such an important review of the district's regulatory functions, which have a significant impact on DC residents and business. Thank you, Mr. Chairman and members. We will be glad to answer any questions that you may have.
Thank you very much. Melinda Fiedler. Is Melinda Fiedler here?
Hi, good afternoon. My name is Melinda Fiedler. Hi, I'm an organizer with DC Jobs with Justice. We're a 70+ member organization made up of local DC labor, community and faith-based organizations working to advance the rights of working people and support community struggles to build a more just community. For the past 5 years, we've been working with community members and local workers to address multiple complaints of labor violations against Power Design, a Florida-based electrical contractor. As you likely know, this led to the 2020 wage theft settlement, where Power Design had misclassified workers in order to pay them less and were forced to pay $2.75 million back to the affected workers and the district. Over the course of our investigation into Power Design, we became aware of potential additional licensing violations. We filed a complaint with the Board of Industrial Trades after hearing that the company had used unlicensed electrical subcontractors to perform electrical work here in DC. We were very pleased to find that DCRA opened and investigated our case and in fact issued a 145-page report in February of 2020 that confirmed what the workers had told us, that Power Design has in fact employed unlicensed electrical contractors to work on projects in our city. Despite DCRA's own findings, the Board of Industrial Trade did not take action and dismissed our complaint without giving us the required written notice, which denied us and the affected workers to know why the case was dismissed or a chance to appeal. On December 16th, we filed a writ of mandamus asking for CHAPRA and Voucher to explain their reasons for this dismissal. And on January 25th, we received a response from them claiming they had no obligation to explain their rationale for dropping the case, and that, quote, Jobs with Justice has no right, let alone a clear and indisputable right, to an explanation of the reasons underlying the board's decision not to institute disciplinary action and to instead dismiss its complaint against Power Design. This seems contradictory to DCRA's previous findings that Jobs with Justice's allegations were true, considering the board only agreed to accept and investigate the complaint because they believe that the, quote, complaint, if proven, would constitute sufficient grounds for disciplinary action. Yet the board has refused to take this disciplinary action or provide a legitimate justification for the complaint's dismissal. Meanwhile, in December of 2021, DC DOES also gave Power Design an Apprenticeship Award of the Year, and they continue to work on many high-profile construction projects, including Upton Place, George Washington Dorms, and Georgetown Student Housing. We understand that DCRA works to fulfill their mission to protect the health, safety, economic interests, and quality of life of residents. This is why it is incredibly concerning not only that this case was closed with no notice, but that the agency and our mayor do not seem to believe that DC residents and workers deserve to know why this was dismissed. We have heard that the case was transferred to the Consumer Protection Unit, but a 2021 FOIA does not seem to contain anything to support that claim. We hope that Mayor Bowser and the DCRA will reconfirm their commitments to transparency and protecting resident safety by increasing active oversight of licensing violations, acting on open cases, and penalizing known violators. Thank you.
Thank you, Ms. Fiedler. Amy Fisher. Ms. Fisher, you're up. At the moment, you appear to be unmutable. Ms. Fisher, you are muted if you're speaking. I can't see you either.
You had a question for me,
No,
Councilman?
I recognize Amy Fisher, who's
Oh, I'm sorry. I'm sorry.
appears to be present, but her video and microphone are both off. I'm going to keep moving.
I'm here. I'm here. I have no idea how to become video more. I don't know how to become
Usually,
seeable. Can you hear me?
I can hear you. There's an icon at the bottom that says to stop video or start video.
Okay, hold on. I'm not finding that. Sound on live on YouTube. I'm sorry. Oh, wait. I see it. No. It's here, but I can't get to it. It's under the more button. I'm so sorry.
Well, why
Can
don't
I just, yeah, there we go. There we go. I'm so sorry.
Yes, I can see and hear you now.
I'm a realtor, but I'm here on my own behalf. Shall I begin?
Yes, please.
Thank you. Your construction bill is good, but if you really want to improve the experience for your constituents, you need to start earlier in the construction process by reforming the DCRA neighbor notification. It's a black box, egregious, and very possibly illegal. Neighbor notice forms are delivered once a developer submits plans. The notice describes why access is requested, provides a link to reams of complicated architectural drawings like this, and to 837 pages of building code. The neighbor has 30 days to digest the plans and code and produce technical objections. No additional customer-friendly information is provided, such as what are our rights, what happens after objections are submitted, what constitutes a technical objection, or what's the role of DCRA. We've submitted objections no fewer than 6 times. Our original developer dodged and obfuscated his intention to overdig our property to maximize his footage. We've hired an architect and an attorney and paid thousands to protect our property. DCRA has remained silent. Our architect, who specializes in technical and code compliance, sums up our situation this way. If you don't hire someone who knows the process, you get jerked around by developers whose focus is to keep the neighbor quiet and get the project approved with minimum information. The process is meaningless unless DCRA requires a developer respond to objections with documents that get incorporated into the permit set, and that the inspector understands the documents and relies on them to confirm compliance during inspections, and that the inspector actually holds the developer accountable. This developer is ignoring your concerns. There's no way to know if DCRA cares about your objections, as Mr. Patel, who handled this file, retired and has no replacement. We're told DCRA is not supposed to issue building permits until our objections have been resolved, but can we trust this? When a second developer purchased the property along with the plans and a raise permit, they were allowed to demolish the structure. Never mind, the raise permit was still in the name of the original developer, or that pre-demolition documents and public notices went unposted and undelivered. The inspector's attitude? Oh well. Delegating the responsibility of providing technical objections is legally questionable. In the 1982 Supreme Court decision Larkin versus Grendel-Stan, the court struck down a Boston ordinance saying that the city could not delegate to private entities powers vested in government agencies. I've watched over 50 years as the council has become more attuned to your constituents. Thank you. We need you to step up here and expand your construction bill to address the neighbor notice and how it's practiced. My written testimony includes suggestions for how it might be improved, and I'd be happy to participate. Thank you for your time.
Thank you, Ms. Fisher. Do you live on Shepherd Street? Because I have a document here that doesn't have a name on it.
No, I'm on 13th Northeast.
Okay, then I don't have a copy of your statement.
You should have been sent in by Mr. Lukadakis, but I can forward it if you tell me where to.
Would you please resubmit it? Just a moment. I'll send it to COW.
Oh, bear with me. COW.
At dccouncil.us. COW Committee of the Whole.
I'm sorry, .us.
That's it.
Committee of the Whole.
COW at dccouncil.us.
That's it?
Correct.
Good, will do. Thank you.
Thank you very much. Danita Coleman?
Yes, can you hear me?
Yes.
Good afternoon, Chairman Mendelson, members of the council. Thank you for taking the time to address the public concerns regarding DCRA. My family and I have lived at 416 Shepherd Street Northwest. We have lived at this home for more than 40 plus years. The construction began next door at 414 Shepherd Street Northwest in 2015 and remains incomplete to this day. For 7 years, my family has had to deal with the shenanigans between DCRA and the developer of the 414 property. DCRA initially began issuing permits to the former owner of this property who had passed prior to the sale of the property. The developer would perform work not in the permit and then apply for a new permit or new permits showing that work as existing. There were numerous stop orders, 911 calls, and piecemeal building permit applications, total of 15, meant to avoid review and the associated stricter requirements. For example, they did not provide a fire-rated wall at our property line, and they had to change the wall from wood to concrete blocks. This condition was discovered by DC FEMS. Earlier in the construction, the contractor left gas generators operating within the property that leaked fumes into our home. The work has damaged our home, and damage continues due to where they have excavated the rear of the property. DCRA advised us that recent changes in the code took away their ability to enforce storm water violations. In our case, the developer raised the ground level at the rear of the property. Soil from that excavation of the basement performed to increase the ceiling height was not taken away. Instead, the debris from the excavation was put in the back of which is the rear of the property yard, and spread it out, raising the height of their yard to a much higher than ours, to a height much higher than ours. This has caused a lot of runoff onto our property and into our basement, as well as 412 Shepherd Street property. DCRA continues to alternate missions to service developers, meanwhile ignoring the safety of its citizens. This project remains incomplete and non-compliant as of today. DCRA has done little to protect my property, and I can't imagine the issues facing those potential new buyers of 414 Shepherd. That is, if they ever get it finished. I have included the permits history for your review. I thank you for allowing me to testify, and in closing, I've counted 22 permits which I've submitted. 19 of those permits have no record of inspection. Thank you for affording me this time. That concludes my testimony.
Thank you, Ms. Coleman. Felicia Dantzler.
Hi, good afternoon. Can you hear me?
Yes.
Great, thank you. My name is Felicia Dantzler. I'm president of ASME Local 2743. I represent over 95 members at DCRA. The work my members perform are intakers to new and renewal of applicants interested in conducting business in the District of Columbia, such as wanting to become an SPO, barber, mortician, real estate agent, etc. For the last year, my members have been overworked, underpaid, worked outside their job description, and retaliated against for exercising their union rights. The agency used the cover of COVID to justify these acts. Morale is low, members are too afraid to exercise their rights, and managers have harassed my members. I have members who have been diagnosed with depression and anxiety, all stemming from working at DCRA. My members have described the work environment as a plantation and a modern-day sweatshop. The agency does not have enough employees to manage the work, nor do employees have the equipment necessary to deliver high-quality service to the applicants. Labor learned that over the past year, 15 employees from the Occupational Professional Licensing Administration, also known as OPLA, either quit or were reassigned. In May 2021, Labor learned that the proprietary software company PSI used to process special police officer and security officer licenses removed their software and equipment sometime in March 2021. This system was installed at SMOB. This software and equipment tracked every SBO license to carry a gun in DC. The software allowed applicants to complete their initial application and renewal application online. The software also allowed applicants to upload photo identification, arrest records, birth certificates, etc. Currently, my members at SMOB and OPLA are using spreadsheets to track the applicants. The agency is relying on the applicants to be honest on clean hands. Applicants who owe monies to the District of Columbia, those dollars are not being recovered. As Labor understands, in 2021, the agency's IT department crafted a Band-Aid process that allows the applicant to only apply for a license and pay for said license. The new process does not allow an applicant to upload supporting documentation. The new process is so flawed that it counts each application as a new application. For instance, if the applicant is filling out an application, becomes distracted by answering a phone call, the applicant cannot return to that application and pick up where they left off. So the new system is counting the applications each time. This is important because my members are completing these applications by hand. The members must go into the general email box, conduct a name search, and review each application submitted by the applicants because they are searching for a completed application. The member then must search that inbox for any supporting documentation. All of this has led up to the agency's general inbox to have over 5,000 emails that have gone unanswered. This system is also flawed because it has the applicant being overcharged several times over. There was one applicant who had paid approximately $1,000 and had to dispute his charges on his credit card. This is not an isolated case. Many of the applicants requested refunds in excess of over $2 million. And upon information and belief, Labor Law Agency's Deputy Director, Shirley Kwan Hugh, had to write a memo to the city's Chief Financial Officer explaining the refunds. Last month, Labor learned that the supervisor in charge of SOMB was separated from employment because of the emails. This is a classic example of the head of an organization failing to take responsibility of his role in this colossal failure. The classic cliche, crap rolls downhill. Surely the director will come before you with a made-up true reason why the supervisor was let go. The supervisor was the glue that kept my members as sane as they could be. Prior to COVID, the agency had 17 call takers to address increasing calls since the system was removed from the agency. The call takers need not know how to help the end users. The exercise is merely for the agency to say to this committee that the agency took in a certain amount of calls. I can state with certainty that I have called the agency and was told by the recorded voice that I had a 122-minute wait, or better yet, I was the 40th caller with 39 callers ahead of me. This council allotted $2.2 million for the agency to hire a division to enforce short-term rentals. The agency hired one employee, Cheryl Newman, and upon information and belief, Ms. Newman never acquired a staff. Labor Review Agency's public salary information for years 2020, 2021, and 2022. And to this current date, Ms. Newman's name is not on the public roster. Labor also learned that the applications for short-term rentals are being processed by other existing OPLA licensing divisions, a division that is already understaffed and overworked. In closing, I'm just going to say the agency needs to hire more foot soldiers to do the work, spend the money to get the proper application processing systems, have employees perform the work at the table to provide guidance and insight to obtain proper working system, provide my members with additional pay for their outstanding work, and have a leader in place that will ensure that the human capital is priority. Thank you for allowing me to present, and I'm open for any questions, comments, and concerns.
Thank you, Ms. Dantzler. Tappan Parker.
Hi there. Thank you for the opportunity to testify today. My name is Tappan Parker. I serve as the chapter chair of the Climate Reality Project's DC chapter, which represents about 350 local constituents. I know we've heard a lot of testimony today that is focused on current housing crises and other major issues we're facing. Mine today is a little more future facing. My testimony today is focused specifically on DC's current building code, which DCRA designs and implements and are in the process of being updated for the 2023 building code cycle. These current codes do not address the urgent need we have right now to update our city's standards when it comes to refrigeration management to permit more climate-friendly refrigerants to be used. This is more of an urgent crisis because the EPA has mandated national phase down of the most commonly used and environmentally detrimental refrigerants through the reduction of the supply of these refrigerants available for purchase. Essentially what this means is that over the next 10 years, the current refrigerants being used in the district are going to be very, very limited in supply. Unfortunately, the district's building code currently and the proposed updates we currently have do not allow for the refrigerant alternatives that the EPA is recommending. And once these codes are finalized, it's going to be another 5 years before code changes can be revisited. This means we're going to miss a critical opportunity to allow for the integration of climate-friendly refrigerants, something that has to take place over the next 10 years, which will both negatively impact the district's ambitious 2032 climate goals and DC businesses and residents who will be forced to pay more for traditional refrigerants over the coming years as national supply dwindles. So this is both a crisis for our climate goals as well as for our residents who will face the economic impacts of this reduction. To provide a little bit of additional context, refrigerants I'm referring to are hydrofluorocarbons or HFCs, commonly used in air conditioning and refrigeration. They're extremely potent greenhouse gases, thousands of times more harmful than carbon dioxide, which the US has now mandated a national phase down of by 2034. This phase down will work to restrict the supply of HFCs available for purchase, encouraging businesses to replace their current refrigerants with other EPA-approved non-HFC refrigerants that are less potent greenhouse gases. Under current DC building codes, many of these EPA-approved refrigerants classified by the American Society of Heating, Refrigeration, and Air Conditioning Engineers as A2L refrigerants are not permitted for use in buildings. Unfortunately, many states maintain antiquated HVAC building codes, making the integration of climate-friendly refrigerants like A2L much more difficult. But states across the US are updating these codes, and DC should be among them. A request has already been made, submitted by the Sierra Club, the Natural Resources Defense Council, and the Air Conditioning, Heating, and Refrigeration Institute on March 21st of 2021 to update DC's building codes to allow for A2L refrigerants. We'd like to add our voice as Climate Reality Project DC to this request, urging DCRA to update DC's building codes to reflect the brighter, more resilient, and more sustainable future ahead of us. Thank you again for the opportunity to testify today.
Thank you, Mr. Parker. And could you please submit a copy of your statement?
Yes, a copy has been submitted already.
All right, well, I don't have it, so maybe you can resubmit it.
I will resubmit. Thank you.
Kate Talmore. Is Kate Talmore here? I have no, I'm told you're on the phone rather than a video. You have to press *6 to unmute. Kate Talmore? Actually, I see you, or I see your box. I'm going to move to the next person. If Kate Talmore can turn on her video, I'll recognize her after Mr. Lapras. Blair Lapras.
Thank you, Phil. My name is Blair Lapras. I purchased new construction back in 2018 here in Ward 1. And not long after moving into the place, I began to realize that there were serious problems with the property. And so at that point, we hired a third-party inspector to deliver a forensic report on the property and its history. Now, that's when my worst fears came to light. We realized that actually the property had multiple code violations, many of which were serious structural defects, such as lack of underpinning, improper brace wall lines for the house, which caused the upper levels to sway, and framing that's literally floating above the footing of the house. Now, estimates suggest that the cost of the repairs for the property would be somewhere in excess of $700,000, more than we paid for the house, right? Each of these things that were mentioned in this inspection report were inspected by a DCRA inspector. The DCRA inspector passed each and every one of them. Now, I'm not a construction expert, but the things that were shown in the report were obvious to me once I saw them. For instance, the framing that's floating above the footing, it's incomprehensible how this could actually structurally support the house if it's not attached to the footing of the house. That's not the way gravity works, right? So it was beyond belief to me that a DCRA inspector would have not picked up on these code violations in a site visit. More surprising is the fact that the developer had hired a general contractor that was unlicensed by DCRA. But at the same time, DCRA had not only passed each and every one of their individual inspections, but they had issued a certificate of occupancy to the property as well. So I'd like someone in DCRA to explain to me exactly how this agency could have failed to do this basic check on licensure throughout multiple rounds of inspection. From my view, there's only two possibilities. One is extreme incompetence, and two is blatant corruption. Maybe it's both. Since then, the contractor has claimed bankruptcy, but continues to operate in the city under a different name on different properties. And similarly, the developer have other properties as well, many of which we have heard have similar levels of code violations. Future home buyers are being actively defrauded right now, and DCRA is doing nothing to stop it. The fact of the matter is that DCRA, and specifically Mr. Chopra, have been tone deaf to the suffering of DC residents. I watched the last DCRA performance hearing, and I have read Mr. Chopra's testimony that he submitted last night, where he paints a rosy picture of the agency's performance. I read how he was proud to report that 40,000 of the 50,000 customers had given them a positive rating. That 86% approval rating is impressive until you realize who their customers are. The people submitting building permits and asking for inspections are mostly developers and general contractors. It's not residents such as myself. I have never been surveyed. So what this KPI is telling me is that 86% of the time, DCRA is in bed with contractors. 86% of the time, it fails to deliver quality outcomes that protect the life and safety of DC residents. Now, I don't see anywhere in DCRA's KPI framework any indicators for outcomes that measure quality of the services they deliver. Take, for instance, number of properties that passed DCRA inspection, which were later given a correction order, like my house, right? Or how about the dollar value in a homeowner losses resulting in DCRA inspections, which failed to uphold the building codes? This is a meaningful indicator. While I know you haven't been tracking these failures, let me put this into perspective for you. If you conservatively assume that just 5% of new properties built every year have similar levels of code violations to mine, and you multiply this by the damages that we are facing for our property, the total losses to DC residents could exceed $175 million per year. Now, I'm sure Mr. Chopra would love to brush this off, but it's hard to understand how he can be so dismissive of these huge economic costs that he is causing DC residents each year. However, I don't want to put this failure of governance solely on DCRA's head. DCHD is similarly dysfunctional, and the bonds put down are barely enough to cover legal fees, let alone repairs. And I was shocked to learn that the bond amount is actually calculated on 10% of the estimated construction cost of the property, where the construction cost is assessed by the developers themselves. This is an obvious conflict of interest. I was further disappointed to hear that a recent proposal to raise the bond to 20% was not acted on by the council. And I'd like to explain I'd like to ask the council members, especially you, Phil, what the council's position on this and why it hasn't reform hasn't proceeded. Every day, I am forced to live in fear that my house will collapse on me because basic structural elements of the house were never put in place. It's infuriating to know that in DCRA, the council and the mayor's office, there is no action that's being taken to do anything about it. And so I want to know from both Mr. Chopra and from the council how you plan to compensate victims like myself for the terrible failures of government which you have been responsible for. And then if you can't see, this is my basement, which was flooded. Has been flooding for the past 3 years.
Does that conclude your testimony?
I'm sorry?
Does that conclude your testimony?
Yes.
All right. Thank you. I will have a question for you. Darinka Kamlojanovic.
Hi there, can you hear me?
Yeah, and you will be followed by Eric Moreno. I'm just saying that so that we can move a little quicker here. Please proceed.
Okay, will do. Good afternoon, Chairman Mendelson and Council. Thank you so much for the opportunity to speak. My name is Darinka Kamjanovic. I'm here to tell you that I live in a death trap. And by death trap, I mean a newly constructed condo located at Georgia Avenue in Ward 4. In less than 2 short years since purchasing this newly built condo, I stand before you to tell you that at times I truly fear for my life. And why is that? The Georgia Avenue condo building I live in was constructed so poorly that the DCRA recently categorized it as a high-risk building, claiming it as one of only 3 high-risk buildings found among a review of 70 properties in DC. What makes this building unsafe? Given the time limit, I will only focus on 2 things. One, the building is structurally unsound, meaning it truly moves in the wind. At 60 feet in height, the building has no lateral support, meaning it is entirely a stick build made of wood without any steel frames, any shear walls to keep it from moving, and it does move. If winds exceed as little as 20 miles per hour, living in this building at times feels like experiencing an earthquake. That is 1. And 2, this building lacks any fire rating. As a type 3A building per code, the building requires essential fire rating on structural elements such as the stairs and walls. Unfortunately, based on professional opinions, none of these fire protections exist. I wish this was all, but there are many more things here. If I had more time, I would tell you about the non-functioning sprinkler system, the hazardous wiring, and what PEPCO has essentially confirmed as red tagged meters, illegal electrical meters. We did a thorough inspection of the building just after a year of living here and found over 60 code violations, of which a handful are seriously a life safety risk. So how did this happen and who is at fault? Yes, the developer here carries some blame, no doubt, but DC is a booming market. Whenever there's high demand, there is going to be bad actors that try to profit off of the people. It is the job of the government and job of the governmental agencies such as DCRA to step in and prevent these actors from defrauding and taking advantage of the citizens. And yes, we were defrauded by our developer, but the DCRA failed to prevent it from happening and issued a certificate of occupancy for a building that should have never been granted one. And how was this possible? First, we learned that this building was substantially complete prior to any building permits being issued. So the first time a DCRA inspector even set foot on this property, there was nothing to review because walls, structures, foundations were already covered and closed up. And it is therefore no wonder that we were unable to find 6 critical inspections, including footing, foundation, slab, among others, just non-existent. There is more though. The engineer on record, we've learned that he has failed his licensure exam 7 times and was only able to gain his engineering license through eminence clause. This individual completely failed to include a basic lateral support frame in our drawing, in the drawing for the building, something that is indisputably required for a 60-foot build. We were later told that this gross error was never caught by DCRA because it was never even reviewed by DCRA due to a policy that at the time allowed engineers of good standing to functionally bypass any reviews and inspections. In summary, this building falsely passed all procedural safeguards because the DCRA failed to do its jobs and perhaps even facilitated the approval of unsafe buildings. Today, we are still trying to understand exactly how the approval process allowed for a building such as this to be built, but the DCRA has failed to deliver on our FOIA requests that we submitted over 6 months ago. I'm here today to tell you my story so that we can hold DCRA more accountable for putting DC residents in such danger.
Thank you. How do you pronounce your last name?
Komnjenovich.
Komnjenovich. I'll try that. Thank you.
Thank you.
Eric Moreno. Sarah Bagg.
Hi, can you hear me?
Yes.
Okay. Hi, my name is Sarah Baget, and I'm a resident of Ward 4 and president of my condo board association. And my testimony is unfortunately going to be very similar to the testimony you've just heard from the previous two witnesses. I'd like to share my experience as a first-time homebuyer in the district and the ways DCRA's failure to enforce building codes has harmed me and my neighbors. I closed on a condo in a 6-unit newly renovated building in Brightwood Park in September of 2019. I, along with several others in my building, were able to purchase with the help of district programs for first-time home buyers like EHAP and HPAP. We soon began experiencing issues with our building that the developer refused to address. To understand the scope of the problem, we have consulted a home inspector, several contractors, a master code professional, a structural engineer, and a licensed architect, all of whom have found extensive code violation. At the request of the inspection company we hired, DCRA came out to do their own oversight inspection on May 2nd of 2021. They found 23 building code violations, 4 energy conservation code violations, 4 fuel gas code violations, 4 electrical code violations, 4 plumbing code violations, 4 fire code violation, 1 mechanical code violation, and 3 other violations. That's a total of 47 violations. These include failure to complete dwelling unit separation walls, failure to provide fire partitions as required, and failure to properly seal penetrations. For those of you who, like me, are not building code experts, this means that the walls built between our units are not adequate to stop a fire from spreading. These are not the kind of issues that a standard home inspection during purchasing is supposed to find. Issues like this are supposed to be found and addressed in the building inspection process. So why were these problems not identified and fixed before our units were sold to us? DCRA's third-party inspection and plan review program allows developers to hire third-party agencies approved and overseen by DCRA to review building plans and do code inspections during construction. This means that the people with a financial interest in the project are paying for their own construction oversight. DCRA is supposed to oversee these third-party agencies, but as our experience demonstrates, their oversight is completely inadequate. As DCRA's own inspection of our building notes, their third-party inspectors failed to find dozens of violations, including several life safety violations. DCRA issued us, the homebuyers, with a notice to correct these violations that their approved inspector had missed. I've included the DCRA report and the order to correct along with my written testimony. A structural engineer estimated the cost of addressing these code violations to be at least several $100,000. Our only recourse as homebuyers is to take legal action against the developer who sold us our units. This has already taken hundreds of hours and cost us thousands of dollars on top of the thousands we've had to spend on repairs to our building. We have no guarantee that the harm we experienced will be addressed. And given how difficult this experience has been for us, it's likely that developers in the district often cut corners, knowing that DCRA will not stop them and that holding them accountable will be too exhausting and expensive for most home buyers. I ask the council to consider eliminating the third-party inspection program, as it is clear that contracting out building code enforcement jeopardizes the safety and well-being of district residents. I also ask the council to consider how it can support those of us who've been left with unsafe homes as a result of DCRA negligence. I am happy to answer any questions. That concludes my testimony.
Thank you, Ms. It's Baget.
Yes, that's correct.
Thank you for your testimony. Desiree Tillinghast. I had called earlier Kate Timor. Is she able to speak and be seen? I can see you, but I can't. Oh, there you are. You just unmuted.
Are you able to hear me now?
Yes.
Oh, I apologize. I've been having technical difficulties. Sorry for missing earlier. I'm Kate Talmore. Unfortunately, my story is very similar to that of the last few residents. My husband and I purchased a townhome, a row house in Northeast DC in March of 2020 that had just been fully renovated and looked brand new inside. The night that we moved in, our kitchen was flooded when my husband tried to take a shower upstairs. There was a pipe that was disconnected going to the shower, and all of the water came through the ductwork and flooded the kitchen. That was a major thing that had to be repaired through cutting into the wall and replacing the pipe. We were hoping that that was a one-time oversight, although we were very confused as to how that had passed any of the inspections that should have happened. Several months later, we began having significantly more issues. We began having our ceiling in our master bathroom collapsed and fell in. All of the fixtures in our house began to crack and separate. The windows separating from the walls, literally pulling out of the window jambs, floors pulling apart, tile cracking, and cracking throughout the walls that did not seem like the normal settling of an older home. We hired an inspector to come in. She found a very large number of code violations, found that most of the work that was done in our home exceeded the scope of the permit, so it was work done without a proper permitting. And also that in particular, the most visible of the problems we were having were caused by the fact that the home didn't have a proper thermal envelope. So it had not been adequately insulated, or in most instances hadn't been insulated at all when a new HVAC system was installed. And so I had thought that insulation was something just for comfort and energy efficiency. I now know that it causes significantly more problems than that. The surfaces in our home were literally cracking and peeling apart because we had forced heated air coming into the home with no insulation. We have had to live here while trying to fix these problems. The back of our home had to be completely demolished and rebuilt in order to insulate it. We've had to get insulation put into our attic, all the windows pulled out and re-insulated, and had to have this work done. I think we're fortunate that we've been able to have this work done and a lot of corrective action, but these are huge problems that have required us to, as I said, completely demolish the back of our house and rebuild it. And this could have been caught, but we had the same instance. We have learned that it was a third-party inspector paid by the developer that came in and signed off on the work without noting any of the problems before the walls were sealed up, so our home inspector couldn't catch it. So this has been tens of thousands of dollars worth of work that had to be done while we're living in the home because it wasn't properly inspected before it was sold. I'm happy to answer any questions. That's my testimony.
Thank you, Ms. Talmore. I don't have a copy of your statement. Can you provide that?
I certainly can.
Thank you.
Thank you.
It's helpful to get the written version of these statements because we do refer to them and some of our oversight work with DCRA. That completes the testimony from the first 15 witnesses. I did want to cover a couple of things. The first few witnesses, it seems like a very long time ago, talked about housing inspections, and the last half dozen witnesses have talked about problems with construction and adequate enforcement of code compliance. I don't really have questions on the either the housing code inspections or on the illegal construction, because I have found that DCRA somehow just doesn't connect sense of mission with its work. But I will be asking the director about some of this. But I did want to, several witnesses commented about how the performance indicators, the KPIs, are not adequate, and I do want some more input. We have a hearing coming up on budget, which will be on March 24th in the afternoon, probably. And that hearing will be not just on DCRA, but also on the new Department of Buildings. So we will at that time have before us what the mayor's proposing for a budget. And I think that the testimony could be very helpful in terms of how we ensure that the new Department of Buildings has adequate resources. I'm hopeful that the mayor will adequately fund it, but I think input from witnesses here today, if you're willing to come back and you're able to comment on number of inspectors or what some of the KPIs should be, that could be helpful to us. I kind of said that to multiple witnesses because multiple witnesses talked about the problems with the KPIs, and I agree. the gentleman from the realtors commented on a flaw in the short-term rental regulations, the regulations that the department adopted. 3 council members, myself and council members McDuffie and Allen, sent a letter to the department. And I have to say, I'm very disappointed as well. We made the argument that the department's zoning interpretation is illogical and contrary to the intent of the law. The intent of the law never said that the primary owner can't live in the basement unit while renting out the upper units. And we pointed out that the law is quite clear that an individual can rent out multiple rooms on a short-term rental basis, a majority of the house on a short-term rental basis. That's not precluded by DCRA's regulations. It's clearly contemplated in the law, but somehow they make a distinction and say that an owner can't live in the basement. I don't know what the next step is there, but I did want to comment on that. I had a question for Danita Coleman. Are you here?
Yes, I'm here.
The property next to you at 414 has been vacant since
2015.
And currently it's listed as vacant with an exemption for construction. How long have they been doing construction on this house?
Since 2015.
Has anything new happened with regard to the construction? Because the construction exemption is only supposed to be good for, I think, 3 years.
Well, it depends on when you ask what year. We have one point there was underpinning that there was no permit for, so there was a stop work order issued there, sir. Then there was the construction of the rears of the house. I understand that we couldn't find a permit there. Stop work order issued again. I think for a year, the house said vacant, and we woke up one morning and we had workers in there banging out a wall and no permit there. One time they came through our wall, and I mean, it's just like my testimony, sir.
Well, so, what I'm trying to understand is whether there's something new and different about the construction that's occurring now. And I have to wonder, what are they doing for 7 years in terms of, is this like very slow, one person on the job at a time construction?
No, oh no. There are several workers that will show up and start working. And we would check to see if there's a work permit. There isn't. So we would call, and all of a sudden, a work permit would show up one day, and 2 days later, there would be an issue of a stop work order because a wall has collapsed. The rear of the wall has collapsed one evening while we were eating, and one time a window fell out. We called and reported that. So
forgive me for interrupting, but what's happening now?
Nothing.
There's no work going on right now?
No.
Okay. I'll ask the director.
Yeah, and for the record, sir, we have hired, much like everyone else, we have spent our retirement money to get an engineer and a surveyor to make sure that we're doing everything right, but nobody communicates to us. Yeah. Nobody tells us what's going on. People will show up. And I mean, this is why I think a lot of our homes are left like this, but I'm not running. I'm not running away. I'm not going to surrender my house to them. Thank you.
Thank you. Mr. Lapras?
Yes.
You referred to legislation to raise the bond to 20%.
Correct, yes.
Say more about that because I don't recall.
I believe it was a proposal. Maybe it never got off the ground. I believe that Ria Nadal had proposed raising the bond from 10% to 20%. That would fix part of the problem. It wouldn't fix everything, especially because I believe the bond is calculated on on the estimated cost of construction, where the developer will estimate that cost. So the percent is almost irrelevant if they can lie about the cost, right? But this is something that immediately needs to be changed, right? The amount of the bond cannot be determined by something that's an inherent conflict of interest if it's determined by the person that has to put down the money for the bond. So the bond amount needs to be raised, and then the value that is based off of needs to be based off the sale price of the house, not off of some estimate which comes out of the blue, right? That's just riddled with conflicts of interest. That, of course, is only going to have an effect on whoever buys a house from the point you change the law onwards. It's not going to affect all these victims that have spoken to you here today, who, as Danita said, are out of their retirement money, out of their life savings. I've saved up for 10 years to buy this house, and now it's not worth the land that it's built on, because it's going to have to be demolished, right? So it would be more valuable as a vacant lot than it is right now. And so I'd like to hear from you how the council will allocate funding to compensate the victims of DCRA and the government's lack of action and oversight in providing basic public services.
Well, ordinarily at hearings, I don't answer questions, but there's not an easy answer here. The department is supposed to regulate construction and make sure the construction is done in accordance with the code. The district doesn't have a fund to compensate property owners for bad actors, and that's what's so angering about these situations that so many of you have testified to, because you all are all harmed. You're harmed by other property owners, and the government could have more to prevent that. And let me be clear, I'm not saying that the government's liable. And in fact, these kinds of issues, the government, anywhere you look across the country, the government's not liable. But DCRA is here, part of their name is what? Consumer Department of Regulatory Affairs. It's to protect consumers, and that's not happening. So I will be talking to the director about it. This is a problem we've been grappling with for several years, and it's why we decided, when I said the committee and then the full council, to break up the agency. We've pounded the table. We're now on the second director. We've thrown cases at them. We've had the DC auditor look at what's going on. There've been plenty of news stories, some generated by us, some generated by unfortunate incidents in the community. And I would dare say none of you are saying that you've seen improvement at the agency. And so we're breaking it up beginning October 1st. And but this testimony is very, very helpful. I had a question, I think.
One last thing, you will have to completely overhaul the entire KPI framework that DCRA has, because it's focused entirely on inputs. So, cost, that's wasting DC taxpayer money, and no outcomes that will actually achieve the core mandates of the. I
understand, and I spoke to that earlier. I invite suggestions on KPIs, and some of you today have already suggested some. I had one question for Ms. Komjanovich, and that is, I participated in a Zoom conference with DCRA and some property owners with a building on Georgia Avenue, and I'm wondering if it's the building that you're in, that apparently sways in the wind.
Yep, this is it.
Yeah. Okay, thank you. I'll see if my colleague is here. I don't think she is. Thank you, each of you, for your testimony. I wish I could wave a wand and say problems are fixed. And I think it's really unfortunate what you're going through. And then additionally, to come here to vent your frustration. And I'm sure it's not satisfying, but it's helpful to us. And when I say satisfying, I'm not able to resolve these problems, but we are trying to make some changes, and your testimony is helpful in that regard. So again, thank you to each of you. You all are excused. I'm going to call the next 15 witnesses. Brian Reed, who's with the Sierra Club. Mommy Preston, who I know is a resident on 13th Street. John Guggenmos, who's an ANC commissioner with ANC 2F. Sabrina Rhodes, who's an ANC commissioner with, she testified earlier today, 5D. Swati Sachdeva, Sakdeva. Joshua Khan, who's with Tacoma Wellness Center. Yvette Alexander, who's a consultant with the DC Cannabis Trade Association. Mary Fitch, who's with the Washington chapter of the American Institute of Architects. Stephen Halbrook, Charles Coleman, Darlene Jackson, Max Broad, who is a chapter leader of Citizens Climate Lobby DC. Chris Otten, DC for Reasonable Development. Steve Amate, and Mike Fonz, who's general manager with Allied Universal. You all should be being let in.
All right, thank you, Chairman Mendelson. Can you hear me all right?
I can, but hold on just a moment, because there are only 2 witnesses here at the moment.
Okay.
And my staff is trying to let other witnesses in. Why don't you proceed, Mr. Reed?
Thank you. And thank you for the opportunity to testify at this performance oversight hearing. My name is Brian Reed, and I'm testifying on behalf of the Sierra Club's DC chapter. The Sierra Club is the nation's oldest, largest, and most influential environmental advocacy group, with chapters in all 50 states, Puerto Rico, and DC. The DC chapter has identified, sorry, my cats are a little crazy right now.
Those are cats making that noise?
Yeah, they're playing around in some bags.
You need to get smaller toys for them.
The DC chapter has identified an issue under the oversight of the DCRA, allowing climate-friendly refrigerants into the DC building code, which we outline in this testimony. Hydrofluorocarbon refrigerants are commonly used in air conditioning, heat pumps, and refrigeration. Hydrofluorocarbon refrigerants pose a risk to the climate because they have global warming potentials that are often thousands of times more than carbon dioxide. Because of this, federal legislation, the American Innovation and Manufacturing Act of 2020, mandates a national phase down of the production and consumption of these refrigerants by reducing the amount of HFC refrigerant available for purchase over the next 14 years. Importantly, by 2024, the amount of hydrofluorocarbon refrigerant for sale will be reduced by 40% relative to the historical average of hydrofluorocarbon refrigerant production under EPA's regulation. Fortunately, safe alternative refrigerants now exist that are much less damaging to the climate and are categorized under the designation of A2L refrigerants. However, these EPA-approved A2L refrigerants are not permitted under DC's current building code because previous versions of industry safety standards did not allow for their use. Extensive research has been conducted and has shown that A2L refrigerants are safe when used and installed with proper safety equipment. Current industry safety standards now allow for A2L refrigerants to be used in buildings. Consequently, a number of states across the nation have recently updated their building codes to allow for these climate-friendly refrigerants. Additionally, the 2024 National Model Code has been updated to allow for the use of A2L refrigerants. On March 29th, 2021, the Sierra Club's DC chapter, along with the Natural Resources Defense Council and the Air Conditioning, Heating, and Refrigeration Institute, submitted a proposal requesting that DC's building code be updated to allow for the use of A2L refrigerants. The Sierra Club urges the DCRA to implement this change in the current 2021 code development cycle process. We believe it is critical to make the change in this current code's update and not wait until the next code update. If these climate-friendly A2L refrigerants are not allowed in are not allowed in the building codes, DC residents and businesses may have difficulty purchasing the HFC refrigerants as the supply shrinks, which could lead to higher installation and operational costs. DC has an opportunity to both protect the climate and reduce the financial and regulatory burden for its constituents by updating the building codes to allow for A2L refrigerants. And that concludes my testimony. Thank you.
Thank you, Mr. Reed. I don't have a copy of your statement. Would you submit it?
I did submit it, but I can resubmit it.
Hold on a moment. My staff is yelling at me.
Okay.
It's rough getting yelled at by your staff. Ms. Preston. And good afternoon.
Good afternoon, Mr. Chairman and members of the council. My name is Mommy Preston, and I'm an over 20 years resident of the district. I've testified several times about the unclear status outcome and deteriorating condition of the 3 vacant buildings surrounding my residence. The structural devastation that impacts my home is well documented and available to DCRA. The properties on 3600 block of 13th Street have continued to impose crime-related dangers, health compromising rat infestation since 2017, and we has not been resolved to date. The vacant buildings have also become a trash dumping ground for outsiders. What has DCRA done to address these nuisances and debilitating structures? What has DCRA done to hold these developers accountable for continued non-compliance, illegal construction, and life-threatening issues that DCRAs like myself are currently facing? I would like to see the developers face legal accountability for their action, DCRA residents to be protected from further predatory development, and the DCRA procedure to reflect this accountability. Thank you for allowing me to testify and for your continued commitment. This is my 4th or 5th testimony.
Thank you, Ms. Preston. And yes, I do know, I've seen the damage, and thank you. Commissioner Guggenmoos.
Thank you, Chairman Mendelson, Council Member George, other council members, and the committee staff. My name is John Guggenmoos, and I serve as the Commissioner of Logan Circle 2FO2, a 32-year resident of Logan Circle and 30-year business owner. I've had the privilege of holding several ABER licenses, and throughout the years, I've been a 30-year consumer of DCRA. As I got ready for today's hearing, I was booking our first vacation in a couple of years. I made arrangements. I wanted to book one of our favorite restaurants, and as I Googled the name, I couldn't stop but look at the Yelp review. Yelp platforms have earned loyal user base, and businesses can find themselves hurt by desperate reviews. And restaurants are a classic example in economics where the consumer has very little information, but decides and judges the reputation. But we are influenced by this. We are influenced by the few. I thought, what a parallel for today. Regardless of how many satisfied users of DCRA, DCRA will be judged by yet still a relatively few number, irrespective of the 1,000 positive interactions that do happen every day. Unfortunately, Even my constituents that have had a good relationship with DCRA are too busy to take time to be here today. I don't fault them. However, the post-COVID world, everything has to be fast, including government. It has to work well and has to be fast to resolve issues. It's just part of what they demand government today. So I will briefly share a few of their experiences of my own. First, I'm not brought in for my constituents because everything is going well. There's usually an issue. However, problems, some of them are easy to solve. Some problems are just helping the constituent find an old certificate of occupancy. Sorry, my mouth is really dry. On the DCRA e-docs, or how you can report illegal construction. It's never been so easy to find information available online. Old e-docs, current permits, stop work orders. They've come miles in being responsible to us. The residents, business owners who consume DCRA, they're much more transparent. Now, responsibility and accountability are different. And in this area, I do feel under Director Chopper, they have made solid progress. I've heard many times, if only the government were run like a business. And typically what follows is the old punchline about a government job and how the private sector would deliver better. However, we know that's not true. DCRA, from the staff from the top down, do act with a sense of urgency. And I was struck by what Councilmember George said today. There is a partnership in place. I reached out to Inez Sakite just a few days ago on February 8th at 3:30 p.m. And even though this issue is not really in her area of responsibility anymore, she took ownership of the issue. And by 4:15, 45 minutes later, the issue, which was a conditional certificate of occupancy for a condominium, had expired. Inez broke the complex issue down into identical parts. She connected us with the inspector, Liabil. Excuse me, I have to. So sorry. With 2 additional DCRA team members that could help us if needed. And Inez took the additional step. She called to make sure I understood everything. And I'd reviewed everything to make sure there wasn't anything else that was needed. The following day, Inspector Liabil had called, and before the end of the day, we were well on our way of making progress. As a background, there was a third-party inspector and a paid expediter that had been working on this issue for over 30 days with just the traditional excuses of, hey, we've really provided everything, and leaving a dozen first-time home buyers in limbo. But once Inspector Liabil and Inez had stepped in with other DC staff members, on the 9th, the conditional expired certificate of occupancy was addressed with the permanent certificate of occupancy. The work of these few DCRA staffers had a dramatic and positive impact on dozens of residents that were left in limbo where the third-party inspectors had failed. I also want to say that there are issues that aren't easy to resolve, but I don't find staff members just brushing them aside. Jenna and Jonathan are both working to resolve a different issue where we have a subcontractor doing work outside of what the approved plans are. And DCRA, Jenna is working with us to set up a meeting with the contractor, both residents, an architect, the inspector, to try to hopefully find a resolution. I know I'm way over, I'm so sorry. Just in closing, I really do feel that the director has embraced a mindset of embracing problems just as part of government. Thank you, and I'm so sorry I'm over.
Thank you, Commissioner. Commissioner Rhodes, Sabrina Rhodes.
Yes, I'm here. Hello again, Chairman Mendelson, committee and witnesses. I'm Commissioner Rhodes, and I represent 5D01 here in Ivy City. I'm also a community organizer with Empower DC, and I'm here to testify for the record. My constituents, including myself, have made several requests over time to have various properties inspected because of trash, infestations, lack of heat, the distribution of heaters by property owners, flooding, deplorable living conditions, mounds of trash, rats, and mold. I won't trash the entire agency. There are some folks that love what they do and will do everything they can to help, but it's evident that there are some that just don't care. As we have noticed, the fines given to property owners are slaps on the wrist and licenses taken away, but doesn't account for the resident quality of life being impacted. I understand that we've been in a pandemic for over 2 years with employees catching COVID. I also understand the district agencies have been short-staffed. This is going on all over the world. But what's not acceptable is for me as a commissioner to see the neglect of properties that have been notoriously an issue and complaints powered high only for the landlord property or property owner to continue with repeated offenses. This practice needs to change. DCRA, as you stated earlier, is supposed to protect district residents, visitors, and businesses. I'm not complaining in total because I have some success with contacting them for issues, but it's too many violations, old and new, and the first they get to blame is us, the ANC commissioners. Either way, in turn, we continue to serve. We all need to work together to make sure everyone is living in safe conditions, prioritizing businesses that respect the communities they're in, eating safe food and drinking safe water, checking with property owners and landlords, checking their business licenses that are expired, but they're still collecting the rent. Just today during this hearing, the same property that has issues with the landlord and an expired license, they contacted me because of no heat, no hot water, wood check cut off around 2 a.m. this morning, to have the property owner show up sometime after 10 a.m. and after 5 minutes he's gone without checking in on the residents, but would call me a liar or the residents that are lying. I've asked DCRA to check both of his properties for violations. They insisted on checking on just the one because of being short-staffed. There's continued miscommunication with property owners taking advantage of residents, DCRA not understanding what's being asked of them, and in the end, we have injuries, questionable living conditions, and possible death. How many people have to suffer because of district agencies spending time working on something that doesn't need to be fixed and neglecting what does? Thank you for allowing me to testify.
Thank you, Ms. Rhodes. I don't have a clear statement, if you could provide that.
Yeah, I sent it before I testified, but I'll be happy to send it again.
Yeah, I think I asked you that earlier with Office of Planning, and then it turned out I had it, but this one I'm pretty sure I don't have. So,
okay, I'll send it right now again.
The next witness, thank you. The next witness is Swati Sachdeva.
Good afternoon, council members and elected officials. Can you hear me?
Yes.
Thank you for your time and for allowing me this opportunity to express. For the next 3 minutes, I want you all to imagine what it would feel like to live in constant fear of your newly constructed home falling on you while you're asleep. Imagine how it would feel to live in a house that can burn down to ashes while you and your family are asleep. My name is Swati Sachdeva, and my husband and I live in one such home, a newly constructed condo building in Ward 4 that is plagued with life and safety violations that happened under DCRA's purview due to lack of oversight and failure to act in a manner that protects homeowners of DC. At the end of our testimony, we plead you to ask DCRA, who do we hold accountable for allowing this flawed building to be constructed without building proper inspection or approvals? The developers tell us that this building as built was approved by DCRA, and DCRA tells us the developer should have been more professional. Fact of the matter is, we, the first-time home buyers who have spent all their savings on a down payment, have been defrauded both by the developer and DCRA. We have heard many horror stories of developers doing shady construction practices, cutting corners in some developing countries. But we thought to ourselves, this can't happen in DC, the nation's capital, but at least not to this degree. Not only we were naive, but we were foolish to trust that DC has necessary checks and balances to protect its homeowners. Within months of moving into our building, we noticed glaring issues with our home and conducted a thorough inspection of the building only to find 69 code violations. The many life and safety violations happened right under DCRA's nose, and in some cases, perhaps even encouraged by DCRA's lack of oversight throughout this process. Take a moment to listen to some of these violations and ask yourself, how can this happen in DC? Who allowed it to happen and who should be responsible to fix it? The building was issued a permit after it was substantially built. The building moves and sways in high wind condition due to lack of lateral bracing. We had to evacuate several times in the middle of the night just to be safe, and we have had our share of multiple sleepless nights since last year. Exterior walls and slabs do not meet minimum fire rating requirements. There are no records of any inspection on footings, foundation, installation, plumbing, groundwork, and wall check. Yet DCRA has issued a certificate of occupancy. The building exceeds the height limit required under the current zoning. The building sprinkler system is not code compliant. Although few stop work orders were issued initially, but after the developer paid some $800 or so to DCRA, they did not care to follow up on it. Clearly an easy money-making mechanism for DCRA. I can go on, but perhaps the cherry on the top is that the DCRA building inspector who signed off on all the building permits has denied ever being inside this building. I want to conclude by pleading council members and DCRA to help our emotionally distressed family in resolving this mess. By not acting in its capacity, DCRA has enabled bad actors and bad developers to harm and endanger DC taxpayers like ourselves. If this house falls down or burns down due to the numerous life and safety violations, our blood will be on your hands. Thank you.
Thank you, Ms. Sachdeva. Is this the same property somebody else testified about at Georgia and Taylor?
Yes, it is.
Thank you. Joshua Khan? I'm told that he's not here. Yvette Alexander, former council member.
Good afternoon, Chairman Mendelson and Committee of the Whole members. I'm Yvette Alexander. I am the consultant for the DC Cannabis Trade Association. Since October, and the DC Cannabis Trade Association are all the licensed or members of licensed medical cannabis dispensaries and cultivation centers in the District of Columbia. Since October 2021, the medical cannabis program has been under the regulation of ABRA. And the association overall has been pleased with this move. However, we are still concerned with the steady decline of registered medical patients and the overwhelming increase of illegal cannabis businesses in our city. In 2014, Initiative 71 was approved to allow DC residents to grow and possess small amounts of cannabis for home use only. However, since 2015, DCRA has been issuing basic business licenses to a growing number of illegal brick and mortar establishments claiming to be small businesses that are selling miscellaneous products and gifting marijuana. This has proven to be a public health and safety threat. The illegal market is selling extracts that are untested, which contain toxic chemicals and contaminants. Also, the Metropolitan Police Department has conducted several raids when residents have reported suspicious activities, robberies, assaults on or in or near the locations of these illegal businesses. They have also uncovered illegal weapons, other illegal drugs, and large amounts of cash, etc. However, decisions are made not to prosecute, and these operations continue. There must be collaboration with DCRA and ABRA to shut down these illegal businesses. And the association would like to make some recommendations. And there are a few questions for DCRA. Before issuing a business license, is there a vetting process? Do business owners have to describe their operations? Is there a site visit before these business licenses are issued? Are there any annual sales records reviews from DCRA? Also, there should be inspectors solely assigned to businesses operating under the guise of I-71 to revoke their basic business licenses, because gifting cannabis with a basic business license is illegal. Only the products that you are selling are allowed. Civil fines should be imposed to business owners and landlords who violate the terms of this basic business license. It's important to note that we are not recommending criminal penalties, only civil infractions, and these business owners in the future would still be allowed to apply for recreational or medical cannabis businesses. But the current market, in closing, the current illegal market has grossed over $600 million in sales. And that could be a $36 million in tax revenue to the city annually. So that is the fiscal impact. And DCRA really needs to consider before they give these licenses, and there's a long list of illegal brick and mortar businesses that their license needs to be revoked. Thank you, Mr. Chair, and I'm happy to answer any questions you may have.
Thank you, Ms. Alexander. Mary Fitch.
Great. Thank you, Chairman Mendelson, for the opportunity to provide comments on behalf of the Board of Directors of the Washington chapter of the American Institute of Architects. The chapter represents more than 2,300 architects in Washington and is the 5th largest AIA chapter in the country. I'm pleased to have this opportunity to offer our perspective on DCRA's performance for district residents. Over the past several years, we've testified several times on the topic of streamlining the building permit process, a process that we believed was burdensome and was hampering the district's economic development and housing affordability efforts. In fact, we pointed out in our 2018 testimonies that studies have shown that making the development process less complicated will have an immediate positive impact on housing affordability. DCRA has made great strides on this issue since we first brought this to your attention in 2018. The agency has significantly improved its customer interface, whether through in-person or online communication. DCRA has adopted a listening-based posture and has worked diligently to understand customers' problems and arrive at solutions in a timely manner in conformance with their service level agreements and statutory requirements. If things aren't perfect, they are now clear and collegial. And while our 2018 relationship was kind of adversarial, today it's a partnership. And we are now consulted on new programs such as the contractors database and pre-approved plans. As the council moves to split the agency in two, we hope that we will be similarly consulted. DCRA's improvements are the most innovative in the region, and in fact, the agency's attention to matters, in our view, is so improved and professional that the council might want to consider it a model for other agencies that are not so customer focused. Thank you for the opportunity to testify on this important issue.
Thank you, Ms. Fitch. Stephen Halbrook. Saw Stephen Halbrook's name, yeah. Stephen Halbrook.
Yep, good afternoon, Mr. Chairman. I'm Stephen Halbrook. Wanted to share my story here with the group. In February of 2019, I also purchased a new construction condo in Ward 1. The property, like my neighbor explained today previously, was formerly a single family house that was converted to a 2-dwelling flat. The certificate of occupancy was issued to the developer, Pace, on October 2018. Before we go into the details for a moment, I'd like to paint you a picture, and this is important, not only because it speaks to the willingness of DC's residents to trust the government and authorities put in place to protect our rights, life, and safety, but because it humanizes this ordeal. It's easy to run numbers and total dollar figures, but there is a human element to not feeling safe in your own home. When I purchased this unit in the district, I entered into the transaction Knowing I had done my homework as a homeowner, I hired a realtor who advised me. I got an inspection. I got home insurance. I read the paperwork. In short, I took the approach of trust but verify. Because I am not an expert in construction and code, despite my best efforts, there were elements I had to trust other experts with. And that is the story I want to tell here. When I toured my home that first time, I trusted that things I was seeing, the upgraded appliances and floors and tiles and layout, were just indicative of the outstanding bones of this shiny new home. I trusted that this home was built by experts that knew how to lay a foundation, knew how to ensure the structural integrity of the unit, and knew how to ensure a multi-unit dwelling has the correct fire-rated assembly. I also trusted that if, for some reason, the experts who built my home did it incorrectly, that the system of checks and balances in place within the city through inspections would rectify and force corrections of those issues long before I entered the picture as a buyer. I, like the over 18,000 other home buyers in the district between 2019 and 2020, trusted our government to protect me by the system of inspectors and inspections put in place for exactly that purpose, to protect the health, safety, economic interests, and quality of life of residents, businesses, and visitors in the district by ensuring code compliance and regulating business. Those words are DCRA's mission statement. In the 36 months I've spent living in this house, 21 of them have been consumed with paying forensic experts to identify the 40+ code and life safety violations present within my home. Over the course of this time, my neighbor and I have spent upwards of $30,000 in legal and specialist fees, and we haven't even gone to litigation yet. We did our part. We did our part and then some. In good faith, we worked with the district. We worked with the builders. We filed paperwork. We documented issues. And we did this while we watched the Surfside condo building collapse in South Florida due to structural degradation in June of 21, followed by a collapse of a 5-story building under construction right here in Northwest DC in July of 21. As we watched the press circle around the issues at play with both sites, we sat in our home pondering how these massive life and safety issues could have gone overlooked by DCRA within our own walls. Right now, we feel like we are surrounded by a ceaseless barrage of evidence everywhere in our homes of a system that was put into place to protect us, but failed. We are inundated with repairs that need to happen from actions we didn't take, bills from experts we need to pay for problems that never should have existed in the first place. We fully understand there are ill-qualified and unscrupulous businessmen and women everywhere. That's just par for the course. We cannot accept, however, is that same lack of accountability applies to the government we elect into place to protect us from those ill-qualified and unscrupulous business persons. We expect better. We demand better. We await a follow-up in detail about what action is going to be taken for the countless failings by DCRA to send qualified inspectors to catch fundamental code, life, and safety violations, and most importantly, to successfully protect us from the very things they were established for and completely failed in. Thank you.
Thank you, Mr. Holbrook. Is this the same property that Mr. Lapras testified about? Mr. Holbrook, you're muted. You unmuted and muted. Can you try again? Mr. Holbrook?
Could you repeat the question? I apologize. I lost audio.
Is this the same property that Mr. Lapras testified about?
It is. We are the two owners of the same unit, of the same house. It's a 2-unit building, yes.
Sure. And I don't have a copy of your statement if you could submit it.
I'd be glad to. Thank you.
Thank you. Mr. Charles Coleman, please. No. I'm told he's not here. Darlene Jackson. Is Darlene Jackson here? I'm waiting for her to join us. Darlene Jackson.
Hello, can you hear me now?
I can hear you now, yes.
Okay, wonderful. Good afternoon, Councilman, Chairman Mendelson, and members of the council. Unfortunately, I was here 2 years ago testifying about the same issue that's very similar to many of my other DC residents. As a brief recap, a DC contractor renovated my home in 2019 and ripped me off for $128,000. With the aid of a DCRA building inspector who failed to identify any of the violations, but instead signed off on all of the contractor's faulty work. It was subsequently discovered by several third-party inspectors that my home had multiple code safety violations. As a result, all of the faulty work had to be demolished and redone in order for my home to be made safe, brought up to code, and made habitable for myself and my elderly mother. In addition to being out of $128,000, plus the additional $170,000 required to redo my home, my mother and I were forced to live elsewhere at great expense and rent and storage costs for our belongings for an additional 9 months as a result of the actions of this contractor and DCRA inspector. I am here today because after 2 long years, DCRA has continued to fail me by not holding the contractor or the inspector accountable for this negligence. The DC contractor was issued a notice of infraction back in 2020, but to my knowledge, nothing further has occurred. I understand that no hearing has taken place on these infractions to this day. Since the infractions were issued, I have been petitioning DCRA to find out when this contractor disciplinary hearing will be held, and DCRA continues to give me the runaround. I have been repeatedly told that the information regarding this contractor's NOI is not public and that I need to submit FOIA requests, which I have, only to be given information that is incomplete or does not contain the answers to my actual request. Is this correct? Are the disciplinary hearings of DC government licensed contractors not open to the public? Is this information not public record, and why am I not able to obtain this information via FOIA request? Furthermore, why does it take 2 years for a hearing to be held? And why am I not privy to a status update or allowed to be in a hearing about a complaint that I filed concerning my property? To my current knowledge, neither the contractor nor the DCRA government employee whom approved all of the work on my home by signing off on an official government document have not been held accountable. And DCRA has done very minimal to assist me in this whole matter. My elderly mother and I are the only ones who have suffered by this incident by still being out of the initial $128K, plus other expenses, the major costs that I incurred to redo the project, legal fees, continued mental anguish, and large amounts of stress. Through the inspection process, DC homeowners rely on DCRA to protect them against predatory contractors by ensuring that their licensed contractors are pulling proper permits and performing work that is up to code. DCRA failed me 2 years ago, and they are continuing to fail me now. When I was here in 2020, Director Sharper stated that this should have never happened to me and that he would look into the matter. Director Sharper, please stick to your word and assist to finally make this continuous nightmare whole. Thank you.
Thank you, Ms. Jackson. Max Broad.
Yes, hello. Hello, Max Broad here from the DC chapter of Citizens Climate Lobby. Hi, Chairman Mendelson and committee of the whole staff. I know you've had a really long day, and I appreciate you being here to hear our takes. And I'm testifying on behalf of the DC chapter of Citizens Climate Lobby, which is a nonprofit, nonpartisan grassroots organization that advocates for climate solutions. You know, here we're raising issues that are facing us with a really pressing climate crisis. And what we're doing, or what we're asking, is for the DCRA to permit the use of A2L refrigerants in buildings during this building code cycle update. And refrigerants classified as A2L are more climate friendly than hydrofluorocarbons, which are often thousands of times more polluting than carbon dioxide. They're extremely potent. And many A2L refrigerants are already EPA approved. So CCL supports allowing low climate impact refrigerants into the DC building code as an important step toward mitigating climate change. Continuing to use hydrofluorocarbons not only jeopardizes DC's climate goals, but also is far from necessary. Less polluting alternatives exist and simply need to be permitted. By enabling buildings to begin using A2L refrigerants, they can further reduce their greenhouse gas emissions and help prevent DC from experiencing the worst of climate change. Today, we urge you to make this possible by updating the building code to allow the use of A2L refrigerants. Thank you so much.
Thank you, Mr. Broad. Chris Otten.
Yes, hello.
Please proceed.
Sorry about that. My name is Chris Otten. I'm here with DC for Reasonable Development, citywide unincorporated nonprofit association in the District of Columbia, specifically looking to stop displacement of DC's residents. We're testifying today about DCRA. Let me quote some headlines. Firefighters extricate a construction worker from the rubble after building collapses in Northwest Washington, July 1st, 2021. DCRA investigator speaks out about fatal Kennedy Street fire. Quote, people died in that place. It didn't have to happen. Dated November 17th, 2020. Neighbors still without power after building collapses in Northeast DC, March 29th, 2021. Construction crane slams through the roof of a house in Northwest DC. Crews rescue injured worker, March 17th, 2021. After 2 buildings collapsed in 4 days, residents question how DCRA is doing its job. And that is January 10th, 2022. These are just some of the headlines I just want to point out because Mr. Mendelson, you said the city is not liable for these oversight failures. Boy, that's really demoralizing for everybody that's been on this hearing today. And second of all, it's not true. Also, you mentioned that you can't wave some magic wand. Indeed, you did just that with the McMillan Park project, which was under review at the Court of Appeals exactly for DCRA lack of oversight in permitting the massive demolition of 20 acres of concrete structures that didn't have on the record a safety plan in place. Right now, those safety measures that are required by code are still not in place. But you waved the magic wand. You did the McMillan nuclear option, exempting McMillan Park from any and all laws. You and Councilmember McDuffie, signaling to DCRA, you can go ahead and let DemPed demolish the site without any care to the people who live in the area. Tons of dust has flown up, 100-year-old dust from these structures have flown off the site to areas around Children's Hospital, to the community, into our reservoir, our drinking reservoir. There is no safety barricades around an excavation site, which is required by the code. And when inspecting, the code official apparently has discretion to say, doesn't matter what the law says, I read it differently, and then people don't have remedy. Indeed, we do. We're going to keep pushing for this. And this city is going to be sued again and again for libel because you cannot keep them to account. In fact, you're signaling to them to go forward with this type of dereliction of duty. Thank you.
Thank you, Mr. Ott. And I don't have a copy of your statement. Mr. Otten, if you want to submit your statement.
Will do.
The next witness is Steve Amate. Please proceed.
Chairman Mendelson, my name is Steve Amate, and I'm the Executive Director of the National Association of Security Companies, NASCO, which is the nation's largest contract private security association, whose member companies employ over 500,000 private security officers across the nation. In the district, NASCO companies employ thousands of security officers and special police officers who are providing security services to a vast array of DC businesses, public and private organizations, healthcare facilities, schools, and other institutions. There are approximately 20,000 total licensed security personnel in the district, working for hundreds of licensed security agencies. Currently, NASCO and its members are working with DCRA officials, the mayor's office, security officer unions, and others to address the ongoing delays and other problems that are plaguing the DCRA's licensing system for security officers in the district. The bottom line is that it can now take 8 to 12 weeks for a person who has applied to become a security officer to obtain authorization from DCRA to start working, and that is simply unacceptable. In other states with similar licensing requirements as the district, new officers can be authorized to work in as soon as a week. These licensing delays are not only severely hampering and deterring DC residents from working in what are readily available, good paying, and flexible jobs as security officers, but they have also increased the onboarding and operational costs for security companies who are now struggling to hire and provide enough security officers to meet the demand for security in the city. Literally, there are hundreds of security officer positions open right now in the district that need to be filled, while at the same time, there are hundreds of security officer applicants waiting on DCRA to approve them to work. And ultimately, a shortfall of needed security officers in the district creates public safety risks for all DC residents and visitors. As mentioned, private security jobs are readily available and only a high school degree is needed to be a security officer. Persons can work private security full-time or part-time. With the constant increasing demand for private security, a private security officer does not have to worry about getting laid off. However, most persons cannot wait months to start a job and earn money to support themselves and their family. Accordingly, to no surprise, security companies in DC are experiencing that up to 80% of the persons to whom they offer a job as a security officer are no longer available to work by the time DCRA has approved them to work. In my written testimony, you'll find information on some of the current problems that need to be addressed by DCRA to decrease the licensing delays and overall improve the licensing of security officers in the district. I would also refer you to the testimony of Mike Fonts with Allied Universal Security Services, NASCO's largest member company, and also the testimony of Felicia Dantzler of Ask Me, who also describes the problems with DCRA security officer licensing. For the sake of both DC residents seeking employment as security officers and DC security companies trying to provide their DC clients effective and efficient security services, we're hopeful that the current efforts by DCRA to address the delays and other problems with security officer license will soon yield positive results. Of note, last week, with the assistance from the mayor's office, DCRA put in place an emergency regulation that has the potential to get security officers on the job sooner. But a lot of work still needs to be done, and some of the needed changes will also require statutory changes. But if everybody works together, the situation can improve. Finally, I would like to also acknowledge the support of the City Council and the district's Workforce Investment Council in their effort to improve DCRA security officer licensing. Thank you.
Thank you, Mr. Amate. I don't have a copy of your statement. Could you provide it?
I mean, it's there. This was my oral statement. My written testimony was provided. I switched it up. I could submit this one too if you want.
Well, I don't have the other statement.
It's in the Dropbox. It's up on the website. So, I mean, I could submit it again.
Whose website?
Well, the DC Council testimony, it's there with all the other.
Sir, sometimes things get a little messed up, but I'm looking at my staff. We don't have a copy of your statement. If you could submit it or resubmit it, I'd appreciate it. Send it to cow.dccouncil.us.
Okay, but it is listed on hearing materials 224.22 performance. So you guys have posted it to the thing there. But I will resubmit it, sir. No problem.
Thank you. Mr. Mike Fonts, please.
Good afternoon, Chairman Mendelson and distinguished council members. My name is Mike Fonts, and I'm here representing Allied Universal Security Services as the General Manager for the District of Columbia. I want to thank the council for the opportunity to provide a statement today. Allied Universal has the highest appreciation for critical role that the government of District of Columbia, specifically DCRA, plays in ensuring that new applicants meet all the statutory requirements to become security professionals in Washington, D.C. The purpose of my statement is highlight the challenges to the security officer professional licensing process in the district and the impact our ability to employ deserving DC residents. First, I would like to let you know a little bit about Allied Universal and our commitment to DC's vibrant economy. Allied Universal is the largest employer of security and safety professionals in the District of Columbia, who provide essential security services both to the public and private sectors. We currently employ 2,700 people within the district. During past periods of normal operations, we typically hire 50 to 75 district residents per month. Unfortunately, the reason for my statement today is that we have not been able to maintain that pace of hiring over the past 20 months, despite the increased demand of private security within the district due to the challenges encountered with the security licensing administered by DCRA. The current process and timeline to attain approved licenses for new security professionals has simply become unsustainable for our company, along with the DC residents and their family who are in our need of these jobs. Despite efforts of DCRA, individuals are waiting 60 to 90 days after submitting a license application to be issued a temporary license in order to authorize them to work. This current timeline results in 70 to 80% of our new hires dropping themselves from the process before they ever set foot on a job site. These applicants are accepting job opportunities where they begin work and receive income sooner, or have to come to some other resolution for their employment challenges. The time and effort expanded by both the businesses and the district to license people who need these jobs in order to take care of their families and start their careers is being lost due to these delays. By means of comparison, in adjoining jurisdictions of Maryland and Virginia, it is a matter of days for the state authorities to issue temporary licenses. We typically place a new hire onto a post within a week, and the new employee begin receiving their first paychecks within 2 to 3 weeks. We would like to take this opportunity to recognize that we appreciate the challenges experienced by DCRA, and we appreciate their efforts to collaborate with the security community to resolve this situation. Over the course of the last year, DCRA has had regular meetings with the business community at the program manager level. More recently, Mayor Baber's office engaged with us directly because of our regional president's letter to Mayor Bowser dated December 3rd, 2021. This engagement helped to escalate the need for an emergency rulemaking that temporarily authorizes DCRA to issue provisional licenses for security officers. This emergency rulemaking went into effect on Tuesday, February 15th, and we are cautiously hopeful that this will at least provide some temporary relief to the system. We have not seen improvement in the issuance of temporary license to our organization yet. However, we do appreciate that the emergency rulemaking has only been in effect for a short time. This only underscores the immediate nature of the problem. However, in that it has been ongoing for a truly unacceptable amount of time and a measurable impact on the issue needed as quickly as possible. Unfortunately, several concerns remain with the process that we hope will be addressed by DCRA in the near future. First, we are concerned that DCRA processing the oldest of license applications first. That time and effort are being extended on behalf of individuals that are no longer viable candidates for the positions they applied for, as mentioned previously. We can appreciate that starting with people who have been waiting the longest appears to be the fastest way to approach the backlog. It also pushes the people who are most readily available to work to the back of the line. Allied Universal has experienced approximately 70 to 80% of those untimely receive a license to be willing to be available to serve in the security guard role. Second, it is the most important point unclear as to what mitigation strategy will be put in place due to the statutory requirement that all license holders must go through a renewal process at the same time in April. Due to the delay caused by the previous COVID emergency, many of the license holders went through the renewal process as recently as last August, only 7 months ago. It is our understanding that this placed significant burden on DCRA's resources and contributed to the current licensing backlog. Thirdly, the emergency rulemaking only applies to unarmed security officers and not special police officer or armed SPOs who provide a critical public safety and security function for the district's unique infrastructure and national assets. These individuals are not eligible for provisional licenses, so they still must wait the 60 to 90 days for employment. Fourth, the emergency rulemaking is scheduled to expire on June 9th, 2022. Although we expect this emergency rulemaking to provide relief to the current backlog, we are greatly concerned that the backlog will quickly compound once it expires with other adjustments to licensing holding. This is a brief summation of the current state of our experience as the industry leader supporting the economy, job seekers, and administration of the District of Columbia, and the safety of the DC citizens and compliance. It is our considered opinion that a variety of unique drivers from COVID to the license management system contract to staffing shortages and statutory inefficiencies combined to force this situation into a perfect storm that is a disservice to the underserved residents of DC that are hungry for new employment opportunities and to the business community that seeks to invest in the safety and security of the district. As a company and as an individuals, we are fully committed to expand whatever efforts are necessary to support and collaborate with the council, the Bauer administration, and the residents in DC in order to successfully resolve these challenges. We thank you for your courtesy, coordination, and time today. We look forward to continuing the partnership with the government of District of Columbia, including DCRA. That ends my testimony.
Thank you, Mr. Fonz.
Thank you.
Let me ask you a couple of questions. I tried to follow your statement as you were giving it, but I'm a little confused how we got to this point. I've had oversight hearings on DCRA for years, and never until now have I heard complaints about the security licensing. So what has gone wrong? Near the end of your testimony, you say unique drivers from COVID. So did we suspend the license renewal requirement during COVID?
We did, sir.
Okay, so then a whole bunch of licenses were due at one time. Is that what happened?
Correct.
And then what is the license management system contract? How's that responsible?
The contract that was in place for PSI, they literally shut that system down and did not have a replacement. That compounding with the COVID suspension and the renewals, it really became a perfect storm because 20,000 people applied for renewals in the August to October timeframe, and it's just literally crashed the system.
Well, what do you mean they suspended or closed the license management system contract?
PSI, they terminated the contract with PSI without having a replacement.
What?
Well, sir, I think it was more that the replacement contractor was not ready to fill in and fulfill all the requirements of the contract when the transition was made to the new contractor.
Well, when was the transition made to the new contractor?
It was April 2021, I believe. And there's still, for instance, the new contractor is responsible for actually printing the hard licenses, the licenses that each security officer must carry with them on duty, as required by law. And yet that contractor still does not have the capability or ability to print those licenses.
He's required to print. These are licenses, I'm going to say like badges or ID cards or required.
Exactly.
But doesn't have the ability to print them.
The previous contractor was printing these badges as part of their contract. They lost the contract, a new contractor came in, and that new contractor still does not have the ability to print those badges. I don't understand it either. I know that they're working on it, but that's part of the issue. Other functions were lost too. Security companies used to be able to go online and they used to be able to transfer officers from one company to another. But that functionality was lost too. When the previous contractor, I think Ms. Dantzler, if you can recall, she brought that up in her testimony, said, this was proprietary software to run this licensing management system. And so when that contractor lost the contract, that software left with that contractor. And then the new contractor has not been able to put in place similar software with similar functionalities.
Thank you. Mr. Fonts, you made reference to a letter from the regional president to the mayor on December 3rd.
That is correct, sir.
And then when did Deputy Mayor Babers engage you directly?
We have been meeting with Deputy Mayor Babers. I would say we started probably two Teams calls or Zoom calls so far. I would say one was in probably middle January, and the most recent one was last week.
So this crisis has been developing to the point where the regional president wrote beginning of December, and it was another 6 weeks before the administration responded.
Correct.
I had one other question for former council member Alexander. Are you there?
I am here.
Okay.
Eating popcorn.
Okay, you don't have to share all that. You concluded your testimony saying that the current illegal market has resulted in an estimated $600 million illegal sales. How did you come up with 600 million, or who came up with it? What can you?
Yeah, thanks for asking. And the DC Cannabis Trade Association has information. There's a marijuana brain trust organization that came up with this figure. They have figures from state to state about the illegal market. And the information is accurate from them. I can provide you with that report. But I mean, if you even go into some of these businesses with what they're selling, if you did an inventory of the sales of, say, T-shirts or health drinks or whatever, the amount that they sell, the amount of customers that they have, and they've actually had actual customers go inside these different operations to purchase. So they have an idea of the daily amount of sales that they have made. But I can provide you with that report.
I think Mr. Stum on my staff has that report, so we'll look at it.
Okay.
Let me turn to colleagues for questions. Councilmember Silverman.
Yes, thank you, Mr. Chairman. Sorry to join the hearing late. I am here perhaps to put an exclamation point on Mr. Fonce's testimony. So I've been working with one of Mr. Fonce's colleagues, Nathan Smith of Allied Universal, Mr. Chairman, on this issue. And I actually missed Mr. Fonce's most of his testimony, but I just want to make a few points to you, Mr. Chairman. Security services is one of our best industries for entry-level employment in our city. And because of this dysfunction at DCRA, Mr. Chairman, people aren't able to work. So I don't know if Mr. Fonce delivered this in his testimony, but right now people are waiting 2 to 3 months. Is that right, Mr. Fonce, to get even a temporary license?
That is correct.
Right. And whereas I believe in our competing jurisdictions, it's a matter of days.
That is correct.
And I think another disturbing thing, Mr. Chairman, I'm not sure Mr. Fonts emphasized, but this is good entry-level employment, especially hires a lot of single moms in our city. And because of this dysfunction at DCRA and they're not able to get their license, they're just giving up, basically. They're not entering the workforce. That's exactly the opposite of what we want to happen right now. I will say, Mr. Chairman, Mr. Smith is Nathan Smith, who's Mr. Fonts' colleague, is on the Workforce Investment Council. I don't know what, so this is a strategy for you to help us with Mr. Director Schrappa, because I'm not sure what else is going to work at this point. This has been brought up at the Workforce Investment Council, which has many executive partners. I know that Director Smith of the WIC has engaged directly the administration. As Mr. Font said, Deputy Mayor Babers has been engaged, but we seem to get nowhere. And this is, to me as labor chair, Mr. Chairman, this is extremely frustrating because of the agency dysfunction, not being prepared when the contract was turned over and now being overwhelmed and not problem solving. What gets me is just the lack of problem solving here. We're keeping households from earning income and from our residents from gaining work. So I will hop off my soapbox here. I hope you're able to press Director Schrappa. I will try to stick around for that as well, Mr. Chairman. But this is a critical issue, which is keeping people from work. And, you said you don't understand what's going on here, Mr. Chairman, and I don't either. And that's why I'm here today. So thank you. And I'll be asking these questions of Mr. Director Schrappa. And I don't know Mr. Amate as well, but it sounds like you delivered testimony on a similar issue. And I'll just say hello to my former seatmate, Councilmember Alexander. I miss you sitting next to me. Don't miss some of your votes, but I miss you, Councilmember Alexander. And to Commissioner Guggenmoss, good to see you. To all the other members of this panel, thank you for testifying. Thank you, Mr. Chairman.
Thank you, Councilmember. Thank you to each of the witnesses. I do want to say something actually before you all disappear, because there was something said about this earlier. I may not have articulated it as clearly as I should have, but I want to be clear here. For those who've testified about the damage done to their property by illegal construction or shoddy construction, I am sorry for the damage that has been caused. And I say that even though I'm not personally responsible for it, but I am sorry for that. The city is not responsible for the actions of a private party who harms another private party. Nevertheless, it's my view that DCRA has a duty to do everything possible to protect innocent people from bad actors. Today's witnesses have a reason to be angry. We, the council, are trying to help after a couple of years of unsatisfactory progress with regard to housing code enforcement, protection of property owners from illegal construction. Our next step was to break up the agency. And I would note that the legislation is law and will be effective with the new agency this coming October 1st, but that was only after the mayor not only refused to fund the legislation, but he actually vetoed the legislation. So we are pushing to try to improve the situation. I want to be clear about that. And I think it's, I've been pretty angry in the past with the director over a witness testifying about illegal construction. I believe today we heard from witnesses regarding a half dozen different properties. This problem has not gotten better. And I don't want it to be construed that I think that I'm callous about that. It's a real problem, and it's a problem that the agency should have addressed, and that I'm hopeful will be addressed on a long-term basis with the new department. So I want to thank each of the witnesses again for your testimony. You're taking the time. You all are excused, and I'm going to turn now to the director of the department. Also, while we're waiting for him and everything to get cleared, I'm going to mute for just a minute, maybe two.
We don't appreciate the crime scene at McMillan Park.
Director, give me a minute.
Okay, Chairman.
Director, when you're ready.
Thank you, Mr. Chairman. Good afternoon, Chairman Mendelson, council members and staff. I am Ernest Chorapa, the Director of the Department of Consumer and Regulatory Affairs, DCRA. I'm here this afternoon to share the many accomplishments and ongoing activities of the agency in fiscal year 21, fiscal year 22 to date. Neil Bowser has set an ambitious agenda for a more responsive and accountable government in the district, and I'm proud to be leading an agency that strives to live up to that aspiration. I would like to take this opportunity to recognize the progress we've made and thank the employees of our agency for their hard work, as well as residents and community leaders who have given us good suggestions on how to improve. DCRA is tasked with very important responsibilities, including serving residents and businesses in the areas of consumer protection, business licensing and regulation, and building permitting and enforcement. As a regulatory agency, the nature of our enforcement work can sometimes create tension or unhappy customers because we must stop someone from building their dream home, for example, due to the fact that it may cause damage to an adjoining neighbor's property. DCRA's duty, however, is to the public at large, not to any specific individual. Due to improvements we've made, there is a reason why so many of our customers are satisfied. Since many of these people cannot be present to testify at today's hearing, technology has allowed me to bring these perspectives to you. At this time, I would like to share a brief video that is representative of what our customers are saying.
Each day, the Department of Consumer and Regulatory Affairs protects the health, safety, economic interests, and quality of life of residents, businesses, and visitors in the District of Columbia. We proudly and responsibly serve the public and respect the investment that taxpayers have made to drive improvement in how DCRA provides government services. As an agency, over the past 3 years, a culture change occurred, and our mission is indeed clear and visibly embraced by our staff at all levels of the agency. In serving, we understand our purpose.
Now, when you contact DCRA, there is an immediate response. You get a code assigned to you by the individual which division which we're speaking. And that's a good thing because you can feed back. It seems like things have changed. There's been an uptick in responsiveness to inquiries, and not just in responsiveness to inquiries, but also in tracking. I'm able to follow now as an end user where the staff is in regard to either issuing my building permit or working on any of the issues regarding review of my inspections of my property. I can tell where they are in the process now.
I feel that the agency has made real investments in tracking communications with customers.
The transformation into the new website is very comprehensive. It was easy to find everything. There was a checklist. Everything was really straightforward and quick and easy for me to get all of the pieces that I needed to be able to do that business license renewal because of that digital transition.
They really helped a great deal. They walked me through the process. The inspector was timely. He explained everything to me that I needed to know. And then the customer service rep, she rounded out the process and she really helped a great deal. So I really appreciate it.
By thinking differently, DCRA has boldly transformed how we operate, and that has resulted in improvements that are beneficial to our customers and stakeholders. By clearly establishing our service level agreements and setting goals for process improvements, we exceeded every key performance indicator for fiscal year 2021 and surpassed our commitments. In doing so, we keep residents safe in their homes and businesses operating in our city. We understand our promise.
The digital transformation is impeccable. Like, it has made the process streamlined. It's 1,000% better. The experience is such a positive experience now.
Project Docs has been great in being able to submit documents quickly
and getting the responses back from reviewers as in real time as they come in, which has been very helpful.
It seems that the employees themselves have embraced this new energy, this new change, and have a real desire for quality. That to me is everything, the desire to try to provide quality in service delivery.
This was very simple, very self-explanatory. In addition to the online guidance and consultation that I was giving by DCRA, it took me less than 5 minutes just to follow the process and then, choose the category that I qualified, apply for it, and shortly in few days, I just got my permit.
DCRA has always been extremely responsive and helpful in resolving issues.
Whether it was vending or getting the restaurant up and running, the Small Business Resource Center, DCRA has always been there for us, and it's always been one of our first go-tos.
At the core, we serve a public trust, and the investment that taxpayers have made in DCRA's digital platforms has empowered us to create a seamless online customer journey. Our customers have positive experiences, greater access, and receive better service now and will well into the future. Now, with just a few clicks, customers can select a building plan that has been pre-approved for use, identify a highly rated contractor, easily apply for a building permit, identify needed inspections, and schedule them, even follow them in real time. And through Tertius, our digital marketplace for construction and special inspections, we have increased our oversight to unprecedented levels. DCRA has demonstrated our progress.
Being able to call and get just speedy service. I mean, your colleagues answer the phone. They're always helpful. They always take the time to find out the answer to whatever problem that I'm having.
I was able to get direct connection with the Office of General Counsel like within minutes. You know what I mean? It was really incredible. And I thought it was done very efficiently by email later on.
Being able to encounter professionals at DCRA that helped us to move along that process so seamlessly really kind of helped me to refocus and get grounded again.
DCRA's customer service level improvements in the last few years have definitely changed the perception of District of Columbia's government as a whole and how they are responsive to their constituents' needs.
Everybody that I've talked to in the recent years have just been really, I've been able to get a hold of someone very quickly. I've been able to explain my issue. I haven't been transferred 1,000 times, and I get a follow-up email, and it's been wonderful. So I've been able to get all my issues resolved very quickly.
The quality of services that I get in DC from different agencies and also from DCRA has been very good. As a matter of fact, it's exceptional with me. It just makes me want to continue.
Our work matters. As a regulatory agency, we have conducted over 47,500 housing inspections, more than 45,000 construction inspections, in excess of 10,000 illegal construction inspections, and over 14,000 vacant property inspections since April 2020. Every month, we field more than 19,000 emails, 6,000 phone calls, and 1,000 live chats on our website. By keeping the customer at the forefront and leveraging new technology, we respond to customers within 3 business days or less, and delivering better service faster has benefited our customers, and they have spoken. Despite the natural tension associated with our enforcement role, 88% of our customers rate their interaction with the agency as satisfactory or excellent, nearly a 3-fold improvement in 3 years. As an agency, it is clear that a visible culture change occurred within our staff, and their embracing of our mission has positioned DCRA to lead among our peers during the pandemic. We value our people.
I interact with DCRA from literally the top to the bottom. I interface with you guys a lot. I appreciate what you do. I know it's not easy. And I appreciate the fact you make it easy to problem solve.
you guys met me right where I was and gave me the information that I actually needed. At the end of the day, it definitely changed my perception of city government as a whole.
And I have to say, with this new digital platform, you can see that the different government agencies are working together to really make this process easier for the customer.
Looking ahead and guided by a pursuit of perpetual improvement, there's more to come in our transformation, and that includes transitioning into the new Department of Buildings and Department of Licensing and Consumer Protection that will begin operation on October 1st, 2022. At DCRA and as successor agencies who will build on our success, we remain an innovative partner with residents, businesses, and stakeholders, the customer we proudly serve every day.
Mr. Chairman and council members, turning now to our key performance indicators, which are essentially measurements of how successfully we deliver our core services. I am proud to report that for the second year in a row, DCRA exceeded the target for all its 19 KPIs. In fiscal year 21, we served nearly 400,000 customers, and our customers have spoken. Out of 59,099 responses that we have received, 44,284 of those responses have given us a positive rating. This means 86% of our customers either rated their experience as excellent or satisfactory. This is quite an achievement when you consider the complex nature of our work and the fact that it is nearly impossible to achieve a 100% satisfaction rating. In all measures, the agency exceeded its target at a faster rate, including resolving issues with customers, issuing business license renewals, clearing consumer protection cases, and completing inspections. Looking now to specific KPIs, DCRA reviewed 98.6% of all non-accelerated permits within 30 business days of acceptance in fiscal year 21, which well exceeded our target of 90%. Another KPI I'd like to highlight is the percentage of basic business license, corporation, and Office of Professional Licensing transactions that are conducted online. We conducted 87.4% of these licensing and registration transactions online, which exceeded our target of 80%. Finally, I'm pleased to report that our Consumer Protection Unit, which received complaints related to COVID-19 pandemic throughout fiscal year 21, closed its cases within days from the date of complaint submission, 95.2% of the time, which exceeded our target of 85%. KPIs are not only a way to measure the agency's alignment with its strategic priorities, they are also an efficient way to quantify the hard work that all DCRA staff put into providing excellent customer service throughout the year. Across the board, the agency demonstrated a strong performance for fiscal year 21, and that is indicative of the positive changes we've made. As for our KPI metrics for fiscal year 22, we will continue to use the same 19 metrics that we've used in previous years. Overall, we are on track for meeting our benchmarks in fiscal year 22, and I look forward to continue to share the successes with you. I would like to share with you several principles that are constant reminders of how the agency must perform in order to deliver on its mission. First, DCRA has embraced a customer-centric philosophy in which customers are prioritized in all agency actions and policies. Given the needs of district residents and businesses, serving customers is the best possible way that DCRA is fulfilling its mission. Next, as the pandemic has shown all of us, it is critical to remain responsive to the rapidly changing needs of district businesses, as the future can be uncertain for them, and we must understand how to work around ever-changing constraints. Finally, we must emphasize the importance of collaboration with our district government partners. DCRA is developing partnerships with our sister agencies, such as when we guide displaced persons in unsafe housing conditions to the Office of Tenant Advocate, or work with the Office of Tax and Revenue to make sure that properties are taxed at the correct rate. These are just some examples of the principles that will continue to guide our agency in the current fiscal year. I would now like to highlight some of the strategic initiatives that DCRA completed in fiscal year 21. First, DCRA sought to modernize its abatement tracking database by capturing abatements at the violation level and streamlining how abatements are documented between pre-inspection and post-inspection. Some initiatives we use to increase abatement activities and modernize the agency's ability to track abatements include hosting online housing summits, updating the agency's records to better capture abatement activities, and communicating with housing providers who have pending cases at the Office of Administrative Hearings to offer incentives for abatements of housing violations. In fiscal year 21, DCRA verified abatement of housing code violations in more than 2,500 properties, a 9% increase compared to fiscal year 20, and the highest annual volume the agency has on its record. This ties in to a fiscal year 22 strategic initiative, which is to support affordable housing through code enforcement and abatement tracking. Mayor Bowser has demonstrated a commitment to creating tens of thousands of new homes, including affordable housing units by the year 2025. To support this goal, DCRA is working to preserve existing housing stock through targeted enforcement against landlords with high volumes of unaddressed housing code violations, as well as supporting successful issuance of affordable housing-related permit applications. We will continue to measure success by tracking increases in housing abatements and publishing quarterly information on affordable housing-related permits issued by DCRA. So far, in the first quarter of fiscal year 22, DCRA identified 15 property owners with high volume of unabated housing violations and began developing enforcement and outreach strategies to get property owners into compliance. DCRA's inspection and enforcement efforts have also contributed to 364 abatements throughout the city. One example is 305 37th Street Southeast, Unit 102. A tenant had complained of unsafe conditions, including broken smoke detectors in the unit. A case was opened on August 3rd, 2021. DCRA went out to inspect the property on August 6th, 2021. A notice of infraction, NOI, was issued to the property owner. A reinspection was performed by DCRA to determine if the violations were abated. And since they were not, DCRA abated the conditions by installing smoke detectors in the hallway and bedrooms. The case was ultimately closed on December 7th, 2021, and a special assessment for $1,333 has been charged to the property owner. DCRA has also identified a list of potential unlicensed rental units in the district and will be reaching out to property owners to ensure that they obtain the necessary business license and inspection. Furthermore, DCRA has issued 75 construction permits in the first quarter of fiscal year 22 that would increase DC's affordable housing stock. Another strategic initiative that was completed in fiscal year 21 relates to improvements in consumer protection unit operations. DCRA has enhanced its current case management system in order to assign specific cases to investigators with subject matter expertise. DCRA has also created digital templates and tools to allow easier cases to be resolved in an expeditious manner, paving the way for investigators to spend more time working on novel or complex cases. In fiscal year 21, the agency developed a statement of work for a new case management system that will be launched in fiscal year 22. In fact, implementing the new case management system is a fiscal year 22 strategic objective. In fiscal year 22, when the system launches, some of its new features would include proactive identification of consumer complaint trends, automated risk-based assignment of cases, and caseload balancing based on complexity of cases. As with all of DCRA's goals and initiatives, this will result in better allocation of resources, a faster investigatory timeline, and speedier resolution for our customers. Next, I would like to highlight other DCRA strategic initiatives that are underway in fiscal year 22 and how they tie into Mayor Bowser's broader goals. First, DCRA is excited about advancing climate change mitigation and adaptation through development of construction codes. This is part of Mayor Bowser's Clean Energy DC plan to cut greenhouse gas emissions in half by 2032 and to create a carbon neutral city by 2050, partly by establishing highly efficient and zero emission new buildings. To support the mayor's goals, in fiscal year 21, DCRA initiated the process of drafting the DC Energy Conservation Code and solicited the first round of public comments. In fiscal year 22, the Construction Codes Coordinating Board, through DCRA, will publish a proposed rulemaking and solicit another round of public comments. Next, the mayor has prioritized relief for small business owners through fee reductions and cutting other barriers to obtaining a business license in the district. With significant business closures during the pandemic, many business owners are trying to restart their business while others are looking to go into business for themselves. To support these entrepreneurs while adding economic growth and recovery, DCRA has created a fast-track permitting, licensing, and inspections team to accelerate approvals for business licensing and permits. Additionally, DCRA will implement fee reductions and develop a more flexible and cost-efficient business licensing model to accommodate seasonal and temporary businesses that only operate a few months a year. DCRA is committed to empowering staff through technology training and regular opportunities for dialogue and feedback. As more of DCRA's work moves to the digital realm, the agency will continue to foster a culture of tangible staff development by providing employees with additional support and training in technology readiness. In fiscal year 22, all DCRA employees will take 3 trainings in digital communication, data analysis, and change management. DCRA has started planning team building activities around these training courses, which will be held in the second and third quarters of fiscal year 22. Moreover, the agency will host quarterly town halls to increase employee engagement through open two-way communication, where employees will be able to comment and ask questions to my leadership team and me about recent and upcoming issues of concern. Thus far, in the first quarter of fiscal year 22, DCRA held an employee appreciation and awards event and an all-staff town hall meeting that provided employees with an opportunity to virtually interact with me and ask questions on a variety of topics. One of the achievements of the past year that I'm most proud of relates to DCRA's improved suite of digital tools. This is something that we know our customers care about. And under the leadership of Mayor Bowser, DCRA has launched several technological applications that have made the DCRA customer journey seamless for many of the services the agency offers. Some of the new products that empower customers and improve their experience include an online marketplace for construction inspections, an inspections on demand system, an innovative and easier to use permitting application, and other measures that will shorten the plan review time. I am proud of how these platforms have replaced prior, often complex processes and better inform customers as to what is required when they undertake a project. The agency is continually setting out to find ways to make applying for permits more user-friendly and intuitive so that customers would not need to know the permit types before applying. The suite of new products innovates and revolutionizes how government services are provided to customers to serve them better, easier, and faster. Notably, DCRA was selected as a finalist this year in 2 categories at the Business Transformation and Operational Excellence World Summit and Industry Awards. Best Achievement in Operational Excellence to deliver digital transformation and Most Outstanding Digital Transformation Workplace Program. I am proud to know that our agency won the award in the latter category, which shows that we are a leader across several jurisdictions and private sector companies when it comes to technological innovations with measurable benefits for residents and businesses. Mr. Chairman and members of the council, thank you for the opportunity to testify. With that, I am happy to address any questions you may have.
Thank you, Director Chirapa. I'm going to apologize at the outset because I'm feeling pretty cranky after listening to 2.5 hours of critical testimony. And I get especially angry over the testimony about or from residents who've been harmed by illegal construction. I think, for example, of Mommy Preston's property, which I know you're familiar with. I mean, imagine anybody. I'll just say this for those who might be watching. So this is a property owner who's not affluent by any means, owns her house. Not her doing it all that the next door neighbor's house was put on the market, a developer bought it, and proceeded to undermine the structural integrity of her house as well as the house on the other side. These are all row houses. So now we have, I believe she testified, 3 vacant properties on that block. Hers is not vacant, but hers is structurally damaged and she's been advised to move. And what is she to do? Is she to go after the LLC who did the illegal construction, who's doing everything possible to avoid having to pay, to avoid any liability? It was an LLC with only that property. In fact, I think the property's been flipped to somebody else. Stop work orders weren't issued timely. Stop work orders were violated. Nothing's been done to remediate the property. And I want anybody who's watching this to think about, what is that woman to do? Her property's been damaged, not remediated. And I guess it's a little bit like living on a battlefield with the next door property dug out underneath, the backyard dug out. And there were others who testified. Building that blows, apparently sways in the night because it was built improperly. And they've been advised that they should move. So yeah, that kind of puts me in a bad mood. There was Chuck Elkins in his testimony noted that one of your key KPIs, % of exempted properties that were re-inspected within 90 calendar days of receiving exemption status, 97.6%. So this is a vacant property that's applied for and been given an exemption for example, construction. Because obviously if you're completely renovating a house, it would be empty while it's being renovated. And the inspections to make sure that that work's actually being done, 97.6% of the time has occurred within 3 months. Director, I find that statistic fantastic, and I don't mean that in a nice way. You testified at the vacant property hearing we had a month ago. The ANC commissioner from ANC 34G testified about, I believe the property owner's name is Mr. Donnelly. He owns 2 houses that are vacant. Both of them have a construction exemption. I think it was his testimony. Once again, they have a vacant property exemption because of construction. No work's being done. So how is this 97.6% statistic made up?
Chairman, I will address how the statistic is computed. But I want to first of all start by saying, I understand how you feel. Over the last few years, I've also sat in these hearings or roundtables, and I've heard many stories about customers or residents who feel they've been let down. And personally, I know I speak not just on myself, but many people within the DCRA organization. We all find that discouraging, and our commitment is to keep exploring and finding ways we can help address those situations, recognizing what our agency's limitations are, what are the limitations of government. But our commitment is not going to waver, because on a very personal level, nobody should have to live in an unsafe home, and people should have some type of recourse if they suffer damage from construction next door or construction within the community. So I just want to put that out there just to start this conversation. Shifting now to your question about how the statistic is computed around vacant building re-inspections or inspections that occur within 90 days. It is simply a matter of a numerator and a denominator. What we look at are exemptions that are granted on a date certain. And then the clock starts ticking for the 90th day. And our goal is to ensure that a lot of these inspections occur within that window. At the end of each quarter and at the end of the fiscal year, it is tabulated, and that is how the statistic is calculated.
Well, but that doesn't speak to how you ensure that there's any integrity behind the statistic. I'm telling you, these two houses, it was the ANC commissioner's testimony that no work was being done. And for a figure like 97.6%, that would be the totality of the ones that weren't inspected within 90 days, and I don't believe it. Do you have quality control around that statistic?
Absolutely. The statistic, first of all, one of the things that we have that addresses quality control is that the program, for example, vacant building or illegal construction or housing, does not calculate their statistic. It is calculated by a separate part of the organization so that independence is there. Second,
that doesn't speak to integrity.
Well, if I could
somebody independent,
my explanation. The first stage you asked about safeguards in place essentially. And the first is to ensure that the person performing the work is not a person calculating whether they've met their goal or not. So that is a process that we have in place. Secondly, once we compute the statistics, we provide the underlying data and the information, and it goes through a vetting process through the Office of the City Administrator. It is no different than what all the sister agencies.
Director, you're not getting at my point here. Somebody is reporting that they are re-inspecting the property, and they're not re-inspecting the property, or if they are, they're re-inspecting it with their eyes closed.
That's
a couple of years ago with the property.
To go to the extent of suggesting that people are inspecting properties with their eyes closed. I cannot agree with that statement.
Mr. Director, the two properties that Commissioner Randy Speck testified about, you can go out and look at him today. He was very clear. There's no construction work happening. And yet, once again, it's an annual basis. The owner goes and he gets a construction exemption certificate. I don't even know how he can do it for as many years as he has. But in any event, it's currently construction exempt and no construction is being done. That's his testimony. So those come to mind offhand. And I'm certain that those are not the only two properties. There's no work being done. And yet your statistic is that 98% of the time, 98% of the time, those properties are getting re-inspected within 90 days. I'll move on. Our analysis of Schedule A materials you provided suggests that you have a vacancy rate of 16%, or approximately 81 positions. This is significantly higher than last fiscal year. What accounts for the high number of vacant positions?
And Chairman, I'll turn to the pre-hearing question. You say you are reporting 81 based off a Schedule A analysis?
Yes.
All right. If you don't mind, what page are you looking at? So that I'm sure I'm speaking directly to what you are looking at.
I'm not looking at a page. We asked for the Schedule A. We got the Schedule A. We asked if the Schedule A list vacant positions. My staff added up the vacant positions are 81. That's 16% vacancy rate.
All right. Putting the calculation aside, you asked about what contributes to vacancy, essentially. And turnover.
You disagree that there are 81 vacancies?
I'm not looking at the Schedule A right in front of me or how your staff calculated the 16%. So I am not disputing that number. I'm focused on your question about how vacancies essentially occur. This Schedule A is a snapshot.
My question was, this is significantly higher than last fiscal year. What accounts for the high number of vacant positions?
The number of vacancies that we have, I think, is 61, not 81. That being said, what accounts for vacancies is staff departures, pandemic-related staffing shortages, and opportunities for us to streamline and align our human capital with the challenges that we have ahead of us. More importantly, recognizing the overall trend in the labor market and recognizing the time it takes to fill the position, we've focused our efforts on hiring people, conducting activities that will shorten the time it takes to fill positions. For example, we are currently in the midst of a hiring event. Some people call it a job fair. We've also partnered with DCHR to have another job fair in March. We do know that as an organization and industry, they are setting hard to fill positions, and we are not alone in that boat. For example, very technical positions, be it plan review or other unique positions, are challenging, and several jurisdictions are dealing with that same challenge as well. But we feel encouraged by the investments we are making in attracting talent, retaining employees, which overall will put us in a position where we minimize the vacancies.
Give me just a second.
Sure.
Was it your testimony, Director, that the impending breakup of the agency is creating some of the vacancies?
Where did that come from? That's not what I said.
I'm just, okay. I might have misheard. Okay.
I counted on myself.
So why do I have a Schedule A that has 81 vacant positions and you're saying there are only 61?
The Schedule A is as of February 1st, 2022. If you look at the agency org chart or where things stand, it is based as of February 22nd. I think your staff received those materials. So that could very well explain the trend you are seeing. But what I can speak to is, I don't know how they calculate their 81. I know how I'm looking at 61 vacancies.
A number of the positions that on the Schedule A are ARPA funded positions. You don't count those in your vacancies?
You mean we don't count vacancies in that are APRA?
ARPA.
The APRA positions are temporary. And when we
They're
look
still
at
budgeted, they're still budgeted, but you're not counting them.
we do count them. So I'm not really sure how your team calculated the vacancies. I mean,
And your testimony is that you, maybe what happened is that you hired 20 people in the last 2 weeks, and you, nobody's left in the last 2 weeks.
No, Chairman, what I said was the Schedule A is based on February 1st. The org chart is based off February 22nd. The
Appreciate
Delta,
that. I appreciate that. I don't believe you hired 20 people and nobody left in the last 3 weeks. And the Schedule A that you gave us has 81 vacancies. You know, I asked for the special purpose fund. That was question 13. My question was, for fiscal years 21 and 22, please identify each special purpose revenue fund maintained by, used by, or available for use by your agency. For each fund identified, provide the revenue source, the source of funding, a description of the programs, the amount of funds generated, and the expenditure of funds. For the last two, which is the amount of funds generated annually and the expenditures, provide specific data for fiscal years 2020, 2021, and 2022, and give starting and ending balances. I'm thinking of this question, which I had on my list to ask you anyway, because of the conversation we just had over what's the correct vacancy number. So you gave me, gosh, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 special purpose fund. For the real estate guarantee fund, guarantee and education fund, your opening and closing balances don't reconcile. For your real estate appraisal fee fund, your opening and closing balances do not reconcile. For your basic business license fund, your opening and closing balances do not reconcile. For your corporate recordation fund, your opening and closing balances do not reconcile. For example, on the last one, the corporate recordation fund, the beginning balance in FY20 was 5.2 million. Revenue was 6.3 million. Expenditures were 4.5 million. Therefore, the end of the year balance or beginning balance for FY21 would be 6.9 million. And what you gave me was 1 million. Listen. For your expedited building permit review program, I guess it started in FY20. FY20 revenue was 7.7 million. FY20 expenditures were 3 million. That means there was 4 million left at the end of the year. Your FY21 beginning balance was listed as 0. Why am I getting inaccurate information? That
when
last
it comes,
page 25.
yes, I see. Beginning fund balance in fiscal year 21 was 0. Fiscal year 21 revenue was 5.8, and fiscal year 21 expenditures was 5.8 as well. And in 20, as you mentioned, the beginning fund balance was 0. Revenue for fiscal year 20 was 7.7, and FY20 expenditures was 3 million. As to why you would expect some type of balance to carry over from fiscal year 20 to fiscal year 21, that is something that I can talk to the OCFO for clarification on how the computation was derived.
Well, I would like the answer to this question resubmitted.
Noted.
It's possible that that particular fund is lapsing, but the other funds, like the corporate recordation, the FY21 balance, beginning balance should have been 6.9 million, and instead you list 1 million. So clearly that's a non-lapsing fund. So would you please submit that answer?
Yes, you are correct.
Answer to question 13.
Yes, you are correct. We have lapsing and non-lapsing funds. The expedited building permit review fund is a lapsing fund.
Will you please submit a correct answer to question 13?
And Chairman, when you say correct answer, do you want to explain why the beginning fund balance is 0, or is it that you feel the fund balance should be higher?
Mr. Director, you list, I can't remember now, 8 different special purpose funds. Some of them reconcile and some of them don't.
That's correct.
Okay. There's only one where the starting balance is 0. The ones that don't reconcile have different numbers. I've already explained it. Can you please resubmit the answer with the correct information? Do I need to go over this again?
And Chairman, I don't want to waste your time, but I also want to make sure that you get what you are asking for, which is
Let's
why
take the real estate guarantee fund. The beginning was 1.4 million. You spent $500,000. You got another $500,000 in revenue. That's 1.8 million. You spent 700,000. That means you should have started with 1.2 million in FY21. You didn't. You list 1.8 million. That's a difference of 600,000, or roughly a 30% discrepancy. A little frustrated here because I'm having to explain this. The basic business license. Here's a different one. I'll repeat the corporate recordation. You started with 5.2 million. You got 6.3 million in revenue. That equals 11.5 million. You spent 4.5. That means you should have had 7 million to start FY21. You list 1 million. That's a discrepancy of roughly 5 million.
And I understand your concern and what you're looking for. And what we will give you is an explanation of the fund balance, including areas where there was a sweep, and areas where it was a lapsing fund, and areas where it was non-lapsing. So we'll get back to you with that information.
Well, if your testimony is that there were sweeps, you certainly didn't indicate that in the answer, and that would have shown up maybe as an asterisk in the expenditures. All I know is that the beginning and ending balances do not reconcile.
Sure.
Going back to vacant property, Director Trump, there was a witness who testified about a property at 414 Shepherd Street. Construction began on it 7 years ago in 2015. And she said that there have been permits, there have been stop work orders, there's been work without permits. This has been going on since 2015. I asked her about the property, if you were listening to the witnesses. I asked her if there was work going on now. She said no. I did ask her how it could take 7 years to renovate a property. And she simply recounted what I just said, that there were work without permits, there was work with permits, there were stop work orders, piecemeal building permit applications. But the important thing is she said there's no work going on right now. It's listed on the, I asked you for a list of vacant properties that had been vacant for more than 3 years. And it's listed on that list as having been vacant for 6.88 years. That'll help you find it since it's in ascending order, the properties. 6.88 years. It's at 414 Shepherd Street. Why does it currently have an exemption for construction? Her testimony was that there's no construction going on.
Generally, when we grant a construction exemption, there's some documentation behind it, whether it's pictures that have been taken, presence of a permit. Those are part of the artifacts that goes in substantiating the construction. As to the specific property, I made some notes, but what I'll do is, after this conversation, I'll look into our system. I'll talk to the program managers to get a fuller update so that we can address your concern or your question as to why is there a construction exemption. But the main point here is that construction exemption is backed by some information, permits, and some proof that some work is being done. And usually when we do the inspection, we take pictures and the inspector puts some notes. So there's some evidence to back up that claim.
Yeah, so this would be one of the 98% of properties that were re-inspected within 90 days.
I don't know the specific status of this particular one. So I don't want to state when it was inspected or when it was not inspected. Rather be more deliberate and accurate in looking at the information in our system and responding to your question.
All right, so you'll get back to me on this. As I said, earlier I asked you about how it's possible that 98% of the properties are, when they're given a construction exemption, that they get re-inspected within 90 days. Now I'm asking you about this particular property, which has been, on which the property owner says that there's no work going on right now, but it's on your own list as having a construction exemption. So you'll get back to me about that. Correct?
Yes, but I want to make sure you said something. The property owner said there's no construction. That is a neighbor saying that.
Yeah, I think that's pretty good evidence.
Well, another good evidence is the pictures we take. But Chairman, this is not about a ticky-tack or going back and forth. So my argument is we will look into the records and respond to you as far as what we find.
Well, do you grant a construction exemption for renovating a house, like a full-on renovation, if there's only one worker who shows up every now and then for 7 years? Do you grant a construction exemption for that?
I'm not aware.
There has to be active work. That's what I'm getting at. Doesn't there have to be active work?
There has to be bona fide construction activity.
Active. And that would suggest more than just one person who occasionally shows up for 7 years.
Chairman, I think you are drawing some conclusions based off a certain pieces of information, which may not reflect the full picture. The property you are talking about was vacant for 3 years, no exemptions. So if it's been vacant for a total of 7+ years, what I think will be helpful is for us to look into the property's history and provide you with information that substantiated the construction exemption. Nowhere does it say the property has received a construction exemption for 7 years. And I'm not sure, I don't think that's what you are getting at, but your concern is whether it was actively being worked on, which was the basis of the exemption.
there's according to your list that you provided to me, this property is exempt from the vacant property tax because of active construction. That's your record. The neighbor testified today explicitly that there is no work happening.
Okay. I will take the testimony that we received, the information that you shared, and I will look into it.
Okay. My colleague, Alyssa Silverman, is here. Do you have any questions? Councilmember Silverman? I see another colleague, Councilmember Henderson. Do you have any questions?
I do, but I wasn't expecting you to call me just so immediately. So hold on one second.
Do you want me to continue?
No. I want my 10. I'm having an issue with Microsoft Word. Give me just 2 seconds. Hello. Okay. Good afternoon, Mr. Chairman. Good afternoon, Director.
Good afternoon.
Okay. Okay, Director. I think some of these questions you might have already asked or answered rather. I don't want to actually, I keep bringing it up because I feel like if I don't keep talking about mold, nobody on your side is going to care. And I know what you're going to tell me is that this is not me, this is DOEE and this, that, and the third. But I'm going to ask you about mold anyway, because I want to keep it on everyone's front of their consciousness in terms of the fact that we are not doing anything in the district right now as it pertains to mold enforcement. So I want to ask, is it your position, Director, that any of the inspectors that you have at DCRA, either the full-time or the volunteer residential inspectors, if during an investigation they notice mold, what happens? Do they just refer the case to DOEE?
Are you asking what is our position on mold or what happens when someone thinks there's mold?
I'm asking what happens. So if one of your inspectors is inspecting a property, whether it be your full-time folks or your volunteer folks, and they see mold, what happens?
If we see what appears to be mold.
Yes, if you see what appears to be mold.
We will make the appropriate referral to our sister agency to have it looked at based on their processes.
Okay, and so that's similarly if a tenant discovers mold and they came to you guys, you would refer them to DOE as well.
Before that step, and I think this a good way to sort of like explain our process. When a tenant comes to us with a concern, mold or some other housing related issue, what we do as a first step is inform the landlord. We send them notice that, hey, we are hearing this about this issue. We ask that you take a look at it and respond before the scheduled date of the inspection. Mm-hmm. So the landlord has an opportunity to observe, address it, or take the necessary steps. When we visit the property and we observe violations, we cite violations that are within our authority. And in the case of our mold, the protocol we have in place is to refer it to the appropriate agency.
Okay, well, let's talk about something that is perhaps within your purview. Does DCRA have the ability to provide tracking to residents who like to know the status of their inspection requests or the outcomes of the inspections?
Yes, that is one of the digital tools we've made available to residents. In fact, residents can schedule their own inspections, get confirmation that we've received their request, get notifications about the scheduled date, get additional notifications when the inspector is en route, get additional notifications when the inspection is completed, and where they can find additional information on our website. So that's a long way of saying, yes, we do provide notifications.
So I've heard about this thing where on occasion we allow a developer or a landlord or whatever to self-attest that they have done the work that was necessary. I.e., so I received a notice to say I have some dangerous something that's going on with my building and that I have X number of days to remediate the situation. But I, as the landlord, can self-attest, yeah, I did it, but nobody from your agency comes back around to double check. How is that oversight? Or how is that, like, how does that work?
The way our process works is that even if a landlord abates or addresses the violation, they have to provide some type of evidence, and we always reserve the right to re-inspect. We also engage tenants to hear from them whether they feel the situation has been addressed.
But what type of evidence? Like a receipt of some sort that?
Well, that could be one, but that is not the only evidence. So if you hire, for example, like an exterminator, or you buy certain materials, you'd also have to provide pictorial evidence and sometimes video evidence. And sometimes we do a remote inspection, and sometimes we go to the ground to see with our own eyes. So there are different ways we can validate what is being told to us, either by the landlord or the tenant.
What percentage of our cases are we doing self-attest remediation versus having someone go out to check? Ballpark, because it doesn't look like you have numbers in front of you.
Yes, I certainly don't have that number, but what I do know is that if you look at fiscal year 21 compared to fiscal year 20, the volume of inspections that we did increased 69%.
I know, but that wasn't my question. Just give me a ballpark. Are we talking about 80% we self-attest, or 50% we allow for self-attest?
Let me put it this way, to give you a proxy. We are not going to close any violation if we don't have evidence that the issue has been addressed. So
I know, but like it's 2022, Director.
How often do we look at our inspections? The bottom line is, if we don't have any evidence that the issue has been addressed, it remains an open violation.
I know, but evidence in 2022, in the world of Canva, right? If I wanted to say, yes, I got a pest inspector, you know how easy it is for me to create a logo online and just say that I did it, even though it didn't happen. And so I'm trying to understand, we are giving so much trust to landlords and developers in terms of how we are running our inspection program. It gives me a little heartburn. You know,
I can understand where you are coming from, or where you are coming from.
Yeah.
But what I also know, because we have boots on the ground and we do the work.
I know, but you can't even tell me how many boots are going back to sea. How about we follow up? How about you send me some data on that?
I will gladly circle back with you to engage more. But in no circumstance should it be conveyed or construed that we are not doing follow-ups, because that's simply not true.
Okay, I'm not accusing you. I'm just saying, in this performance oversight hearing, I just got to kick the tires and ask some questions. And unfortunately, I'm a data person and you don't have any data for me right now, so we don't have to circle back. I want to ask you another question. So my office has received calls about pest infestations from constituents who have a voucher from the housing authority, but they rent from a private landlord. And the constituents say that they reported the issue to the housing authority and that a DCRA inspector was sent to examine the issue, but that the issue persisted following the inspection and that the landlord did nothing, and that the housing authority then sends out a DCRA inspector a second time, but the landlord still hasn't addressed the issue. And so I know that there is some unique relationship that is happening between DCHA and your agency. However, we're talking about a private landlord here who I don't feel like gets special privileges just because you are renting out to a voucher recipient. So in these particular cases, though, your agency isn't following directly up with the tenant because they went through DCHA. Is that accurate? Is that how that happens from a procedural standpoint?
I don't think so. I mean, if I'm hearing you correctly, somebody had a code violation or alleged code violation. They just happen to be living in a property that is related to the housing authority.
Correct.
It doesn't change our inspection process. The fact that it's a housing authority related property or it's a voucher, no, it doesn't.
Except for the fact that if I'm the tenant and I've contacted DCHA to report the problem, I don't even know to what extent you have my information. I'm just trying to understand, should we be advising our constituents that when they have an issue, regardless of what type of property you live at, that they should come directly to you as opposed to going through a middleman agency, so that they are able to track the progress themselves? Is that a better recommendation?
I understand your question. What I would recommend is that regardless of who the property owner is, or regardless of the voucher relationship, if a tenant has a problem, they should notify the landlord because the landlord has rights and the landlord is required to address the issue. If the landlord does not address the issue in a reasonable time frame, yes, that is when DCRA comes in. But people are welcome to file complaints with us at any given time by phone or email or through our website. What we ask when they file the complaint is, have you notified the landlord? And you must notify the landlord first. And once you notify the landlord and the landlord fails to address it at the date and time of the inspection, if there is a problem, we issue a citation as part of our enforcement mechanism. So the first step is with the landlord, and the next level is through DCRA.
Okay, I'm out of time and I see Councilmember Silverman here, so.
Councilmember Silverman?
Yes, thank you, Mr. Chairman. My apologies. I got caught on a phone call when you called me the last time, so thank you. Director Shrapa, good afternoon to you.
Good afternoon.
So I actually caught your comments, Mr. Chairman, and I just want to echo them. Today, I'm not going to ask you about many of the issues, Director Shrapa, that witnesses have come to testify about in terms of illegal construction and damage to their property. And I know the chairman seems very passionate about that and has asked you a lot of questions. It will ask you a lot of questions about that. And I just want to double down on what Councilmember Henderson talked about. I think you, me, the chairman, and Councilmember Lewis George looked at a case on Georgia Avenue that dealt with this self-attestation issue that has led to serious issues for tenants of a property. So I couldn't agree more with her on that. I am going to ask you about what I engaged the last set of public witnesses on, which is this security licensing issue. As I said in that round, after the public witnesses testified, several of whom were from security companies, this is a serious issue for me as chair of the Labor Committee and as a member of the Workforce Investment Council, in that this inability to issue licenses is preventing families in our city from working. Now, certainly we want our security staff licensed. Certainly want to do that. But I want to really understand what happened here, Director Shrapa. So first, as one of the witnesses told the chairman, the department issued a contract to a new vendor that was not prepared, it sounds like, to take on all of the responsibilities and tasks of issuing security licenses. So help me understand why we hired someone who wasn't prepared to take on all the responsibilities when their contract began.
Sure. First, I think it's important to put on the table that I share your concern about speed that district residents or people can work in the security industry and putting people to work in general. Also, deeply saddened that we've not been able to process license applications as fast as I would like for that to happen. That has been a challenge that we've been focused on how to address it, and we've made improvements in that area. So I'll give you the background, but before that, I think I also want to highlight that as a result of several changes that we've done in response to the backlog, we've reduced the backlog from 11,500 towards the end of the year to 5,590 about a week ago. The backstory to all of it is that our licensing processing capacity or capability slowed down as a result of a confluence of a few factors. One is the pandemic-related staffing shortages and absences. We had to grapple with that. The second is software challenges. And the third was what I think Steve and the others mentioned, that is the complex requirement to get licensed. More specific to your question about the contracting, up until March 2021, we had contracted with our PSI services. We're not pleased with the service based off poor quality, IT security vulnerabilities, and constant budget pressures and deficits. It was a problem that we wanted to address. So we started a procurement process way in advance because we knew the contract was going to end. It was an RFP process, and at the end, the best value for the district or the best vendor got selected. We also baked in lead time to transition from one system or one vendor to another system or multiple vendors. That was all part of the planning. Unfortunately, about a few weeks towards the transition date, we were informed by the vendor that they had some problems and couldn't meet the deadline. Knowing that, we quickly put together a stopgap system just in case the vendor that had won a competitive procurement process does not come through. Regrettably, when the time came to transition, the vendor said, no, I can't deliver. At that point, we had to keep license operations going. And
why not, Director Shrapa? So I'm trying to understand this. You were unsatisfied with a vendor, with PSI, because they kept going over budget. Is that what I'm understanding? They kept saying they needed more money to do what we had contracted them to do?
That was one. There was also the problem of poor service, and also the problem of cybersecurity vulnerabilities that we had noted.
Think about this from a taxpayer or from Allied or any of our other businesses that rely on you. So you decide not to renew a contract with a vendor you believe is performing poorly. You have an RFP process, and then you select a vendor who then weeks before they're supposed to supply the service to district government says, yeah, actually, we can't do that either. There's a problem here, right? You had an RFP process. Were there multiple companies that bid for this contract or only one?
I don't recall the total bidders, but what I know is that the contract was structured in a way that did not even lend itself for competition. So when the contract ended, we had to go through a procurement process. We just had to. We just couldn't renew the contract. Like we had to go through a procurement process. At the end of the procurement process, the vendor that won,
right,
one that leading up to the transition said, no, we have to delay this further. So
right, but let me pause you there. I don't mean to be rude, but I'm just saying we have a procurement process in which we outline what we need, right, from a vendor. We have a competitive process to evaluate the vendors. And what I'm asking you is, well, was there just one vendor? Because if there were multiple applicants to the RFP, then we were evaluating, who's going to do the best job for our money? And then we end up selecting somebody who then says, actually, you know what? We can't do this. We can't do this in the time frame that you asked. So there's something broken here, isn't there?
I would agree with you that the problems that we are dealing with is unfortunate and we have to do better. That is something that I wholly agree with. There's no question about that.
Okay.
We recognize the problem. We deeply understand the impact to our customers and our stakeholders. And we've done a lot to address the situation and we'll continue on doing more. Some of the witnesses testified about the engagement that we've had with them, taking their ideas, implementing things, for example, like provisional licensing, hiring additional staff based on the funding we've received, streamlining processes, even looking at statutory requirements, regulatory requirements, and reforming them or making attempts to reform them, collaborating with the Deputy Mayor for Operations and Infrastructure to help address the issue. So it is front and center for us, Council Member.
My time is going to run out, Director Sharpa, so we're probably going to have to get that to you in the next round. Well, my time is running out, Director, and I'm not in charge of the clock here. Chairman is. So let me ask you this. Was the problem OCP's problem or DCRA's problem in terms of selecting a vendor that couldn't actually deliver the product we were asking for? Where was the problem?
The real problem is that the vendor could not deliver. But
we as a government selected that vendor through a competitive process. So then the problem is ours because we shouldn't have chosen that vendor because they couldn't deliver, is my point. So is the problem that, is OCP the problem here, Director? Because they were in charge of the procurement process, correct? Or is the problem that DCRA didn't give OCP the right parameters in terms of what selection criteria? There was a problem. We shouldn't have selected this vendor, it sounds like.
The premise behind the question, I would say the problem is neither. At the end of the day, DCRA is accepting responsibility for the transition, the good, the bad, and the ugly. And our commitment is to get it right. And that is why we feel at the pace that we are going today, Councilmember Silverman, and the changes that we've done, we are going to clear the backlog before the summer.
Okay, I'm out of time. Mr. Chairman, I'll return to this in another round, the next round.
Thank you, Councilmember. So is there a contractor or a vendor handling the security licenses?
Is there a contractor or vendor working on the security licensing?
Who has to contract for the licenses?
We've put together a team of contractors that are building and enhancing the system. There's a vendor that won the customer service part of the program, and there is a vendor that won the examinations part of the program, and that is PSI, it turns out. So the answer to your question is there are vendors in place that are supporting the direction that we are in.
All right, I'm confused. With regard to the issuance of security officer licenses, prior to last March, how many vendors or contractors did you have?
Got one vendor.
One, PSI.
That's correct.
Okay, today you have two.
Today we have two firms and a team of developers who are—
Developers, you mean like the car company and Acridge company?
No, that's a good question, Chair. But we live in construction so much that when we say developers, people put in the real estate. IT developers, software programmers. So there's a vendor that is a firm handling the customer service component. There is a firm, a vendor handling the examinations component, and that's PSI. And we've assembled a team of software engineers, developers, that are enhancing and building the system to support the changes that we are making.
And this is developers on your payroll?
That's correct.
So you have
contract.
But not a firm, individuals whom you're saying contract workers who are working for DCRA.
That's correct.
And so who's issuing the badges? Because there was testimony that right now nobody is getting badges or documents or identification cards or whatever they are. I'm going to call them badges. Who's issuing them? Nobody.
I'll double check on the name of the firm that is printing the badges. I don't want to speculate, but here is something that we also did. We provide the identification information online. So if you want to know if Robert Guggenheimer is licensed as a security guard or security professional, you can go online, pull up your name, and you see the image. I believe the contractor that is printing or that is going to be printing the ID cards is the one doing customer service, but let me just verify that and I can circle back with you.
So you believe it's one of the existing two, but it actually might be a third?
I don't know for certain. I would rather verify that and give you that information. Let me look through my notes here. It may be somewhere.
So what's the solution here? Since you said there are like 5,000 that haven't gotten their renewals?
A couple of things. One, thanks to the emergency regulation and the delegation authority that we received from the mayor, we can now get people to work faster. And that has helped a lot. We've already issued 50. The solution also—
You've already issued what?
Provisional licenses, the temporary license that the gentleman talked about. So we have a solution in place for that because of the emergency rulemaking. We also have a solution in place as far as the processing capacity and capabilities. We've hired 2 FTEs and 5 more contractors to speed up throughput. And we are now processing about 500 applications a week. So that is a good number, which is why I feel good about our chances in clearing the backlog by the summer. When it comes to the system overall, we are partnering with the Office of the Chief Technology Officer to assist us with software quality.
But Director, sorry to interrupt, it's now half my time has been expended on this issue. Your testimony was that you will eliminate the 5,000 by the summer.
That's correct.
There was testimony earlier that other jurisdictions issue these licenses, assuming the person's qualified, within 2 days. And there was testimony that people who are applying for a job can't wait 3 months. So getting this cleared up in the summer is completely unsatisfactory. In addition, there was testimony that processing the oldest of the license applications first, while that sounds fair, is actually counterproductive because those people are probably not available right now. They may have dropped off. And the people who've most recently applied are the ones who are, what do I want to say, most job ready, most likely to actually still be wanting to be hired. I might not.
I hear that. It is more nuanced than that. The jurisdictions that are allowing people to work or getting people to work in a couple of days, I'm not sure whether that is provisional or full licensure. But if it is provisional, we are on par given the changes we put in place. As far as
you said, no, you're not. You said you're doing 500 a week and you've got 5,000 pending.
It doesn't matter, Chairman. This is why we are on pace. Even if we issue somebody a provisional license tomorrow, we still have to issue them a full license. So I'm responding specifically to the notion that other jurisdictions are getting people to work in a few days. I've not seen anything that tells me that people are getting full licensure in 2 days. I suspect it is about provisional licensing. And that is where we've adopted emergency regulation that would allow us to move faster. So
it's not the same as issuing a provisional license within a couple of days. You've got 5,000 pending or 20,000 pending. And it's going to be weeks before you get those issued.
Chairman, there is a reality that we are contending with, and that is we are moving as fast as we can. We are also notifying applicants who have pending information or those who may have abandoned the application that by a date certain, if you don't respond to our inquiry for additional information, we will just put your application in a different file. That will speed things up. So at the end of the day, we are going to get people who are currently working on provisional licensing or those who desire provisional licensing, we're going to get them to work sooner. So when I put out clearing the backlog by the summer, it is because I viewed all these factors into play. And I also know we are maintaining discussions and engagement with our industry partners on different ideas that can be implemented. For example,
well, nobody is sounding, the industry partners, nobody is sounding satisfied. I've got correspondence from universities. I've got correspondence from the consortium. I had 2 security companies who testified today. I've never had a security company testify at a DCRA oversight hearing.
I am not satisfied either, Chairman, and my
we are
commitment is
concerned that with DCRA processing the oldest of the license applications, that time and effort are being exerted on behalf of individuals who are no longer viable candidates for the positions they applied for. We can appreciate that starting with the people who've been waiting the longest appears to be the fairest way. It also pushes the people who are most readily available to work to the back of the line. Allied Universal has experienced approximately 70 to 80% of those who ultimately receive a license to be no longer willing or available to serve in a security guard role. So this problem has been around for months, and it finally escalated. Well, on the council side, it finally escalated this week. On the executive side, you got a letter December 3rd. Why did it take the deputy mayor 6 weeks to meet with anybody about this?
What I do know, Chairman, is that the problem that is being brewing is something that we take ownership for. And it's something that we've done everything we can and will continue pushing to solve. We've had several meetings with our industry partners about this issue. We've taken targeted attempts to clarify issues. Some have even provided us their list of applicants, and we've checked over where they are in the licensing process, and we sped things up. We have to look at the big picture, and that is to treat everybody fairly. if there's somebody who's no longer interested in getting their license, if they don't respond to our notification that for us to move forward, they have to indicate interest, that would help clear this issue. And those who are more likely available to work will be processed in due course.
So I'm over my time. Let's just recapitulate here. This problem has been around for months. DCRA decided that the previous contractor was not satisfactory, so you replaced him with somebody who couldn't do the work. And currently, you're not issuing badges. You've got a backlog of thousands. We have witnesses who've never testified before testifying on this. 70% of those who you're giving licenses to are no longer willing or available to serve. And this is a better situation than the previous contract. Let me turn to a colleague, Councilmember Henderson.
Thank you, Mr. Chairman. I hate to break up the line of questioning because I feel like Councilmember Silverman is itching on this, but I have one other question and then I have to run. Director, I noticed there's quite a bit of overlap in terms of enforcing the housing code violations between your agency as well as the Office of the Attorney General's office. And I've noticed, especially in the last year, that the Attorney General has been taking a lot of landlords, slumlords, if you will, to court on some of these issues. And I would think that DCRA would be a great first line of defense so that it never has to escalate to the Office of the Attorney General. So when it gets to his level, I usually think of it as maybe DCRA investigated, but whatever you did in terms of your enforcement mechanisms, the problem was never resolved. That tenants had to band together to take their claim to the Office of the Attorney General. So let me ask you this. Does DCRA ever collaborate with the Attorney General on these matters?
First, your concerns about level of collaboration.
Director,
it's something
I have to go pick up my child. So if you could just answer my question.
Allow me to kindly answer your question. It would help inform the matter. DCRA collaborates with the Office of the Attorney General as matter of course. It's nothing new. We've been doing this for years. In fact, you may not be aware of this, but one of the things they will tell you is that we've compiled a list of owners that deserve stronger enforcement attention, not because DCRA has not done anything. It's because we've exhausted avenues available to us through the law and our regulatory channels to try to get the violations addressed. We routinely provide inspection reports, data on our activities to help bolster their cases. So that is something you should know, that DCRA doesn't exist in a vacuum, or DCRA does not collaborate with the Office of the Attorney General. It is par for the course as far as how we approach cases.
You're muted, Councilmember.
Oh, thank you, Mr. Chairman. In that regard, though, so for some of these, it's water damage, it's pest problems, it's, do you ever go back to your inspectors or your own policies and procedures to determine whether or not there's something different that can happen so that the Office of the Attorney General?
You muted again. Did you mean to? So the Office of Attorney General
does not have to get involved.
I want to recap what I think I heard. You asked if we reevaluate our policies to see.
Right. So you have some, I kind of view it as sometimes like when it gets to the Attorney General's office, then that should be like the measure of last resort. Do you reevaluate your regulations, policies, and procedures to ensure that
perhaps you don't have to go to the Attorney General next time. Like, should we change our fine measures or enforcement mechanisms such that these landlords don't feel like, it's just DCRA for now?
Yes, we do. And it's routine. When we are making referrals to the Attorney General, it's because we see a pattern of neglect or a pattern of not addressing the underlying issue. So, for example, if you take a look at even some of the lawsuits that the Attorney General is filed, it's because DCRA made a referral to them. There are landlords who are in receivership or are going through bankruptcies, and we still do inspections and re-inspections, and we still do our critical work to support the overall enforcement action being taken. So we see the OAG as a critical partner in the district's overall structure to bring address housing code violations to a minimum level and to hold landlords accountable. Just the same way we see the Office of Administrative Hearings as a partner, so that our enforcement actions, when they get appealed, can be adjudicated the right way at that agency. So that's a long way of saying, yes, we review our practices and we review our regulations, and we also look at the laws to see what can be done differently.
How many landlords have you referred in the last year to the Attorney General's office?
What I can tell you from memory is that just on February 6th, they received a list of 22 entities that we've identified as top 15 owners who have the most housing code violations. And some, for example, like Wheeler and 10th Place, Stanton and Glen, we know they are in bankruptcy, and we've partnered with the Office of Attorney General so that the liens we've placed on the property for abatement that we've done can be recouped. So it's really normal for us to be collaborating with the Office of the Attorney General. My staff have conversations with their staff routinely, and they even evaluate cases that we refer to them so that they can provide some suggestions and ideas on things that we can do to help protect our vulnerable residents, and that will continue.
Okay, thank you. Thank you, Mr. Chairman.
Thank you, Councilmember. Councilmember Silverway?
Yes, I appreciate Councilmember Henderson's questions, but I do want to return to this issue on security licensing. So Director Shrapa, I want to make sure I understood an answer that you gave to Chairman Mendelson. We had a vendor to process security licenses. The answer you gave to me, why you said that PSI, that vendor, delivered unsatisfactory performance to the district, correct? And then, yes. And then in the answer you gave to the chairman about how many vendors we have currently doing this work, you said we've rehired PSI. Did I hear you incorrectly?
No, I think there's a misunderstanding. This would help.
Okay.
There was one vendor.
Right. And actually, before you go further, actually, the RFP that was issued, was that to have one vendor or to have these multiple vendors?
And let me explain.
Okay.
To what I was going to say. And I understand where you are coming from, trying to understand the picture. There was one vendor. That was PSI. Before PSI, there was another vendor called Pearson View. So there's a pattern. What we discovered based on the poor service and changes in the marketplace was that there are several vendors who can do different parts of the work. So the RFP process was designed to boost competition and ensure that our requirements are clear so that we don't end up with the service challenges that we're having with PSI causing budget deficits.
Mhm.
And PSI won the exam testing component as sort of like their core service. Another vendor won the software system, which was their core service. Another vendor won the customer service. So that's how the procurement process played itself out.
Okay, but let me pause you there. We are unsatisfied with the performance of a vendor, and I understand that apparently through our RFP process, that vendor wins again, but shouldn't that raise red flags for us? We fired this vendor, or we didn't renew their contract because of cost overruns and other performance issues, you told me, but then we go and hire them back again. That seems like that is the definition of insanity. Isn't it, Director Shrapa, doing the same thing over and over again and expecting different results? Okay, so we rehire PSI, which we didn't renew their contract because they were poor performing, didn't meet our expectations and so forth, and then we hire them again. Why?
It is not your conclusion I would disagree with, but I share your sentiment. This is no insanity. It's far
Seems
from
like
that.
insanity.
Yeah, it may seem that way, but council
mean,
member, with all due respect, it is not. The competitive process plays out, and we have to honor whoever wins.
But then that's my point, Director. I don't mean to be rude, but I got to say, then something's broken with our procurement process, and I think it is, because we do not want to renew a contract with someone because they are, as you said, apparently end up more expensive than they said they were going to be, not performing well. And then you're saying, oh, but you don't quite get the full picture, council member. Like, I mean, the full picture is we didn't want to renew their contract because we didn't think they were good for our city. And then we hire them again. I'm sorry, Director, but we are going to agree to disagree, but I think this is insane. But I got to move on because I only have 6 more minutes. Okay, so I just want to tell the chairman, I believe that the contract for PSI expired March 31st. I will tell you, Mr. Chairman, I started hearing about this issue through the Workforce Investment Council in the summer. In summer 2021. So like I have emails from August 2021, and I will tell you that if this came up at the Workforce Investment Council, that means the administration was aware of this issue from August 2021 as well. And the security companies were surely aware of it because as Mr. Amate, I think, writes, like basically when we switched over vendors, is it called the OPLA system? Or no, OPLA is the division in DCRA, but the system just shut down, Mr. Chairman. Isn't that correct, Mr. Shrapa? Like on April 1st, the system to renew the licenses just like didn't exist anymore, essentially.
That's not correct.
Well, that's what Mr. Amate is writing, I believe, the National Association of Security Companies.
Yeah, it may be a play on words, but at the end of the day, licensing operations have continued. What may have colored the picture is that during the pandemic, license renewals were automatically pushed out. So people didn't have to sort of like rush to get things renewed until the pandemic-related changes expired. So I really not here to dispute individual statements. My broader point and main picture is that we own the situation where service had not been delivered at a level that we are capable of. We've taken steps to address the issue, whether it's emergency rulemaking, getting rid of antiquated regulations, hiring more staff, being adaptive to a very different labor market and pandemic-related staffing shortages. And we will do everything we can to ensure that people who want to work in the security industry or any occupational related license industry get out and are able to work as fast as they can.
Okay, I appreciate that, Director Sharpo. So I will move towards solutions as the chairman did as well. So you issued this emergency rule that took effect last week. My understanding is February 15th. So how many temporary licenses, and I apologize if the chairman already asked you this, how many temporary licenses have been issued since the emergency rule went into effect?
About 50.
About 50. And
actually, let me correct myself. 465. 465.
So in 1 week, today is February 23rd, is that correct? So in 1 week, you've issued over 400 temporary licenses?
Yes.
Okay. Now, I believe Mr. Fonts brought up this issue of the backlog, in that if you start from the oldest licenses, a lot of these folks have already moved on to jobs. So what is the current backlog right now?
Around 5,500.
5,500. And so what is your approach, given the concern of the security industry that if you go in chronological order, it's going to be very inefficient?
One thing we know is that we have to treat people fairly. That's one consideration. We also have to adapt to various market conditions. So far, we've honored the fairness component, and we are open to ideas as far as ways to speed up the applications. One of the things we've been successful at, in spite of all the challenges, is intaking a list of applicants from the security agencies and looking at where those applications are in our system and addressing the license processing. That effort will continue. So I share that to say, I cannot sit here today and commit to going from first in, first out to last in, last out exclusively. We will see how things are evolving, especially since we are sending communications to applicants. Hey, we will consider your application abandoned if you don't do X, Y, Z.
Gotcha.
That in itself is giving people notice, and that would help expedite license processing.
I have two things before my time expires, Director Sharper. First, what my request would be is for you to work with our largest security companies on what they think might be a good process. The second question I have to ask you, Director Sharper, is, as I mentioned, this problem started April 1st. Yet here we are, February 23rd, still, and the emergency ruling only came out February 15th. Why did it take 8 months for DCRA to address this issue after multiple engagements that I know happened at fairly high level? Why did it take 8 months?
The first part of your request, as far as engaging the security agencies, is something we've been doing throughout this whole process, and that is not going to stop. The fact that the deputy mayor has even had a couple of meetings, I know my staff continue to talk to them, that shows the level of collaboration. And they have testified on the record that they've been working with DCRA on this. So you don't have to worry about that. That commitment is not going to change. As far as why it's taking so long, unfortunately, we've had challenges, and we are sorry people had to deal with this issue, and we would not been able to process things as fast as we would like. At the same time, we've put in place several changes that are paying dividends. The fact that we are able to process 500 plus applications is an indication that we're on a positive trajectory. And that is where we want to redirect and focus our energies, solutions, engagement with our industry partners, hearing feedback from whoever wants to give it to us, and then we evaluate what is practical and feasible without disrupting the gains that we've made.
Okay. Well, my time is up. I will just say, Director Sharpa, going from 0 to like almost 500 raises red flags for me. I'm glad we're processing applications, but that we can go to this rapid speed also raises concerns for me. But I appreciate you taking responsibility. Not everyone does that, Director Sharpa. I just don't know why it took us this long to address an issue that really does impact people's lives, really does. I appreciate you answering my questions, and I look forward to working with you constructively on this. Thank you, Mr. Chairman, for your time and attention to this issue as well.
Thank you, Councilmember Silverman.
Thank you, Councilmember. There was testimony from Darlene Jackson that there were problems with a contractor. The DC contractor was issued a notice of infraction by DCRA back in 2020, but to my knowledge, nothing further has occurred. No hearing has taken place. Can you speak to that, Director?
Yes, I first of all want to say to Darlene that I do remember her when she initially raised this issue, and I promised that we'll do everything we can, and we have been doing so. More specific to the question about hearing, this is what I do know because I just made some notes, and this is not a full picture. There's been about $28,000 or so in fines that we've issued against a contractor, and there's a hearing in April around that matter. As it relates to the FOIA request that she's made, she's received documents that are responsive to it. But if there are some underlying questions that she's asking for, my staff will continue to engage with her and assist her any way we can. We do know that people end up being on the short end of the stick when they're dealing with contractors. And we have a consumer protection unit that investigates these issues and deals with it. The solution doesn't happen overnight, but we want to make sure that our case is robust so that it can, our actions can be sustained in court. So I, as difficult as it is, ask for a little patience so that the process plays itself out.
Well, why has it been 2 years and no hearing?
Chairman, you know, I don't control scheduling of our hearings. You know, what I do know is that we will work with our partners to,
But the hearing is, you say that there is now a hearing in April.
The hearing is on the notices of infractions that we've issued.
So no fines have been paid.
A final order has not even been issued for fines to be paid. So your answer is correct. Your statement that no fines have been paid is correct, but it is because a final order has not been issued. And if a judge doesn't issue the final order, there's no basis for us to say pay the money.
She also said, I've been repeatedly told that information regarding this contractor's notices of infraction are not public, and that I need to submit FOIA requests, which I have, only to be given information that is incomplete and or does not contain the answers to my actual requests.
I don't know the specific question that she asked, but notices of infraction, if you are looking for something else, it is a standard document. So if you are looking for something else out of it and you don't see it there, it's because it doesn't exist. But I want to reserve further comment until I even understand the specific question she asked. But I trust my staff is handled this the right way, especially when it comes to responding to FOIA.
We also had testimony from Jobs with Justice about power design. I assume you're familiar with the issue?
Not so much, Chairman.
We were very pleased to find that DCRA had investigated our case and issued a 145-page report in February 2020 that confirmed what the workers had told us, Power Design had in fact employed unlicensed electrical contractors to work on projects in our city. Despite DCRA's own findings, the Board of Industrial Trades did not take action and dismissed our complaint without giving Jobs with Justice the required written notice, which denied Jobs with Justice and the affected workers to know why the case was dismissed or a chance to appeal. In December 2021, we filed a writ of mandamus asking Director Charapa and Mayor Bowser to explain their reasons for this dismissal. On January 25th, that's like not even a month ago, we received a response from them claiming they had no obligation to explain their rationale for dropping the case. Why is that? Why does the Board of Industrial Trades, which is supported by DCRA, summarily dismiss a case without any written notice or written order or written finding or written anything, and then both you, Director, and the Mayor refuse to then explain anything?
I deal with so many cases that I don't remember the details of this particular one. But for anybody else who's listening, for what it's worth, I mean, the Board of Industrial Trades, we provide administrative support, but they make their decision. I don't even sit in their meetings when they are deliberating on these matters. So I don't know what else to add other than what I've just stated.
Well, but you provide staff support, and surely DCRA or your general counsel can advise them. They're allowed to dismiss a case that, without an order?
I'm not familiar with the particular details of this scenario, so that is something that I can look into, Chairman.
Well, please, I'm making a note here that you'll get back to me on this. It was the testimony of Melinda Fiedler. She was the 5th witness to testify today, and I know why the case could be summarily dismissed and why you would have indicated to Jobs with Justice that you don't have to respond. We had testimony today from several witnesses with regard to A2L refrigerants, which apparently are prohibited in the current building code. And a letter was sent to you in March last year. The impression I get is that there was no response. Why can't we get this resolved quickly? If EPA has approved A2L refrigerants, why can't we allow them quickly?
Two things to keep in mind. When it comes to the co-development, the public has an opportunity to participate in that. The second is that if there is some refrigerants that EPA has approved from a development standpoint, now I'm not talking about like software development, but like real estate development standpoint, somebody can propose an alternative means to meeting the intent of the code. That is why we have code modifications. So there is an option available to address their concerns. In fact, there are 2 options that I can think of in a moment: code modification request and participation in the code development cycle, so that those alternatives can be considered.
Well, the challenge for me, Director, is that there were several witnesses and they indicated that they had communicated to DCRA or the code, the what's it called, OCA committee, and they've heard nothing, and it's been a year.
That is what they are saying. I've now looked into it, so I don't want to respond to that specific issue. What I think we all would agree on is they are interested in seeing alternatives being allowed. And at the end of the day, if somebody wants to build tomorrow, as part of their plan submission, they want us to consider an alternative, there is a process that supports the review of that alternative. And I'll encourage them to go through that process.
Well, I assume that the mayor cares about climate change and reducing impacts on global warming. So DCRA has the ability now to send over legislation to amend the building codes to allow A2L refrigerants that have been EPA approved.
The mayor not only cares about climate change, Chairman, but she's done a lot to address it.
Speak to A2L. Speak to A2Ls. So why haven't you sent over legislation?
There is a solution in place, Chairman. I just laid
Why
it out.
haven't you sent over legislation?
Why is it necessary when there's a solution in place now? I mean,
there isn't.
Who said so? I'm giving you a solution right now.
What's the solution? To wait 2 years?
They can go through a code modification request if there's a builder who wants to go with an alternative that EPA finds acceptable, and will review it and make a determination from there. That is the fastest solution. Like, not everything requires legislation as the only option, Chairman. You know that.
Correct, but I'm guessing that the environmental community feels that the developers think that they can't do this, or why would they do something that they haven't done, even though they could do it? And so if the code does it, then it becomes something they can talk about more easily. I don't think that's unreasonable.
They don't know. I'm not aware of builders saying, hey, I want to go through this alternative and I can't go through it. For every problem, Chairman, there is a solution. We have to work
well,
together.
So the building codes have to be approved by the council, correct?
Yes.
Okay. Why don't you just send over legislation that changes this provision so that then we can stop talking about it?
This is the first time we are talking about it.
Correct.
And legislation is not the only solution. So I hear your point, we'll consider it. But what I want to make abundantly clear, there is a path forward for anybody who has an alternative that is widely accepted, and that is to go to the code modification process. They can also go through the Construction Codes Board and provide comments so that the board evaluates that. There are multiple ways of solving.
When you say that, you're disregarding what has already been settled, which is that they wrote to you or the committee that reviews the code and already asked for this, and they heard nothing. And it's been a year.
I'm sorry, Chairman. I don't recall anybody writing to me, and I don't want to speak for anybody else.
But please don't say that there is a solution they could write because they've already written. There is another solution, which is that you could send over a bill, and that's what I'm asking. So you will get back to me on whether you will send over a bill. My understanding is that the code modification process is on a per project basis, correct?
That's correct.
Okay. So if we want to see multiple projects use an environmentally friendly refrigerant, then we're going to have to change the code instead of saying, oh, one off, everybody can one off. And when they one off, they have to then make the case, correct? Do I get to just send a code modification request with no backup, no justification, no argument?
Absolutely not.
Okay, so you get back to me on whether you're going to send the legislation. I appreciate that.
You are welcome.
To go back to your KPIs, the KPIs that you have all speak to the timeliness of DCRA's response. And while there's some value in that, the KPIs don't speak to the outcome. What are you going to do to fix that?
We can fix anything. That generally, I want to put that out there as part of our commitment to continuous improvement. What I'll ask in return is what outcomes are people looking for so that we can evaluate and see how we can meet them where they are. I've not had a specific outcome, or maybe I missed it, But currently, there are outcomes that we have in our KPIs and our workload measures. For example, the number of buildings abated is one outcome that we track. The health of the economy, and we use a proxy for that, or the level of economic dynamism, we use a proxy for that, and that is the number of business licenses issued timely within 1 business day. So there are things that we are tracking and outcomes that we pay attention to when it comes to protecting the consumers from predatory business.
Well, how about this? How about this? One KPI could be number of by number of addresses in which there's been a complaint of illegal construction. Because the goal here is to reduce the number of instances of illegal construction. So that would be a useful measure.
Thank you, Chairman, for that suggestion. And it is something that we will look at. Because
okay, how about this one? How about this one? The number of re-inspections for serious housing code violations. I'm not quite phrasing that right, because it's not just re-inspection, it is sort of like a repeat complaint. So tenants complain that there's no heat. Are they going to file another complaint of no heat a month from now? This is one where we want to see fewer numbers, not more numbers. So that would be a good measure. Or like water, number of complaints for water and how many repeat complaints for hot water.
I really appreciate this conversation, Chairman. I think this is the first time that we've actually gotten to a level of like specificity about some KPIs that you want to see or think is worth looking into. And I really appreciate that. These are things that we will consider, especially as we are thinking about how to stand up the Department of Buildings. And I know you care deeply about solving those issues. So I want to say thank you for this suggestion. And it's something that we're going to look at and engage with our various stakeholders about, once the KPI is defined, resources that are necessary to ensure that we are in a position to succeed and not just have numbers for tracking purposes. The outcomes, we got to have a good chance of meeting them.
Well, I appreciate that this is, it seems to me that outcomes are valuable and outcomes can be outside your control, but they're still an important measure because they speak to your mission. So if we look at each of the areas where there've been a lot of complaints, from housing code enforcement to illegal construction to vacant property. You don't control vacant property, but wouldn't it be a great outcome if there was less vacant property? So what reduction in vacant properties or reduction in blighted properties? Let me keep moving here. Short-term rentals. You stated in question 46, you stated there have been 413 applications. How many have been denied?
I'm not aware, but again, this is just in the moment response. If some have been denied, I'm just not aware of it. As I sit here to engage in this conversation.
For the current fiscal year, the fees for basic business licenses and certain license endorsements were lowered. Are you tracking the impact of the lowered fees?
Oh, yes. We are tracking that, not just quantitatively, but also quantitatively. In the previous roundtable, you heard comments from people that we've asked, how has the fee reductions impacted them? And several of our customers have said it's been huge, going from having to pay $324 to $99 is a big benefit and it's boosted their fortunes, however small it may look to somebody. From a quantitative standpoint, we also look at number of renewals and number of new licenses, and we publish some of this data on our website. So in short, yes, we are tracking the impact of fee reductions, and overall it's been very positive, and we are thankful for the mayor putting in place that, and I also appreciate council support of that initiative.
So your answer began by talking about what I would call anecdotal evidence, but you are actually compiling quantitative evidence?
We do, yes, we do quantitative and qualitative.
One of the pre-hearing questions I sent to you was about reprogramming, no, intradistrict transfers. And in fiscal year 2021, there was a $663,000 intradistrict transfer to the Department of Energy and Environment for the Green Building Fund. What was that?
And I'm sorry, I have to have you repeat yourself, Chairman. You said question number
10 on page 13.
I would have to check what was involved in the total amount, but I do know that we partner with our DOE on grants, and we also partner with them on different initiatives. But let me look if there's additional information.
But you also have a fund. You have a special purpose fund called the Green Building Fund. Brought in
Yes,
$1 million in revenue in 2020. Brought in 1.8 million in 2021.
Yes, we send them money from the Green Building Fund.
Why do you have the fund if they're the ones who are spending it?
We spend money against the Green Building Fund as well for like solar permit reviews, green inspectors. But as far as the 663, that is something that I can get you the details on. I mean, I mentioned previously, we partner with them on grants to support different green initiatives because they have grant making authority, we don't. But the specifics behind the spend is something that I can circle back with you on as far as an answer is concerned.
Okay, so you'll get back to me on both the transfer and the specifics around the spend.
Yeah.
You also transferred intradistricted $450,000 to the department for four hired vehicles.
That's correct, because we are leveraging some of the technology to improve transparency and responsiveness of our inspections. They had previously implemented a system for tracking our cars through GPS, and it made sense to partner with them so that we can leverage that to dispatch inspectors. That is a reason why today, when somebody asks for a housing inspection or legal construction inspection, they get automatic notification about the service request. They are able to track the inspector as the inspector makes the visit. The same way you can track the Domino's Pizza dude. So that is what the money for. The money is for the system that we are leveraging to increase our responsiveness and transparency around inspections.
I'm a little confused. Doesn't the system belong to the government? So why would we pay twice? Why would you have to pay for it when the government already has it? You're not getting people from the Department for Hire.
Vehicles. Yeah, I can see why you think about it that way, but it's different. Moving from tracking cabs to people and inspectors requires some changes and adaptation of the system. It's not just like a plug and play. So there's been significant work that has been gone into the effort to adapt the system for our specific use and scenario. And that is partly what the money is for.
In question 16, we asked for the budget enhancement requests for last year and the previous year. Why aren't we getting those?
The city administrator's office handles and centralizes all requests and responses as it relates to enhancements, requests, and like budget decisions. That is not within the agency.
I didn't understand that. How are we supposed to understand what your needs are if we can't see those documents?
When it comes to enhancement requests and any information pertaining to that outside of the package that is delivered to council, the response to those sort of questions has been centralized, and that is handled by the city administrator's office.
What I'm going to move on because I'm not going to get anywhere with that. You're doing improvements to the IT system regarding short-term rental regulations. You said in your answer, currently DCRA is working on additional enhancements. Can you describe?
Yes, generally some of the enhancements that we are working on include the detection of properties that have been listed as short-term rentals, the number of days they've been rented. That's just like one example. Another is even further streamlining the customer journey as they go through, the application process. So to get a little bit into the weeds, and then I'll lift up to why that is important. If you have to pay a fee, you can have a credit card on file, and automatically, once your license is approved, it's auto charge, you receive notifications. I mean, those are some of the things that we are considering. So I don't have the list of improvements that we are looking at, but one that I do remember, in addition to the ones I've mentioned, is the possibility that people can do all the application processing and functions from mobile devices. Currently, you have to do that from a desktop, if I recall correctly. So we are simply just responding to opportunities for improvement as part of our broader commitment to perpetual improvement.
Is your short-term rental technology fully integrated with other DCRA IT systems?
For the most part. So for example, if a license is issued, customers don't have to go, or neighbors or stakeholders don't have to go to a new place. They can go to Scout, which is our property information database that we've made available online, and they can find out that a particular property has a license. So to that extent, yes, there's integration.
But my question was fully integrated, and the answer was no.
I don't know what you mean by fully integrated. So,
well, you said for the most part. Most part means not entirely. sent you a letter joined by Councilmember Allen and McDuffie regarding this incorrect interpretation of the short-term rental law that prohibits a host from living in an English basement, even though the law clearly permits the host can live in the smaller portion of the house. I gave the example of a 5-bedroom house with an old lady. She lives in 1 bedroom and she rents out the other 4. The law clearly permits that. You haven't said they can't. It's just this English basement. So can we have the zoning administrator's rationale in writing?
I'm not sure exactly how you want me to answer this, Chairman, because we've explained how we arrived at our decision on how to handle English basements. And we've explained why we think the distinction between principal and accessory use is something that ought to be honored. And we further explained how people can challenge our decision. So there's nothing extra that I can add, Chairman.
But actually you haven't explained. So a letter was sent to you on January 27th from myself, Councilmember Charles Allen, and Councilmember Kenya McDuffie. The letter is roughly a page and a half. It makes 5 points. States 5 reasons why the department's interpretation is incorrect. And we have this response. The agency has reviewed its position and given due consideration to your constituents' concerns. But the interpretation remains the same. I will just interrupt. We expressed our concern. We didn't express a constituent's concern. In any event, to continue, we will be adding a few facts, FAQs, to help constituents better understand how we treat English basements. As we stated earlier, if the constituents disagree, and again, we weren't writing on behalf of a constituent. As we stated earlier, if constituents disagree with the agency's zoning interpretation, the appropriate place for it to be adjudicated is before the BZA. That's not an explanation. Now, I did think today whether I could go to the BZA for an interpretation. Besides the fact that'd be a little weird, I'm not sure I have standing. Because one can go to the zoning BZA if they've been denied a license based on zoning. I would not have been denied a license. So I don't know that, I'm not going to say I don't have standing, but I don't know that I do. I think it's unreasonable to say, well, individuals have to go off and argue this, but I'm getting away from myself here. You haven't provided an explanation. We wrote January 27th, and I read to you your response, and it doesn't explain substantively the agency's zoning interpretation. So I repeat, can I have the zoning administrator's reasoning in writing?
And I have to double check because I thought the letter we sent recently was a follow-up to the roundtable conversation and a previous explanation of the need to maintain a distinction between principal and accessory use. So if that is not sufficient, I'll revisit the matter, but that's what it comes down to. We feel the law, the way it's been constructed, and the zoning regulations, the way it stands today, requires a distinction between principal and accessory use. And that is why if somebody just wants to live in the English basement, and which is a smaller part of it, and rent out all the other rooms in there, that is problematic. And that is also the same rationale for if you have a small apartment house that has like 3 units, you cannot rent all of them as short-term rentals. So it's the same applicability. And Chairman, that's really all I have to offer on this topic.
Well, let me check with staff. Did we get a response to our letter after the hearing? No, we don't have any response, except for the email I read to you.
All right, and not to belabor the point, I tried to explain our position.
No, I'm asking for the zoning administrator's rationale in writing. I don't think the agency is entitled to duck that.
So you don't think the agency is entitled to?
Duck that.
Oh, Jim. Can I get back to you? On
I've
what
asked you
else?
to get back to me with the zoning administrator's rationale in writing. I don't think the agency is entitled to duck that. I don't think that's unreasonable. I do think it's unfair to ask a consumer that they have to go and go through the whole BZA appeal process. But if they were to, the zoning administrator would have to account for himself there. So why don't you account? Why doesn't he account for himself before the city council?
Oh, Chairman.
I'll take that as a yes, a reluctant, but yeah, a yes.
I'll get back to you.
I would like you to resubmit your answer to question 18, which asked for all pending lawsuits. You did not list the captions. We wanted a list of all pending lawsuits, and to say claimant A, claimant B, claimant C is not sufficient. So I'd like you to resubmit that. I'll note that the captions are a matter of public record. Our question number 35 asked about the FOIA lawsuits. No, not FOIA lawsuits, a FOIA request. And my quick calculation was that the cost of processing FOIA requests went up by 233% between 2020 and 2021. Can you tell me why?
1 second, Chairman. Let me look at the
Page
data.
69.
Thank you. I have some data on the volume of FOIA, but maybe not. So we will circle back with you on the increase in cost incurred as it relates to FOIA.
Okay, what I'm really interested in is understanding why it's costing as much as it is and why the cost has gone up so dramatically. It's a little hard to tell, but I think you're on track to spend about the same amount this year. So in 2020, you spent 200,000. 2021, you spent 466,000. Looks like you're on track to spend at least that much again this year. I'd like to know why, what the cost is and why it's gone up so much. And if I sound like I think somehow the agency's at fault, I don't mean that. I would like to understand just the expense.
Sure, I understand. Volume plays a role, but this is something that I want to take a closer look at and then provide you with the answer to your question.
On page 77, in response to question 40, you give us a breakdown of inspectors. So for example, in the current fiscal year, you have 38 housing inspectors, 7 illegal construction inspectors, 3 vacant and blighted inspectors, 31 construction inspectors. If you look on that page and you look to the answer under B, how many full-time inspectors? The answers are 85 full-time inspector positions and 113 part-time inspectors. All right, when I added up the numbers for FY22 in the table, I got 79 inspectors and 118 contractor/resident inspectors. So can you explain to me why these numbers aren't the same? I'll rephrase the question. If I add the numbers in the column that says number of inspectors for FY22, it totals to 79. But under B, it says there are 85 full-time inspector positions. And there's the same issue of the numbers aren't the same for 113 versus 118. Can you explain that to me?
Yes, one is that the number of illegal construction inspected is an error. Is actually 8. So that will give you the 85 if you also add the fact that we have 5 contractors working full-time hours on our proactive program. So if you add the 5 to the 79 that you have, that gives you 84, and you add 1 more because the legal construction is supposed to be 8, that gets you 85. That's a mental note that I had jotted in my notes as I went through this. So that's sorry for that error.
And what about the, thank you for that. What about the discrepancy in the part-time? I'm assuming the contractors/resident inspectors are part-time.
That's correct, with the exception of the 5 contractors that are in the proactive program that pretty much work full-time hours.
And the proactive are the, that's the proactive housing inspection?
That's correct, Chairman.
Question 42 asked to provide a list of vacant properties. I have to say I did not expect that I would see $712 properties. But what struck me was that of the 712, none of them are older than 8.36 years. Now, I know that's not true. So if you look at your exhibit, and the exhibit is in ascending order of length of time that they've been vacant. So on the last page, the last property is 4720 Mead Street Northeast, vacant for 8.36 years.
Yeah, I understand your question. So I want to recap to be sure that my understanding is correct. You expect to see more properties that have been vacant for more than 3 years on that list.
No, that was a comment. That wasn't my question. I know that there are properties that have been vacant for more than 8 years.
So question will be, or the comments will be?
Why is it that you're not showing the properties vacant for how long they've actually been vacant?
One of the things that I know is that with database reform efforts, we look back as far as fiscal year 2014, because anything beyond that, the data quality just goes downhill. So that may explain it, but I would like to look into it further to understand, because the way I interpreted the question was properties that have been vacant for continuously vacant for 3+ years, not sort of like properties that have been vacant at any point in time.
But correct, but that has nothing to do with my question. There's a value in knowing that I think it's 2720 Ontario has been vacant for 20 years, or 1,000. It's not 1,000, 10,000, 1,000 C Street Northeast has been vacant for 30 years. There's a value in knowing that. And evidently your data is sufficiently compromised that you don't go back more than 8 years. That's what I'm hearing from your answer.
I'm providing context to the request that you've made, and also pointing out the broader picture.
I don't want context don't give me context on the question The question I asked was to list all properties that have been vacant for more than three continuous years, and to list them in ascending order.
Exactly, Chairman. So if there's a property that had a break in the vacancy classification, it wouldn't be on the list.
But if there's a property that's been vacant for more than 8 years, you only show it as being vacant for 8 years.
No, Chairman.
That's a fact. You've had properties vacant for more than 8 years. 1,000 C Street, 2720 Ontario, those are two that come to mind right away. And
I'm sorry, I don't remember the exact history of Ontario. We looked at this in terms of classified as vacant for more than 3 continuous years.
Yes, and according to your table, no property has been vacant for more than 8 years continuously. And that's clearly not correct.
Chairman, I think this is semantics, really. Because if there's a property that has been vacant, let's say for 20 years or 30 years, but there were breaks in between, it wouldn't be on this list.
And what if there weren't breaks? What if there weren't breaks?
That wasn't the question, though. That wasn't your question.
I'm stating as a fact, because as you know, I have been digging into this, that you have properties, or there are properties that have been vacant continuously for decades in this city. And you list them as being vacant for 8.36 years. Let me go to a different question. The Council adopted the Electric Vehicle Readiness Amendment Act of 2020. It's question 44 on page 82. The law took effect on October 1st, 2021. The question was, since October 1st, 2021, approximately how many properties have incorporated EV make-ready infrastructure into their design as a result of these new requirements? It's pretty clear to me, but I thought I would ask just to be sure, that the answer is, with regard to complying with the law, 0, because the regulations haven't been written. The answer is consistent with the Act. DOEE is writing the regulations to implement this law. So am I reading this correctly, that the law isn't being enforced because the regulations haven't been written?
Regulations have to be adopted before we can implement the law.
Why is it taking so long? The mayor signed the bill, enacted the bill on January 13th, 2021. That's over a year ago. So you've known for over a year that this is the law. Why have the regulations not been written?
Consistent with the law, Chairman, DOE would write the regulations, and we will enforce it through the permitting process.
You could probably force it to happen. Do I read in this that the mayor doesn't care about this environmental law?
Chairman, you know that is not true. You know
Well,
that.
she's not implementing it.
Initiatives. So, I mean, I get your point. It looks like you want this to happen faster. So let me look into it and see what else we can do.
How long did it take you to do the emergency rulemaking for the provisional security licenses?
We do a lot of things, Chairman, you know that. And we can't compare.
So it took less than a month. It took less than a month to write those regulations. It's been 13 months. 13 months since the mayor signed the bill. The council actually adopted it in December, so that would be 14 months.
Chairman, you know it's much more complicated than that. But I get your broader point. You want to see things happen faster.
My broader point is that evidently the administration doesn't care about this environmental bill.
No. I cannot accept that, Chairman. You know it too. I mean, when it comes to greening initiatives, DC is a leader because of the administration's efforts. And we appreciate that now there's a law in place to address electric vehicle readiness. And we'll do everything we can with our partners at the OEE to make things happen.
Give me a second. With regard to the illegal construction at Georgia and Taylor, I believe that's the building that sways in the wind. The testimony was that the building was issued a building permit after it was substantially built. How does that happen?
You said George and Taylor? Unless I
It's the one we had the Zoom conference call on.
Oh. I don't recall the specifics of the issuance of the building permit. I just remember the issue that was at stake during that call. So unfortunately, I have nothing extra to add other than the fact that I'll be meeting with the HOA, and this is information that perhaps you're not aware of, which is not related to the building permit, but is about steps that are being taken. The developer submitted plans and is ready for permit issuance, but we need the HOA to take some action so that the permits can be issued. And we've told them we wouldn't get or take a position on means and methods, because ultimately that is something the developer has to do. As long as they submit code compliant approaches, that will be a fair game to us.
Will you get back to me about the allegations? This was in the testimony by Swati Sasha Deva. She said the building was issued a permit after a building permit. I guess it was illegal construction, and then they got caught. They got a building permit after it was substantially built. Her testimony was that as a result, structural issues weren't inspected because the walls had been closed. She also says the building exceeded the height limit required under current zoning, and the building sprinkler system is not code compliant. Can you get back to me on that?
Yes, we'll look into that.
Give me just a second. At this hearing, we had testimony regarding illegal construction. Amy Fisher testified. She didn't give the address. She's a realtor. She testified to being adversely affected by illegal construction. We had testimony regarding illegal construction at 414 Shepherd Street. Illegal construction at George and Taylor, the condominium I just asked you about. We had testimony about illegal construction at Hamilton Flats condominium. We had testimony about illegal construction in 2-dwelling conversion of a house in Ward 1. 2 witnesses testified to that. We had testimony about illegal construction at 3644 13th Street. That's Mommy Preston. And we had, I think, next to her. And we had testimony about illegal construction at 916 Kennedy Street. That's the building that blew down last summer. What is DCRA doing to hold these developers accountable? What are you doing about these bad actors? I asked you a question.
And I'm thinking for a second, because you had a list of our properties, and I'm not commenting on any specific property, but generally, when it comes to doing everything we can to address illegal construction, one of the things that I made a commitment to solve was around intractable problems. And response time to an illegal construction complaint was one of them. We've increased our capacity in terms of the number of illegal construction inspectors. From the chart that we went through previously that looked at a number of inspectors, and I'm going to reference that so that I'm more specific. We now have a pool of 79 people. 3 years ago, we were nowhere near that number. So if you ask, what am I doing to address illegal construction complaints? There are a series of steps that we've taken and will continue to take. One is improving the response time by building out our capacity for inspectors. Another thing that we are looking at, and we've done so previously, is targeted enforcement strategies, going to certain parts of town where our data tells us that there is a high potential of illegal construction. We've also taken steps to enhance the training of our staff by looking at lessons learned in the past about illegal construction and sharing that to the team so that we have a better sense of how to catch illegal construction. We've also looked into what we call, or what you call, the bad actors. And for those, they go through more scrutiny when they submit permit applications. We've made it easier for customers to respond or inform us about illegal construction so we can take action. Now, looking ahead, particularly as it relates to the Department of Buildings, we see that as an opportunity to do a whole lot more. And while I'm not yet ready to put something in front of you as the next thing we're going to add to our arsenal, we would continue looking at solutions to not just hold actors accountable, but actually try to stop people who are more likely to cause damage from doing that damage. And that will take some creativity. We would also continue working with the Office of Administrative Hearings to pursue enforcement actions. If you look at the NOIs that we've issued for illegal construction, you will notice that the number increased to about 59%, comparing last fiscal year to the previous year. We've also adopted regulations where there's a fee for staff work order compliance. So these are all measures that we've taken, but the key point here is that we are committed to minimizing the incidence of illegal construction or doing everything we can to prevent it from happening. And when it does happen, we hold the actors accountable.
Thank you, Director. I think I'm going to leave it there. It's almost 7 o'clock. So I want to thank you for your testimony. We will see you in a month, March 24th. So I'm going to wind down this hearing. I have another hearing to start right after this. You may be a witness at that hearing, but we're actually I'm going to convene it and recess it. The next performance oversight hearing by the Committee of the Whole will be tomorrow, starting at 10:30 in the morning, where we will hear testimony regarding the Retirement Board, the DC Auditor, the State Commission, and a couple other agencies. Thank you again. The time is 6:56 p.m. and this hearing is adjourned.
Good night.
You tell me. You're ready, huh? Okay. I'm calling to order this hearing. This is a hearing of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chairman of the Council and Chair of the Committee of the Whole. Today is Monday. I'm sorry, it's not Monday. It's Thursday, February 24th, 2022. The time is 6:57 p.m. The subject of this hearing is Bill 24-526, the Engineering Licensure Amendment Act of 2021. This legislation deals with the scope of practice of engineering with respect to consultants, officers, or employees of the district government or an independent agency of the district government. This hearing was scheduled to begin immediately following a preceding hearing on performance of several agencies. That hearing just concluded at 6:56 p.m. And because of the lateness of the hour, and we've already contacted the witnesses, we're going to recess this hearing. I'm going to recess this hearing. We will announce a rescheduled date for the hearing, and we will take the matter up then. So anyone who's interested in this, contact the office, Committee of the Whole, and see what the rescheduled date is, or look on the council website, www.dccouncil.us. And we will reconvene this hearing at a later date, I hope within the month. With that, the time is 6:58 p.m.